Yes, sir. submission, the memo was moved last week. It is not listed. Date would be fixed.
Engaging Ashok Garnishee is not available.
Don't give any reason like that before my bench. Understood? Don't mention any names. You want a date, you take a date. The court is at the convenience of litigants and lawyers, not A, B, C, or D. Before my court. Please don't misunderstand that. Yes.
Printing matter, lots.
Give it.
Land acquisition matter.
Give it.
Responded without acquisition, abolishing the bidding matter. 230.
Who is the other side?
Union of India and state.
No, correct. State. Yes, state. You give an extra copy and you find out some demolition. We'll take it up at 2:30. 2:30. Give him an extra copy. Tomorrow. No, give it.
My lord, tax fresh matter. Previously the date
Give it.
tomorrow, my lord.
Yes.
My lords, on memo for being
Serve
spoken.
advance copies on the council.
Served, my lord. It did not reach.
Memo for being spoken, my lord.
Give it.
Can it be tomorrow, my lords?
Yes, tomorrow.
My lord.
There are 6 petitioners, my lords. The land of the petitioners are acquired for formation of Shivram Khad and layout. In the year 2021
Give it.
years.
Tomorrow.
With your lordships,
You serve in
kindly.
advance on any of the BDA council who handle these matters.
With your lordships, kindly. My lords, a vacating stay application has been moved.
Give it.
Which is, my lords may have it tomorrow. The advocate general has to appear, my lords.
Give it.
My
Or
lord.
on the top of the list, my lords, an indulgence,
It will
please.
come. Vacating list.
The lordships, this is a.
My lords, either tomorrow or day after. Any day on top of the list, my lords. There's some urgency.
Fresh matters list आदमी को.
The lordships, this is
I'll give a memo.
mention.
Memo करता है दिन को.
This is a disposed of APIM where there were certain documents that were placed in a sealed cover. The company has gone into CIRP in the NCLT and those documents are required. I'm only asking for the application to be listed.
Yes.
My lords, may I mention?
Wait, page wise.
Tomorrow, your lordships.
My lords,
The-
my lords, may I make a mention, my lords?
Just wait, page wise.
Amendments list 1, page number 1, page number 2, page number 5, serial number 2 to 8, page number 6, 9 to 18, page number 7, 19 to 24, page number 8, 25 and 26, list 2, page number 1 and 2, page number 2, 3 to 10, page number 3, 11 to 17, page number 4, 18 to 25, page number 5, 26 to 31, list 3, page number 1, page number 2, 2 to 7, page number 3, 8 to 9, 8 and 9, page number 4, 10 to 14, page number 5, 15 to 22, page number 6, 23 to 27, page number 7, 28 to 36, page number 8, 37 to 45.
Your lordship, serial number 40, your lordships, list 3, serial number 40, can we have it on 29th, your lordships, in the same stage? Some difficulty today, your lordships.
Relisted request.
29.
Yes.
Page number
Same stage, your lordship.
9, 46 to 52.
My lord, 49 in list 3. My lords, that there is a ex parte order where there is a DRC 13 has been issued. I had mentioned it last week to be listed today, but it is listed in list 3 and 49. My lord, can this be taken up at 2:30, my lord?
Court officer.
We'll make a mark.
My lord, serial number 46, my lord. List 3, serial number 46. Bank account has been attached. Last time when my lords issued notice, I had mentioned this, but thereafter it did not come up for hearing. It was
I'll
listed
make a
on
mark of it.
46,
Yes.
man.
I'll make a note of it.
10,
Please.
53 to 60, page number 11, 61 to 68.
My lord, 51 and 53 also, my lord. Bank accounts are attached and some portion of the tax also has been recovered from my ITC ledger. 51 and 53.
Matter pertains to GST and royalty. There is some urgency. They may freeze the account. That's the reason I'm requesting for hearing at 2:30.
After fresh matters list, we'll take it up.
Please.
Just after fresh matters list.
Right.
List 3, my lord.
List 3.
9.4.
9.4.
Petition 7072.
Yes.
Above petition was ordered to be listed on 4/6/2006.
Court
Just come
officer.
today. has nothing to do with income tax. Mistake.
Serial number 9.4 to be delinked from the batch of matters and listed before the roster bench on the date already fixed. Just wait.
Page number 10, 53 to 60. Page number 11, 61 to 68. Page number 12, 69 to 77. Page number 13, 78 to 84.
My lords,
Page number
70. May I submit, my lords? Page serial number 72 and 81. List 3. I have a bank attachment in those cases, my lords. Can be taken end of the list, my lords.
I'll make a note of it. 72
Please.
and
81, my lords.
81.
My lords, serial number 86 and 87, my lords.
Just wait. Next
Page
page.
number 14,
Yes.
85 to
My
90.
86 and 87, my
86
and 87, my lords. Petitioner is a university where the registration has been cancelled, my lords, retrospectively. Can it be taken at 2:30, my lords? Because subsequently EO will pass the order in consequence to that cancellation. Obliged, my lords. 2:30, my lords, please.
Your Honor, in list 3, item number 57, also lien has been marked, Your Honor, on a bank account of a business.
Just wait.
Page number 15, 91 and 92.
Your Lordship, serial number 91 was to be listed on 25th, Your Lordship. It has come today, Your Lordship. It is a matter which Your Lordship has heard and had directed the matter to be listed on 25th. It was to be listed on 18th, but as 18th was non-sitting day, it was to be listed on 25th, Your Lordship.
Relist on 25th.
Grateful, Your Lordship.
Page number 16, 93 and 94. Page number 19, 95. Page number 20, 96 to 97. Page number 21, 98 to 100. Page number 22, 101 to 106.
My lords, 104 and 105 can be taken up along with 86 and 87. Similar, same petition.
List along with 86 and 87. Yes.
Page number 23, 107 to 111.
My lord, serial number 111, list 3. Appear for the petition. Mr. Venkatraman is appearing in this matter. His requested can be taken up on 25th of April, my lord, Saturday. I wanted after I want after vacation is fine, man. Any day. First week of June, my lord, we can
List the matter. We commencing from.
interim orders may kindly be extended.
Orders in operation are extended till the next day.
Much obliged.
Page number 24, 112 to 116.
My lords, serial number 116, my lords, for respondent number 3 and 4. My lords, senior is out of station on a case, my lords. It may be taken up on 28th, my lords.
My lords, we appear for the petitioners, my lords. We are completely ready, and it's a critical issue. If my lords would then list it on 28th at 2:30, my lords, we can go on because this is the 9th occasion it's coming up post the initial order. Would my lords list it on 28th at 2:30 and continue the interim orders?
We list the matter on 28 at 2:30. Interim order in operation is extended till the next day. But
and
how much
my
time
lords,
will it take? How much time will it take?
My lords, it will take, at my end, my lords, it will take about 45 minutes or so.
The reason why I'm asking is there will be some changes in the roster after 30th. So if it cannot be concluded within that, within those 2-3 days, then it's better to have it after vacation.
My lord, shall we take our chance? Because my lord may be able to. And may I only request one thing, my lord? May it be recorded that this request is from the respondents. Because my lord, the normal order says at request and company officers then face some heat. My
yes, at request made on behalf of respondent 3 and 4, relist the matter on 28th at 2:30.
My lord, interim orders to continue, my lord.
Operation are extended till the next day.
Grateful.
Page number 1.
My lords,
One and
list 4, item number 1, my lords. If it can be heard at 2:30, my lords. It's a simple matter, my lords. Last time you had ordered it to be listed as fresh matters. Last time, my lords had ordered it to be listed in fresh
In
matters.
the fresh matter, if it doesn't reach today, we'll see what to do.
My lords, it will take hardly 2 minutes, my lords.
Page number 2.
Let us
Serial number 3 to 9.
Update for my lords.
Page number 3.
List number 4, serial number 2, we are settling the matter to all 3 writ petitions. And I mean, I request your lordship to take it at 2:30. We are filing joint memo.
2:30.
In the meanwhile, man, I may have permitted a small correction in the amendment.
In the
Small amendment is there. I may, in respect, I have filed an application also.
for amendment of
Amendment of survey number. Two
I-
root petition.
In the prayer.
IA2
there
of
is a-
23.
Ah.
IA2 of 23 in serial number 2.2 has been filed for amendment. Full stop. It submitted that by oversight there is a mistake in the survey number. In light of the reason made out and amendments, said application is allowed. Necessary amendment to be carried out. Pass over.
Two writ petitions.
Huh? No, the amendment is only in 2.2.
There is only one. There is only one.
Two applications is there.
In which other matter?
2.1 and 2.
In 2.1 also.
Please.
IA2 of 23 filed in 2.2 as well as similar application filed in 2.1.
So at 2:30 we will file.
Yes, 2:30.
Page number 2, 3 to 9. Page number 3, 10 to 16. Page number 4, 17 to 20. Page number 5, 21 to 26. Page number 6, 27. Page number 7, 28. Page number 8.
Page number 7, page serial number 28 is covered by your lordship's judgment. Vivek also agrees. He's little late. My request it to be taken up 2:30. It is covered by judgment. Your lordship's judgment. Preliminary notification agide, final agilla ashte.
Which layout?
Flood, that is RT Nagar, Mysore. Your lordship's judgment is there. And he is T.K. Vivekananda have only represented the respondents therein.
Yes, yes.
Page number 8, 29 to 36.
36, please, my lords. I may seek one short accommodation of 2-3 days, please, my lords.
You just inform the other thing.
I will, please, my lords.
Chandrasekhar.
Request relist on.
Page number 9,
Sir,
37 to 45. Page number 10, 46 to 54. Page number 11, 55 to 59. Page number 12, 60 to 64. Page number 13, 65 to 68. Page number 14, 69 to 70. Page number 15, 71 to 73.
My lords, 74 my lords.
Just next page.
Page number 16, 74 to 76.
That's 74 my lords. I appear for the respondent. I requesting for the 2:30 my lords. There is some urgency. This is regarding the formation of the road in the Continua Stadium my lords. The entire project is hold up because of this interim order. The petitioner has challenged with regarding the award, but there is a status quo which is granted with respect of the land also my lords. So my lords, the entire project is on hold. I requested 2:30 my lords. Some urgency in this matter.
Today there are too many matters for 2:30. Manjuna, fresh matters. Yavat fresh matters. Delist in fresh matters list tomorrow. Tomorrow.
Please, mates.
Fresh matters list.
Top of the list, mates.
Fresh matters list.
Please, mates.
Just intimate the other side.
Please, mates. Please.
Page number 17, 77 to 79. Page number 18.
79.3 mana. Dealing by mistake mana linked with other. What it is? 79.3.
79, 79.1 and 79.2.
No, my lord, they are not connected. 79.3, my lord, is to be dealing.
See number 79.3 to be delinked and listed separately
in the
fresh matters list on
27.
In respect of other circumstances, central government has actually they sought for time last occasion matters. They requested the day after tomorrow because some other.
My lord, I appear for the union in 79 to 79 1.6.
Just 1 minute. Now, if 79.3 goes out, the rest goes before the regular roster. It doesn't come here. That's what the court officer says. So
yes, my lord. Actually, the matter has been heard by the Justice Hemalata madam. The matter has been heard.
So it will go before the regular roster.
Day after tomorrow.
Remaining matters to be listed before the appropriate bench on 24th.
Much obliged.
Lordship.
List number 2.
Page number 19, 81 to 84. Page number 20, 85 to 90. Page number 21, 91 to 94. Page number 22, 95 and 96.
My lordship. List number 2, serial number 8, your lordship, seeking for adjournment. Seniors having some personal inconvenience.
Shravan Madam.
Sheetal Borkar.
Serial number?
Serial number 8, list number 3. After
Serial number-
vacation.
At request, relist the matter after vacation.
My lordship, one submission with regard to memo for posting.
Give it, you're late.
17th date put is our list ಆಗಿಲ್ಲ
Actually,
Matter serial number 1.
My lordship. My lordship. Serial number 53. Serial number 10. 2 weeks, my lordship. List 3, my lordship. Serial number 10.
Correct. 10:45, you keep mentioning how I can take. When
Two
we
weeks.
call the page, you must be ready. That is the discipline. Now, if you come, what I can do? Till 11:30, I'll have to sit and do this. Which matter?
Serial number 10, my lords.
List?
3. List 3, my lords.
Garnish Karabin.
2 weeks.
At request, relist after 2 weeks.
List 3, item 18, my lord. List 3, item 18. It may be taken up, my lordship. Recovery notice has come. My lordship has posted today.
Mark. Let us see. I'll mark.
My lordship.
List 3, serial number 80, my lord. Tomorrow or day after.
Serial number?
80, my lord, 80. List 3, my lord. Tomorrow or day after on top of the list, my lord. There's an interim order that I saw.
Relist the matter in the fresh matters list on
24th.
My lords, list 4, 53, my lords, serial number.
My lords, in that list.
I
serial
moved the
number
matter,
85.
my lords. Since there's an office objection, it may be overruled, my lords. The fresh matter, my lords, it may be taken up at 2:30, my lords. Urgency is this, my lords. KDB has passed the order, my lords. If it does not stay the matter, means it will be dispersed the compensation amount, my lords. The office has raised the objection in the regard.
We'll take it after fresh matters list.
Yes,
You
ma'am.
wait, you ask the KDB council to be.
Yes, my lord, I'll intimate him.
List 1, serial number 85. Bank attachment has taken place, my lord. 85, my lord. List number 3. Requesting that it could be taken up, my lord. Serial number 85, because I have sought an interim order. It's been a.
Let us see.
My lord, my
Mark mud.
If possible today, my lord.
Let us see.
Please, my lord.
My lords, and mentioning my lords.
Serial number 1.
Give it.
Serial
One
number,
being
list number
spoken
4,
to.
my lords. Serial number 66, my lords. 66.1 may be delaying, my lords. (528/2020). 66.1 may be dealing, my lord. 528/2020.
That has nothing to do with 66, is it?
No, my lord.
Is this fourth list being mentioned?
Yes.
Please. No, it's both pertain to the same survey number. Survey number 128.
Let us see. Let us see. Both
The matter reached, my lord, so I have to point out.
Both they're saying relates to same survey number. Let us see when it reaches.
List 1 being spoken to serial number 1.
Lord, I appear on behalf of the petitioner, my lord.
Yes.
Your lordships had passed the order on the last occasion.
Yes.
List 1.
Yes. There was some missed. Correct. Now, insofar as the release of amount, any instruction?
My lords have granted us time till next week, my lords. We have written letter to the EDA.
So we'll get the instructions and then submit on that day.
Yes. All matters being was listed for being spoken to. As it is submitted that the matter as uploaded did not reflect entirety of the order that was dictated.
That also, my lords have noted that.
Noticed the order that was dictated on the said date. Taking note that there appears to have been a lapse office to upload the entirety of the order dictated on that date after verification. Full stop. The office order is dictated on such date reads as follows. Accordingly, the order dated so and so is substituted by the following order. Relist the matter on
Next week, no, it's 27th or 28th.
27th or 28th.
27th. Relist on 27th in the fresh matters list.
Please, great.
My lord, serial number 73 in list number 4.
No.
My lord.
Mentioning is over. Mentioning is over.
Serial number,
Yes,
fresh
kindly,
serial number 2.
Lord,
Serial number 1.
Lord, there are other connected matters in the
Serial number 1, my lord.
serial number 1 only.
This is in relation to 5 writ petitions, my lords, pertaining to Jamna Lal Bajaj Seva Trust.
Correct. Now these matters
Only, my lords. This interim order, my lords, was pertaining to only with regard to that particular acquisition.
the interim order passed was in only insofar as 4550. It is clarified.
Yes.
Interim order passed is only with respect to WP.
I'll give those numbers, my lords. There are 5 writ petitions. I'll give those numbers.
So it's there, isn't it?
4550 is the writ petition which is filed by the landlord, my lords. Writ petitions were filed by BDA challenging that order, award, my lords, that are connected.
That is
because the other
WP
matters
number
were connected
22088.
in the order.
22088.
I'll give those numbers.
Office to further list other writ petitions stating which are stated to raise identical legal issue.
Please.
These are as follows.
Please. Lord, I filed an application for dispensation of the certified copies in the other connected matters, Lord. Lordship formally dispense with.
In serial number?
Lord, writ petition 965, Lord. 1045.
1.1, 1.2.
Lord, 1106, 1109. I'll give the numbers. I'll give the numbers. Lord, dispensation of the certified copy.
IA filed.
Please.
Seeking dispensation production of certified copies of
The awards.
the awards.
Please.
Is allowed.
Please.
Subject to the undertaking that in one of the matters, certified copy would be produced in due course. Accordingly, IAs for dispensation in the present batch of matters is allowed.
Please. Public.
Great.
Special matters, serial number 2, Leela.
My lords, I appear for the petitioner, my lords. My lords, I'm seeking writ in the nature of Mandamus, my lords, to consider the representation of the petitioner to for acquiring the entire remaining extent of land in survey number 130/2, and my lords, to direct the respondent to pay the additional compensation of rupees 3 lakh that was resolved by the Land Valuation Advisory Council.
Take out notice.
Please, my
AGA
lords.
accepts notice for respondent 1 and 2. What about 3? HL Pradeep Kumar accepts notice for respondent number 3. List the matter in the preliminary hearing list in the week commencing from
11th June. Serial number 3, Vasant Kumar.
For the annexure H, impugn cancellation challenge, the petition father was allotted his site.
Cancellation of?
Termination of site.
15th.
He has not paid the amount within stipulated period for which cancellation came to the issue. And thereafter, fresh application was filed.
2007.
Yes, ma'am.
Cancelled in 2007.
Yes, ma'am. The entire settle amount was paid within stipulated period. My father died. And also the...
You take out notice.
Please.
And learn counsel. BDA. BDA.
Yes, sir.
B.S. Karthikeyan is directed to accept notice for the respondent. Read the matter in the week commencing from
15th of June. Serial number 4, Sundaraj SC.
Not appear for petition in this case. The petition's revenue site was acquired by PDA for the formation of Saram Veshweshwaraya layout. Further, in the Jinjama case, the alternative site was allotted in the year 2026 by fixing the market value, the present market value. So that is under challenge before this law court. The identical case, this court has set aside the fixing of market value prevailing the date of allotment letter. And
who is there for the BDA? Any BDA council?
Vasant.
Learned council. Vasanta is directed to accept notice for the respondents. You just find out. He's saying it's covered. relist in preliminary hearing list on
29th.
yes
29.
5. Varaprasad K.
For petitioner in this case, it is a matter pertaining to land acquisition by KADB, my lord.
3 and 4.
Same notification earlier been challenged before this court, my lord, and this court have considered the grievance and granted interim order in the said case, my lord. The very same final notification which has been notified after 14 years of preliminary notification, your lordship.
File occurred for respondent 3 and 4 PV Chandrasekhar, my lords.
So on the same grounds they're saying, so shall we stay?
Yes,
Learned Counsel PV Chandrasekhar accepts notice for respondent 3 and 4. AGA is directed, where is that? AGA is directed to accept
Earlier
notice
interim
for
order at
respondent.
annexure L, my lords, page
1 and
45,
2.
my lord.
Good stuff. It is a case of the petitioner that the preliminary notification that the declaration under section 28(4) is after 14 years after passing of the preliminary notification, submitted that in identical matters, this court in WP 852 of 2026 has passed an interim order of stay of an
Annexure F, my lord.
final notification, stay of the final notification.
Annexure F.
And on the principle of parity, an identical order may be passed in the present matter also. Interim order passed in WP 852 of 2026 reads as follows. Next, accordingly, in the present matter as well, there would be stay of the final notification at annexure
F, my lord.
at annexure F.
Page 31, your lord.
At annexure F. A list along with WP number so and so.
6.
Lordship, serial number 10 is also of same thing.
Just wait, just wait. Next.
6. Sundari.
This is only a mandamus to consider my representation for execution of sale deed in respect of the site allotted. Site was allotted in the year 2013 and the amount was deposited.
BDA. Vasanta is directed to accept notice for respondents. This is the matter in the preliminary hearing list in the week commencing from
15th of June. 7. Sangamesh RB.
The matter where plus this is a matter where, my lords, the national highways, my lords, they've utilized my land, my lords. They have not notified it, my lords. Neither compensation is paid, my lords. This, in fact, my lords, the second round of litigation. My lords, earlier round, my lords, it was disposed of, my lords, with direction.
Take out notice.
My lords, I have sought for interim prayer, my lords. Interim prayer is that, my lords, to conduct survey, my lords, so that to find out what extent of land they've used, my lords. My lords may direct them to accept notice. My lords may have it on 28th. My lords.
Learned Counsel Chief Kumar accepts notice for respondents
1 to 4.
1 to 4 and, my lords.
1 to 4
and 6.
My lord.
And 6.
5, 6 and 7, my lord, date will be taken. I'll learn it.
1 to 4.
1 to 4.
AG accepts notice 5 to 7.
Let them sir copy, my lord.
Relist the matter the same stage on.
Let them sir copy, my lord.
Copies to be served.
I'll serve it, my lords. On 28th.
Sir, I have kasa.
Yes.
Number 8.
On 20th, lords.
Mandamus to consider my representation for.
I'm sorry, my lords. My lords, on 28th. My lords.
28.
Didn't read.
This is only for execution of sale deed. My site was allotted in the year 2013. Till today, my lord, the sale deed was not executed.
Learned Counsel
PDA. Same similar to serial number 6.
Basaraj HT is directed to accept notice for the respondent. Relist the matter in the preliminary hearing list in the week commencing from
18th of June.
Yes.
Serial number 9.
Here for that. The respondents, my lord, have received the notification proposing to acquire survey number 40/5, 40/7, and 53/3, my lord. Thereafter, my lord, final notification is issued, acquiring only half quintas in survey number 40/7 and dropped the proceeding in respect of other survey numbers. My lord. In spite of it, my lord, the RTC continued in the name of the Urban Development Authority, my lord. Therefore, my lord, requires to be
AGA is directed to accept notice for the third respondent. Muda.
1 and 2 Muda. 1 and 2 Muda.
Learned Counsel. Learned counsel Shishar Kauda GP is directed to accept notice for respondent 1 and 2. Relist the matter in the preliminary hearing list on.
Okay.
Yes.
10. Varaprasad.
For petitioner, my lord. Lord, the again matter pertains to land acquisition by KDB, my lord. The same notification, my lord, at annexure F, your lordship. The same notification been challenged earlier before this court, my lord, and this court having looked into the grievances of the petitioner, granted interim order, my lord, which is produced at annexure K, your lordship.
Same order.
Please, your lordship, annexure.
Same
Please,
interim
very
order.
same notification.
Same interim order.
Please, your lordship.
As in serial number
5, my lord.
5. No change.
No, my lord.
Annexure.
Annexure F is a final notification.
Stay of annexure F. Same order as in serial number 5.
Please, your lordship.
11.
I may probably take notice for that.
B. Chandrasekhar accepts notice for respondent 3 and 4.
2 and 3. 3 and 4.
3 and 4. AG accepts notice for 1 and 2. Yes, next.
Grateful to us.
11. Excellency.
My lords, appear for the petitioner, my lords. I have served the copy in advance to the standing counsel, my lord. Writ for Mandamus, my lord, to consider my representation at annexure A, page number 14, my lord. Out of 6 acre, 20 guntas, 3.5 acre is acquired. Remaining, my lords, 2 acre pertains to me. To that effect, my lord, I am seeking for no objection certificate from the concerned authorities, that is KHP, my lords.
Learned counsel Pradeep Kumar accepts notice for the respondents 2 and 3. AG accepts notice for 1 and 4. Relist in the preliminary hearing list in the week commencing from
15th of June.
Yes.
12.
Great.
Varaprasad K. 12.
Yes. Appearing for the petitioner, my lords.
That cannot be a submission.
Submission is, we are asking for a representation from BDA side, my lord.
Consideration of representation.
Yeah.
Learned counsel. Some compensation is learned counsel. PRR. K. Krishna is directed to accept notice for the respondents 2 and 3. AJ directed to accept notice for the first respondent. Relist the matter in the preliminary hearing list on. Yes.
13.
Much obliged, my lords.
13. Samik Shettiya. 13, sir. Samik Shettiya.
I'm extremely
13.
I'm extremely sorry, madam. Please.
Yes.
My lord.
Remand number.
Yes. 13. May I beg to directly take my lords to 102, my lord, page number. This is the alignment of the 102, my lord. The petitioner owns extensive lands. As per the continuous notifications issued by the National Highway Authorities for acquisition of land. 102, first sketch, your lordship, you can see. First one, there are 2 sketches are there. This is up to starting from 2020. This is the alignment of the National Highway, my lords. National Highway has to be straight. And the next one, now what they do is, next one is this. Now presently what they've done is annexure. It's second portion, my lords. Where the land, National Highway touches my property, my lords, they have divided it now. Without any purpose. Complete alignment itself is they changed. May.
You serve the council, will have it tomorrow. Learned council.
Highway. May, with kind permission, may I pass on the.
Tomorrow we'll have it.
Tomorrow, my lords.
So you point out, if you have extra copy, you give it to him. Let him have a look at it.
Please. The very narrow stretch of land where there is an excess. They already acquired, paid the money, that narrow stretch of land in survey number 30/4. Now they want to delete that by changing the alignment. Entire payment is made, award has been passed for 30/4, my lords. That very narrow stretch of land, my lord, now they want to delete it from the alignment and make it change the alignment itself there. At that exact moment, exact portion, my lords, they change.
I request, my lord.
Turn
After 2 days, my lord. 2 days, my lord. Because.
My only fear is, my lords, if they go for 3D, now they have rejected my objections, my lords. I have put the objections, how they are doing it, my lord, very to please somebody, they have done it. They rejected my objections.
We'll have it day after tomorrow.
Good.
Council Shri Kumar accepts notice for respondents 2 to
5.
2 to 5.
6H government.
5 and
6, my lord.
2 to 5.
Deputy Commissioner.
PGA accepts notice for respondent number 6.
6 is government.
So,
2 to 5M.
is for the first respondent. The senior counsel appearing for the petitioner would draw attention to the sketch at page 102 and submits that the change of alignment appears to be malified in order to accommodate the interests of certain landowners for say of the petitioner, for say of respondents 1 to 5. 5 relist on. Yes. You may have to implead that other landowner also.
Pardon me, other landowner, his land is already acquired, money is paid, my lords. They want to now drop it. Once money is paid, I beg to submit, my lord, land has already vested with the national highway authorities. RTC has changed it, my lords. Record of rights is the national highway authorities.
Let us see.
If your lords feels, my lords, you lords can direct me, I'll obey it.
Let us
the next.
14.
Please.
Lord, I prefer the petitioner.
Yeah, the previous matter, fresh matter is this.
Most great.
Somsekhar KM.
Lord, I appeal for the petitioner. Lord, the BDS allotted a site in the year 1992. The petitioners paid and made the entire payment. Then they have executed the lease cum sale agreement. All of a sudden, my lord, they have allotted site to third person and executed sale deed. Then the petitioners made representation from 1995 to till 25, my lord, for allotment of alternative site.
BDA, Learned Counsel, K. Krishna is directed to accept notice for the respondent. Relist the matter in the preliminary hearing list one date. These are genuine cases. Now you give them site, then you allot it to somebody else. These matters, even without it coming before the court, you must solve it on top prior. Otherwise, the very confidence in the authority would stand shaken if their bona fide claim. Relist in same stage on. Yes.
Obelisk.
You take some personal interest in.
15. Narasimha Rajan.
Appearing for the petitioner. This is a writ of Mandamus not to disperse the compensation. My lords, the petitioners herein are filed in OS suit, my lords. Kindly page number 13, my lords.
Page?
Page number 13, my lords. The petitioners are filed in OS suit, my lord, for partition and separate possession, my lords. Thereafter, the respondents have also filed a rejection, IA, my lord, for rejection of client. That IA also came to be rejected, my lord.
Now the defendants in that suit,
yes, my lord,
are respondents here.
Yes, my lord. Respondent number 5 and 6, all defendants are made as respondent in this, my lord. My lord, thereafter,
now the land has been acquired
on 8/7/2025, my lords.
8/7/2025.
Item number 4, only the item number 4 of the scheduled property has been acquired by KDB, my lord.
Item number
4 of the scheduled property in OS, my lords. Kindly come to page number 22, my lords. Serial number 14/2, measuring 2 acre 24 guntas.
Paragraph?
Item page number 22. Item number 4.
Item number 4, you would say.
Yes.
Page number 22.
Suit was filed earlier.
Yes, my lords.
So then you still don't disperse it. Let us see.
Yes, my lord. I take notice of respondent number 2.
Joint Counsel Subindar Shirali accepts notice for respondent number 2.
Yes, ma'am.
AG accepts notice for first respondent. Emergent notice to the private respondent. Submitted that the petitioners herein have filed OS 604 of 2021 seeking for the relief of partition. Seeking for the relief of partition. Full stop. In the said suit, it is stated that the private respondents herein are arrayed as defendants. Full stop. Further submitted that the suit is filed in the year 2021 while notification for acquisition was issued on 8/7/2025 during the pendency of the suit for partition. Full stop. Further submitted that there is a possibility that the second respondent may disperse compensation. Full stop. Next, in light of the rival claims made out and noticing the pendency of OS 604 of 2021, the respondent KDB is restrained from disbursing compensation insofar as item number 4 is concerned. 4 of OS 604 of 2021 insofar as the disputed share.
Yes, ma'am.
Till the next date.
Kindly press for
Emergent notice to respondents 3 to 12. AG is directed to accept notice for first respondent. Yes.
Kindly press for
16.
It will be uploaded. It will be uploaded. Yes.
16. Darren.
I appeal for petitioners, my lord. The writ of Mandamus to consider my representation, which are, my lord, annexure K, K1 and L, my lords.
What is the relief you are seeking?
What has happened, my lord, out of 2000 square feet,
The
400 or some odd square feet has been acquired. Rest of the property has become, my lord, unusable. Lord, kindly see the photographs which I have produced at annexure F.
Okay, so you are saying you
Asking
acquire
Lord,
the whole thing.
asking VMRCL to acquire whole thing, Lord, since
Then council, HL Pradeep Kumar accepts notice for respondent 2 and 3, AGF of first respondent, relist in the week commencing from
15th of June.
Yes.
17.
For the same stage, my lords.
15.
Yes, yes.
And for the petitioner, my lord, kindly pass over, my lord.
It won't reach, madam. What now? What is it? What have you challenged?
My lord, senior ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ engage ಆಗಿದ್ದಾರೆ, man.
28(1) and 28(4). Also, they issued notice under 28(6), my lord. It is under challenge.
Whether there is a stay in any other matter?
No, my lord.
No.
No stay.
You take notice, will fix a date. And council, Vasanta accepts notice for respondents
2 and
4.
4.
AG accepts notice
Well,
for 1
kindly
and
pass
3. Relist the matter in the fresh matters list on.
29th.
Yes.
18. Suresh.
I was appearing with the petitioner, my lords, seeking for quashing of the general award, my lords, and seeking for the consent award, my lords. One suit.
Then council, Chil Pradeep Kumar accepts notice for respondents 2, 3. Shall we dispose it?
Yes, sir.
AG accepts notice for the first respondent. Petitioner sought for issuance of writ of certiorari to set aside the general award dated 11/10/2019 at annexure A insofar as lands of the petitioner are concerned, and has further sought for issuance of a writ in the nature of mandamus to direct respondents to consider case of the petitioner for passing of an award in terms of agreement as is permissible under section 29 subclause 2 of the KIAD Act. Full stop. Repeat. There are 3 till end in WP 36627 of 2025. Annexure general award.
Annexure A, my lord.
Annexure A, my lord.
Same.
Annexure A.
Same
Well, the
annexure.
Seal number
A.
4, my lords, list number 4, seal number 46. my
Respondent
lords.
number 3.
Lord, respondents 2 and 3.
Same.
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 2 and 3.
Respondent 3.
Yes, my lord. 3. SLO is 3.
Same identity. Accordingly.
Well, seal number 46, list number 4, similar.
Same
orders.
party, my lord.
Seal number.
List number 4, seal number 46, my lord. Same party, but survey number is a lot different. Survey number is 105/8, my lord. What is this? Annexure A, my lord. Annexure A, page number 14, my lord.
That's the general award.
General award. 105/8.
So same.
Same. Respondents here, my lord, is 6. Respondent number 6.
Respondent number 6 at paragraph 5, Roman 3. Same order, HL Pradeep.
This was very much obliged, my lord.
19, Anusha, Nandish.
Query for the petitioner, Mullets. The petitioners are challenging the Betterment tax levied, Mullets, by the BDA, Mullets. Petitioners' houses are regularized under the Shivram Karant layout, Mullets. They are left out of acquisition, Mullets. Because I am not disputing our liability to pay Betterment tax, Mullets. We have disputed the rate of Betterment tax, Mullets, and the minute we have disputed it or objected to it, Mullets, it has to be referred to the district court, Mullets, for computation and assessment, Mullets. None of it is done, Mullets, and directly interest is being calculated, Mullets. I've produced demand notices as well as interest breakup that is being reflected online, Mullets. Served advance copy on the advocate for
What is the provision in case of dispute
21, Mullets, 21, 4, Mullets.
of
BD Act.
Order.
21 is for assessment of betterment tax by the authority, Mullets. 1 would be for show cause notice, Mullets. 2 and 3 would be regarding opportunity of being heard, Mullets. 4, Mullets, if your lordship's got subsection 4 of 21, if the person concerned does not accept the assessment made by the authority or fails to give the authority the information required under subsection 2 within the period specified therein, the authority shall make a reference to the district court for determining the betterment tax payable by such person.
No, you have stated that you're not accepting it.
Please, Mullets, objections are filed, Mullets. Mullets, first of all, Mullets, there has to be an assessment list, Mullets, that is published. Pursuant to that, Mullets.
That the district court will examine.
Please, Mullets.
If according to you the procedure is wrong, then it has to be referred.
Please, Mullets, there has to be a reference to the district court.
Yes.
Lord Millard, see, my lord, the BD Act section 20 for a moment. Section 20, my lord, refers to, my lord, the betterment tax which can be levied on the person, my lord, whose house can be regularized. Section 20, my lord. Pursuant to which, my lord, now we have passed an order. Insofar as, my lord, Shivram Karnataka, my lord, spread across 17 villages. Insofar as 17 villages is concerned, my lord, insofar as each regularized house is concerned, a certain price is fixed. That, my lord, my learned friend herself has produced at page number 34. Petition.
What is this betterment levy for?
Well, now, my lord, there are houses which had been constructed prior to the final notification being issued. Now, those houses later on at later date, my lord, pursuant to Supreme Court's order, came to be regularized. So, by virtue of which, my lord, they were permitted to hold the sites in spite of the final notification. Now, because of Shivram Karant layout being formed, there has been an increase in the land value. Earlier, it was a revenue site. Let us say, my lord, it was valued at 1,000 rupees. Because of Shivram Karant layout being formed in the adjacent area, the land value came to be increased to 2,000 rupees. That's for example. So the difference is around 1,000 rupees per square feet. With respect to that 1,000 rupees per square feet, since there is an enhanced value insofar as their land is concerned, as per the provisions of that, the BDA can levy some tax called as a betterment tax. Because your land value came to be increased because of the development made by the BDA, they are bound to pay, the landowners or the site owners are bound to pay a certain amount of tax that is called the betterment tax that is levied under section 20 of the BDA Act. That what was levied, my lord, is at page number 34 of the petition. Insofar as each village is concerned, there is a different betterment tax which has been finalized insofar as, my lord, the Shivram Karant layout is concerned. Now BDA Act, my lord, section 20 may kindly be seen. Levy of betterment tax.
No, correct, but in case they dispute it.
Yes, my lord. Now kindly see, the 20, my lord, is the levy of the betterment tax. That is the tabular column, my lord, which I took your lordships through at page number 34. Thereafter, my lord, notice comes to be issued. At 21, in that notice, we say what is the betterment tax liable to that specific site owner is concerned. Now, that is the notice which we have issued. That is the notice which they have impugned before your lordships. That is at annexure. This is at page number 36. I don't know the annexure, but it's at page number 36.
It should be.
This is the, my lord, insofar as the petitioner is concerned, they are to pay around 22,64,000 odd rupees. The bottom portion, then after the tabular column, there is a note, my lord, which has been put up. E notice ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕದಿಂದ 90 ದಿನಗಳ ಒಳಗಾಗಿ ಸಂಬಂಧಿಸಿದ ಭೂಮಾಪಕರು ಸದರಿ ಭೂ ಅಭಿವೃದ್ಧಿ ತೆರಿಗೆ ಮೌಲ್ಯವನ್ನು ಸ್ವೀಕರಿಸುತ್ತೀರೆ ಅಥವಾ ಇಲ್ಲವೇ ಎಂಬುದನ್ನು ಲಿಖಿತವಾಗಿ ಕೆಳ ಸಹಿ ಮಾಡಿದ ಅಧಿಕಾರವನ್ನು ತಿಳಿಸತಕ್ಕದ್ದು. Within 90 days, they have to reply whether they are accepting it or rejecting it or they have any objection to it. To which, my lord, the petitioners have replied. Now, as per, my lord, 21(2), thereafter, my lord, we have to issue another assessment order. 21(2) may kindly be seen. The authority shall then assess the amount of betterment tax payable by each person concerned after giving such person an opportunity of being heard, and such person shall within 3 months from the date of receipt of the notice in writing of such assessment inform the authority in writing whether or not he accepts the assessment. When the assessment proposed by the authority is accepted, such assessment shall be final. If not, my lord, then we will have to refer to the district court. Now, my lord, here may be a case, my lord, wherein we have not passed a subsequent order. Let this, my lord, the matter be remanded back. In view of the objections we have filed, let us, my lord, the BDA be given a direction to pass a fresh assessment order, keeping in view the objections raised by the petitioner. And after that assessment order, my lord, if the petitioners are not agreeable, then, my lord, as per the relevant provision, we'll have to refer the matter to the district court for final adjudication.
No, now you have taken note of, or you say that it can be reconsidered.
Yes.
My lords, interest is being calculated, my lords. Proposal when.
Just 1 minute. Now they're saying they'll reconsider it. So where does interest come?
Because, my lords, annexure D1, my lords.
Madam, just understand. He's saying, so that order will go.
Please, my lords, that the
then
interest.
they will reconsider.
Please, my lords.
So then where is interest that goes out?
Please, my lords, let that also be, because, my lords, the minute the phone number is entered, my lords, the demand notices as well as the interest breakup comes, my lords. My lords, for 3 months, my lords, they calculate interest over 1 lakh, my lords. All these are small houses, my lords.
But it's left out. So you have to pay under protest and then contest it. What will happen? It has been left out, isn't it, from acquisition? That is a big relief for you. No doubt there is some financial implication for that, but you could pay and then anyhow leave it.
In fact, 90% of the homeowners, they have paid, my lord. It's only few of them, my lord, who are before lordships. My lord, that apart, if given opportunity, my lord, BDA will consider their objections and thereafter pass fresh orders.
No, correct, but actually how you can pass a different order once in the table? You have fixed it.
Yes.
You can't reconsider. It will have to.
No, reconsider, my lord. No, what happens, my lord? The primary contention of the petition is that there are 17 villages. Not every plot is the same village. Now, what they are saying is the adjacent landowner who falls in a different village, they are valued at a different price than the petitioners therein. This is one of the conditions. In list number 4, my lord, there are batch of petitions. So that can be clubbed with this. Now, common contention raised is there's differential pricing insofar as different villages are concerned. Now, it is spread across 3,000 acres, the entire layout. The price is fixed in one portion cannot be the price in the other area. In that background, there's a differential pricing. That apart, when the pricing we have fixed, it is for a residential, for a duly constructed plot after taking permissions. Now, many of these, my lord, are revenue site holders. Revenue site holders, my lord, cannot be considered on parity with the regularized site owners. In that background, my lord, the valuation is higher. They may have purchased for a lesser value. A duly formed layout, my lord, would be sold at a higher value. So there is a differential amount. They are agreed by that also.
The fixation under the BDA Act, my lords,
the betterment tax has to be fixed per road. It has to be assessed, my lords. Each village cannot be generally and commonly. My lords, that has been held in Gangaya Naidu's case, my lords, and it is a settled norm, my lords. Each house has to be assessed differently.
Anyhow, they're going to reconsider.
Please, my lords, there are
Raise your objections, annexure.
Please, my lords. Annexure, page 42, my lords, annexure C1, C2, C3, my lords.
Fine, dealing करते हो।
The petitioner has sought for setting aside of the endorsement at annexure A. I sought for setting aside of the resolution. Resolution as regards subject number 67 of 24.
Please, the resolution.
67 of 24, dated 7/3/24. Petitioner has also sought for setting aside of the demand notices at annexure B1, B2, B3. Next, it's the case of the petitioner that insofar as fixation betterment levy, petitioner has made out a representation dated 21/11/2025, making out grounds as regards their objection with respect to the fixation of betterment levy. That representation is detailed. Full stop. It is the case of the next is the case of the petitioner that if an assessment as regards betterment levy is made and the petition and the landowner / site holder is not agreeable and registers objection, then the respondent BDA terms of section 21 subclause 4 of the act is required to make a reference to the district court for determining the betterment tax payable by such person. Full stop. Next, accordingly it is submitted that in light of the objections raised by the petitioner in terms of their objections at annexure C1 to
C3, my lords.
C1 to C3, the respondent BDA ought to have referred it to the district court and could not have raised a demand and sought to enforce such demand as against the petitioner. Next, non-counsel Shiv Prasad Shantan Gowda appearing for the respondent BDA accepts notice for respondent 2 and 3. Order sheet and mark. So and so accepts notice for respondent 2 and 3. He accepts notice of first respondent. Non-counsel Shiv Prasad Shantan Gowda would submit that insofar as the representations, same would be considered and appropriate decision taken as regards such objections. Further submitted that they would keep in mind the provision of 21(4) as a consequence of not accepting the objections if such conclusion is arrived at. Full stop. In light of the same, the petition is disposed of. The respondent PDA is directed to consider the representation at annexure C1 to C3 and pass appropriate orders. And if respondent BDA does not uphold the objections of the petitioner, necessary steps to be taken in terms of section 21(4) of the Act Accordingly, petition is disposed of. Full stop. In light of disposal of the petition with a direction to reconsider representations at annexure C to C3.
Please.
The demand notices at annexure
B1 to B3 minutes.
B1 to B3 are set aside. All contentions on merits are kept open. Accordingly, petition is disposed of.
Look, similar batch matters are at list 4, serial number 27.
Dispose it of.
Similar.
Copies are served already.
You appear in all.
All matters. Serial number list 4, serial number 27 to 27.8. Similar matters.
You appear in all the matters.
All matters.
So same order.
Please, annexures may vary, because
that you make a table and give it.
I will give it.
Same order.
Please, same.
27.
Serial number?
27, list 4. I'll make a table and give it,
Dispensation.
These serial number is the present. 19, a list along with the serial number 27 batch of matters and serial number 27 in list 4. Identical prayer.
Identical prayer where resolution is challenged, demand notices are challenged, and the interest is challenged.
Same. In all these petitions, an identical prayer is made challenging validity of the resolution. Resolution of
all these petitions. I filed my statement of objection. I filed it today morning. Taken on record.
Validity of the resolution of BDA dated 67 of 24. Dated 7/3/20. The petitioners have challenged the action of the respondent BDA as regards fixation of betterment tax under section 20 and 21 of the BDA Act. Next. The petitioners in all these matters have filed detailed objections for the levy of betterment tax. The details of the representations of the petitioners as regards levy of betterment tax are depicted in the table as below. So you make a table.
I'll make a table.
And then you say writ petition number, first column, then second column, you put the date of representations.
Please, Manoj.
Demands to
demand notices. I'll also mention demand notices, Manoj.
And then you mention the impugned annexures in the last column.
Please, Manoj.
And then you put one more paragraph of which of the demand notice annexures are being set aside.
Please,
in the last. So in this you make the table.
Please.
You put there the impugned annexures.
Please.
Also, and then you make a separate paragraph mentioning in which writ petition, which annexure, which is the demand notice, is being set aside.
Please.
Accordingly, petition is disposed of. The statement of objections, order sheet, statement of objections filed by the on behalf of the BDA are taken on record.
Milords, in all these matters, objections are filed, Milords. Even if the petitioners do not file objections, it is as good as they have not accepted, Milords. There's some matters which have not come up before the court.
We'll see when it comes up.
Please, Milords.
Yes.
Obliged.
Serial number 20. Serial number 20, Chetan, AC.
Yes.
Appearing for the petitioner, my lords. It's a simple mandamus, my lords, in order to consider the representation to provide alternative site, my lords.
Sajay Kumar. Give him an extra copy.
It will be given, my lords. My lords, earlier the BDA has granted 4 sites, my lords, out of which 3 sites had no problem, my lords. Only 1 site is falling under the park zone. For that, we are asking for to consider the representation and allot alternative site, my lords.
Let him find out. AGA accepts notice for first respondent. Land Council Ajay Kumar accepts notice for respondent 2 and 3. Relist the matter in the preliminary hearing list on
29th.
My lords, kindly fix a date, my lords.
29th.
Umesh BN.
Now, in case Ajay Kumar, in case you are ready to consider it, you ask her to move a memo.
Please.
Case.
29th, by that time I'll try to.
So on that, then you can make it clear. We can pass some more.
Please, 29th I'll get the instructions for that. Please.
Much
Break.
obliged.
21 Umesh BN.
My lord, regarding considering the representation regarding the variation of the measurement in the adjudicant set.
Regarding
variation in the measurement of the adjudicant set, we have made a representation that has not been considered.
Okay. Land Council B. Anusha Prasad is directed to accept notice for the respondents. Relist the matter in the week commencing from
15th of June. 22 Sharon N.
My lord, it's a quashing of general award. It is, my lord, page number 82, my lord, annexure H.
Shall we dispose it off?
Please, my lord.
Krishna has challenged the validity of the general award passed by third respondent at annexure H, insofar as it relates to properties of the petitioner more fully described in the schedule. Next, petitioner sought for consequential direction to the respondent. Number 3, to consider the representation for passing of award on the basis of agreement in terms of section 29(2) of the KIAD Act. Repeat para 3 onwards. Annexure
H, my lord, general award is annexure H.
para 5 Roman 3 annexure H.
Please, my lord. And the second prayer is what has happened, my lord, subsequent to passing a general award, a corrigendum notification has been issued. In that, my lord, my lands were notified. My name and extent of the lands has been notified. So that is, I have produced, my lord, annexure J, my lord, which is page number 91. Relevant portion is, my lord, 92. Their names of the petitioners and their lands has been mentioned, my lord. So, my lord, in that extent, my lord, as per the corrigendum notification, they have to consider my claim, my lord, under section 29(2) after
Paragraph. The respondents also to consider the request of the petitioner, keeping in mind the extent notified in the corrigendum notification dated 17/1/2019.
Please, my lord.
Huh?
Please, my lord.
Dated 17/1/2019. That one that much. Published on 18/1/2019.
Please, my lord. That is as per 1/12/2020, my lord.
Huh?
As per 1/12/2020.
What is 112?
There is second in the page number 92, my lord. Tiddupudi Adhisoochana Sankhi CI 106 SPQ 2019. Dated
Corrigendum notification dated 1/12/2020.
Please, my lord.
Corrigendum notification dated 1/12/2020. One sentence at 36627 of 25 extraction. Land Council Pradeep Kumar.
And serial number 34 in list 4, my lord. That is also same.
2 and 3. Metro?
Pradeep Kumar.
HL Pradeep Kumar.
Metro who accepted? Huh?
HL Pradeep Kumar, where also appear.
AGA for first respondent, 224 HL Pradeep.
ಎರಡು compare ಆಗಂಗಿಲ್ಲ.
Yes.
For list 4, serial number 34 is also same, my lord, general award.
Serial number 34, list number 4, ma'am.
Who accepts notice here?
It's Pradeep Kumar acceptance. Sir, ನೀವು ಒಂದು ಕನ್ಫ್ಯೂಸ್ ಆಗ್ತಾರೆ ಸಾಹೇಬ್ರಿಗೆ. ಕನ್ಫ್ಯೂಸ್ ಆಗ್ತಾರೆ ಸಾಹೇಬ್. ಅದರಲ್ಲಿ. ಬೇಡ, ಇದನ್ನು ನಮಗೆ ಕೊಡಿ.
Council HL Pradeep Kumar accepts notice for respondents 2 and 3. AGA accepts notice for the first respondent. 34. This is developed land, this is.
Please, my lord, that is the order has been produced, my lord. Your lordship order, which is 136 page number. Annexure K, my lord.
Correct, if you say same, then it becomes difficult. 130,
Which is 136 annexure K, my lords.
the petitioner has sought for setting aside of the impugned general awards. Why so many general awards?
It belongs to one family only, my lord. It's a different extent of land. For each extent, my lord, the different general award has been passed.
It's sought for setting aside of the general awards. Insofar as their lands are concerned. As follows, you make a table and give. You
Please,
make a
madam.
table. Which petitioner, which general award,
Please, madam.
which survey number.
Please.
You make 3 columns. So, general award, then survey number and petitioner number.
Please, my lord.
The details of the challenge by the petitioners are as follows.
It's the list, my lord.
The petitioners have also sought for consideration of the representations. Annexure H2, H8. You make another table.
For representations, my
Huh?
lord.
And which representation?
Please, my lord.
Which is depicted in the table as below. Next. The petitioner submits that they were ready to accept developed land in lieu of cash compensation. From WP 6457 of 2026. Repeat para 3 in para 4. Learned Counsel Shri HL Pradeep Kumar, appearing for respondent. Para 5. Accordingly, general award and annexures are set aside. Next, the respondent number
2 and 3, my lord.
2 and 3 are directed to consider request of the petitioner for grant of developed land in lieu of cash compensation in terms of government order dated 23/2/2021. Next, Repeat para 7. Substitute the word the general award at annexures dash would stand revived. Last sentence. Repeat para 8. In para 8, substitute the word to respondent number 3. Same respondent number 3. Respondent number 2 and 3. 2 and 3 are directed to consider claim of the petitioner for passing an award in terms of section 29(2) of the Act by way of agreement, and also as regards granting of developed land in lieu of cash compensation. Such consideration to be completed within a period of 4 months from the date of receipt of copy of this order. Accordingly, petition is disposed of.
Number 41, madam. I'm appealing for
41,
fourth list. Next year, A, page 25.
Next year?
Next year, A, page 25.
This is a
No, it is only for general award.
general award.
Yes, no development. Prayer is only for that.
41 is to 4. Private Council Sri P.V. Chandrasekhar accepts notice for respondent 2 and 3. AGF for first respondent. Petitioner is sought for issuance of certiorari right to set aside general award insofar as petitioner's property is concerned, and is further sought for issue of writ in the nature of mandamus to direct respondents to consider case of the petitioner for passing an award in terms of agreement under section 29(2) of the KIAD Act and pass consent award. Repeat para 3 till end from WP 36627 of 25. Annexure and respondent number are same. Accordingly, petition disposed of. Yes, next.
List 123, Sangamesh RB, Ajay Kumarian, A. Chandrachud.
Respondent number 1 and 2. Kindly pass over.
Pass over. It won't reach.
Mullets.
Pass over.
If I may submit, Mullets. I've sought for an interim prayer, Mullets. Interim prayer is, Mullets, to not demolish, Mullets. Mullets, all these petitioners, Mullets, are slum dwellers, Mullets. Mullets, they are all residents of Lingrajpuram slum, Mullets, where, Mullets, they are all allotted, Mullets, the sites by the BDA, Mullets. I produced all those, Mullets, sale deeds, possession certificates, all, Mullets. Mullets, the layout, Mullets, passes close to the track, Mullets, railway track, where now, Mullets, the railway officials, that is, Mullets, respondent number 1 and 2, Mullets, for a outer project, Mullets, that they propose to develop, Mullets, they want to demolish these houses, Mullets. In regards to this, Mullets, I'm seeking, Mullets, an interim order, Mullets.
Kindly pass over. Senior in the
230. 230.
Yes, sir.
Pass over. Where's Ajay Kumar? He also.
Chandrachud.
Answering respondent is Chandrachud.
Yes. Respondent 1.
230.
Yes.
You asked Ajay Kumar also to be present.
I'm sorry, my lords. In serial number 7, my lords, my lords had heard if it is in the fresh matters list, my lords.
We'll see. Yes,
on 28th it is, my lords.
Let us see. Next.
24, Vijay Kumar.
The first matter, 24, I representing for petitioner, filed the writ of Mandamus, considering the representation to the special land acquisition officer not to disperse the compensation amount since there is a dispute of title under the KOV Act is pending before the Tahsildar between the private respondents. In the meantime, they wanted to disperse the compensation to the private respondent number 3 herein. Lord, therefore, this honorable court granted an order of injunction not to disperse the compensation amount since the subject matter of the lease is It is a Karnataka under the Karnataka Village Officers Abolition Act. Lands were regranted to my forefathers. Subsequently, that was challenged by the private respondent before the writ court, my lord, this honorable court. This honorable court, my lord, has remanded the matter to the Tahsildar to fresh consideration of the matter. In the meantime, my lord, before fresh consideration, some of the respondents were died. Against the dead person, order was passed in favorable to the private respondent. That was challenged by me before the district court. District court held that it is a dead order against the nullity in the eye of law without bringing the other LRs who are died. The order was passed. Therefore, District Judge Millard has set aside the Tahsildar order and fresh remanded to the Tahsildar to consider the fresh in accordance with law. That was challenged before this court. The private respondent in a separate 24.1. In the meantime, my lord, when the matter is pending before the Tahsildar, subject land has been acquired by the land acquisition officer for the portion of the land. My lord, that was compensation, my lord, was based on the earlier order passed by the Tahsildar, regrant order. They are claiming right and now they are dispersing the compensation. I filed an objection. Matter is pending before the Tahsildar. A title dispute is there. Unless and until title has to be decided who is the holder of the land, the compensation cannot be dispersed. That was not considered by the land acquisition officer. Therefore, my lord, I filed a writ petition and accordingly both the cases have been clubbed together. One question, my lord, is 24.1, where the learned district judge, my lord, has passed an order remanding to the Tahsildar, while I filed an application for Section 5 of Limitation Act. The Section 5 of Limitation Act from Millard has been not separately passed any detailed order with regard to Section 5 without condoning the delay, directly remanded this is an against the dead person. On the ground that 24.1 serial, Millard, the private respondent challenged that there is a delay, a huge delay is there. The learned district judge is without considering the delay application. On merits passed the order and remanded and entire order was set aside. These are the sum and substance of 24 and 24.1. Now, my lord, my submission before the court, till disposal of the authorities has to decided, first writ petition may kindly be disposed. This is a writ of Mandamus. The land acquisition officer also, KADB also filed objection before the court stating that since the matter is pending before the Tahsildar, let them decide. Till that we will not, because they will issue notice to both the parties who is the holder of the title holder of the land in question has to be adjudicated. That's all my submission.
Second case is decided, madam, it will become first case will impurchase. The second case is decided, first case will become impurchase.
But second case has
All
to.
of the previous litigations.
Lord, there are a series of orders passed by this honorable court. This is not a agriculture land, as my learned friend is contending. These are land converted in 1937 itself. This 188 acres of land was granted to, allotted to respondent number 3 company for setting up a factory for manufacturing of sanitary pipes, my lord. And this, please, my lord, similar matter had come. 28 crores your lordships have directed in another matter. There was one more claimant.
Same company.
No, same company. One more claimant where your lordships have directed them to deposit 28 crores before this honorable court, because it was disbursed to one of such claimant by KADB. Similar situation, my lord, in 1937, the lands are granted to me, which are industrial for industrial purpose. The 2008 order of the Tahsildar categorically identifies that these are converted lands. There are factory activities which are going on. 2008 order gets challenged in 2022 after a delay of 14 years. And Section 5 application is filed. No order is passed by the Honorable District Court. The MEA is allowed. And if your lordship may kindly look at the MEA also, cost title is different. They do not give the correct address of the respondent number 3. They give a wrong address so that the notice doesn't come to me. And conveniently in the writ petition, a correct address is given. Well, this is the kind of petitioner who's come before your lordships now seeking for a stay.
Okay. And what could be done?
Please.
Now, in so far as dispersal of compensation,
please,
to be stated that till there is a finality of the order regarding the regrant order, amount will not be disbursed.
If I may, please.
Now, in so far as 24.1, that will have to be decided on its merits.
My lord, if I may submit, my lord, these two can be independently decided, because they are saying that
My representation before the KEDB has to be considered. Until then, you do not disburse the amount. They have been litigating from 1972, my lord. And who is before your lordships now is only one person. Some 3 people file a MA before the district court, and only one person comes before your lordships now. Out of 3, 1 has remained, and all of them were represented before the Tahsildar by lawyers. The order of 2008 passed by the Honorable by the Tahsildar, my lord, categorically identifies that these are represented by a lawyer. So their argument, it is against dead person, will not survive for consideration.
Okay, so now just no, now if 24 is disposed of,
please,
stating till there is a finality insofar as the interstate dispute regarding rival claimants as regards the regrant order, which which was also pending before the district court and now remitted.
Please.
Yes.
And then we pass some order to that effect. Then we could dispose of 24. Then 24.1 will have to be heard on its merits.
My lord, in case in 24.1, if I succeed, my lord, then 24, which would be pending before KEDB, may not survive for consideration because I'm challenging the district court order itself, which is the basis for the petitioner to come before your lordships now. They're saying my MA has been remitted to Tahsildar. It is pending before Tahsildar, and let the Tahsildar decide. Until then, let the KEDB not disburse the amount. I am before your lordships now challenging the order passed by the Honorable District Judge, wherein the judge allows the order, sets aside the order after 12 years of delay without notice to me.
Correct. So what I was thinking, now 24.1 will have to be heard by a roster judge if it is delinked.
Please.
20.
Yeah. So what I was thinking, subject to that, insofar as 24, we will say unless there is a finality and dispose it off. 24.1 will direct it to be listed before the roster bench and be heard.
Well, my submission would be because if I can take your lordships through the judgments passed by this honorable court.
Right, that will hear, but if you want before this bench, then we'll fix it in first week of June. Another 2 weeks.
One more, sir.
See, if that other bench is relatively more free, then no, I'm just saying
Please,
practically,
please,
practically,
please.
then 24 we can dispose of and protect both interests. 24.1 will relegate it to the roster bench and make an observation. You can move it. Your choice.
Well, my submission would be if 24 is disposed of, then without even any right, my lord, that Tahsildar will never pass an order and representation before KEDB will continue to remain. Because I have been fighting since for 8 decades now.
No, correct. No, suppose 24.1 is disposed.
Please.
Now, whoever is entitled in terms of the order passed in 24.1 will be entitled for compensation, isn't it?
Well, if your lordship may kindly look at the representation or the tenor of the representation. One person goes before KDB and says, you implead, these are the legal representatives, you implead all of them. So such kind of a representation, even KDB it will be difficult for KDB to even decide. So that will also remain pending.
Generally, land acquisition officer has to issue notice to all rival claimants who are necessary parties in the land. Not all are the rival claimants, and they are all legal heirs of the original grantees are pending consideration.
There are
One
no
more,
regrant
even my lord,
applications,
the learned district judge order, if not considered section 5 application, my principal submission, my lord, is that it has to go before the learned district judge only to reconsider whether section limitation take an inquiry. Without inquiry, if conducted, not that order has to go and remand it to district judge. District judge has to adjudicate on section 5 application. Entirety of the district judge order will not go, my lord. Remand, because section 5 is not considered, and without holding inquiry, the order was passed and remanded to the Tahsildar on the principal ground that against the dead person order is passed. Therefore, it is nullity in the eye of law. Even assuming for the sake of argument, the section 5 application is not passed by the learned district judge, the matter, my lord, has to remand to the district judge. District judge has to adjudicate that section 5 application. How many days delay is there? Whether what is the reason stated? It has to that only final conclusion part, my lord, is my submission.
details of the legal representatives are there?
No, my lord,
Details
even
of the
in
legal
it, don't make them a
representatives,
party.
we are only one of the, some of the parties we represented.
If you furnish all the details, then we can remand it back with some direction.
We are representing in the, before the learned district judge, my lord, for three of them, we will furnish, we already furnished and given represented.
No, you have challenged only insofar as your.
Only my concern, our details we have furnished.
Correct.
I have no.
Now, insofar as lands of the petitioner.
Only one land.
25589.
Please.
If they give the details now of who are the legal representatives, then it could be remanded to hear them also and pass whatever orders as per law.
That's only.
Please, because even my connected matter, I'm seeking for setting aside the order of the district judge. So both the matters can then be disposed of on that basis.
And ask him to hear them also. And then consider, since we are reopening it, all other contentions of both parties can be kept aside.
Please, and a time frame may be fixed, my lord, because it's already 8 decades for me.
Let us see.
And Milord, till that Milord, the compensation to be held by
But that will.
Milord, again, the entire matter is that.
He has to decide, isn't it? Re-decide. So then, till then, he has to keep it in abeyance. WP.
Well, let there be a condition on me that in case if they succeed, I'll have to refund the money with interest.
That is not,
can happen,
72 first time I succeeded,
happen.
second time they succeeded.
No, now, anyhow, it will be kept in interest bearing whatever FD. Then let it be decided.
Well, may the council on record wants to take instructions from the client on whether they want this.
You decide.
Please.
You decide what is in their best interest.
My lord, if the time frame is fixed, my lord, at least that will help us.
Correct.
My lord.
We'll say expedite. The reason being, we don't know what is the workload of that officer. So I will make an observation to expedite. After all, what it is, it's a question of law. They can decide without inquiry. I don't want to say
without
that.
inquiry it can't be.
I will leave that. I won't say that. But I'm saying, so it depends on how. I can just say endeavor to dispose it off in light of the WP 25589 of 25 has been filed. Seeking for issuance of a writ of Mandamus to respondent number 2, Special Land Acquisition Officer, to consider the representation dated 28/8/2023 and restrain from paying compensation without considering objections filed by the petitioner on the premise that there is a dispute pending before the Tahsildar, Bangalore North Taluk, in case number so and so. At annexure, in case number so and so, at annexure B, in respect of land in survey number 79, measuring 28 guntas, situated at Chikka Banavara village, Yashwantpura Hopli, Bangalore North Taluk. Full stop. It is the case of the petitioner in this writ petition in WP 25589 of 2025 that petitioners had filed an application.
Petitioners and sisters filed application
Seeking for regrant of the land in question in terms of the Karnataka Village Officers Abolition Act. Full stop. It is a further case that the said claim of the petitioner for regrant is still pending consideration and has not attained finality in light of the learned district judge in MA number
MA 3 of 2022, page 23, Milord.
3 of 22.
Page 23.
In light of order in MA 3 of 22,
Dated.
having allowed the miscellaneous appeal, setting aside order of the Tahsildar in HOA.CR within bracket N 8 of 2004-5 dated 14/11/2008 with a further direction to hold fresh inquiry by giving opportunity to the legal representatives of deceased R3, 4, 5 and 11 within bracket. Reference to respondents is reference to the respondents in MA 3 of 2022, close bracket. Full stop. Next. Writ petition 36521 of 2025 has been filed.
Lord, prayer is at page 23, my lord, seeking to quash the order of the learned district judge, which is at annexure K.
Has been filed seeking for setting aside of the order passed in MA 3 of 2022, whereby miscellaneous appeal filed challenging the order passed in HOA CR N 08-2004-05 came to be allowed with directions to reconsider and pass fresh orders after giving an opportunity to the legal representatives of deceased R3, 4, 5 and 11. Within bracket, reference to respondents are the ranks that respondents hold in MA 3 of 2022. Next, learned counsel for the petitioner would file a memo along with list of legal representatives. Legal representatives. Now this MA has other matters also. Only this
Only one survey
separate
number.
order.
Please, my lord, that's fine.
Yes, my lord, only one survey number.
No, there are two survey numbers which were, which was the subject matter of the Tahsildar order, which has been challenged, my lord.
Correct, but in the MA order.
Please, my lord.
Now,
One order, my lord.
suppose we are to remit it back.
Please.
This MA 3 of 22 is only between you and him.
Yeah, only
You were not, please, my lord. It is.
Huh?
between only, my lord. Between
Because
only.
between us only, my lord.
Between only.
Please. You're ready.
Of the deceased respondents as referred to in the order passed in MA 3 of 2022. Next. Noticing that there is already a direction in MA 3 of 2022 to rehear the matter after issuing notice to the legal representatives of the deceased respondents as mentioned therein, and also noticing that the counsel for petitioner has filed the list of legal representatives of the deceased respondents. Without entering into the merits of the order in MA 3 of 2022, both sides submit that the Tahsildar
My lord, matter has to now go back to the district judge because district judge because
Because
this
he has
MA
not-
order will have to go, my lord.
he has not decided on merits.
On merits, we were not heard, my lord. And also, my lord, it would only be between us and the petitioner. The legal representatives are not before your lordships. Nobody has challenged except the petitioner. So the reopening of the matter for the entirety of all those respondents may not arise, my lord. Because it is
Our
only the
cons-
petitioners who's agreed before your
My
lordships now.
principal submission and ground before the district judge, my lord, was that entire order passed by regrant order passed by Tahsildar was against the dead person. We are not given an opportunity. Therefore, my lord, the learned district judge has remanded to the Tahsildar, since against the dead person without bringing all the LRs who are rival claimants has to be adjudicated. Therefore, district judge, my lord, has remanded the matter.
My lord, that is our submission before your lordships. The legal representatives were also not before the district judge. It is only the petitioner statement. There are other legal representatives. They have not been brought on record by even, at least before your lordships also.
No, correct one. No, if the respondents had died earlier to the proceedings before the Tahsildar.
Yes.
Huh?
Yes.
No, my lord, your lordship
Yeah,
may kindly
yes,
take
my
the
lord,
Tahsildar's order. I will take your
31 may
lordship's
kindly
to
look at, my lord.
Tahsildar's order.
But page 31 may kindly look at, my lord. There,
No, when did they die?
my lord, they died. I have given in my writ petition page 31 date of my first petition may kindly take, my lord. Page 31. Page 31, para 12 may kindly look at, my lord. Page 31, para 12. Respondent number 1 has not taken into consideration. Para 12, my lord. On the death of the respondent number 3, Muniappa, who died on 1/6/2006. Respondent number 4, Rama alias Ramaya, who died.
You're reading at
Page 31, my writ petition, district judge order.
Order?
Para 12 of the order.
2559 25589 of 25, your lordship.
Yes.
Page 31, lordship. Para number 12, lordship. The date of death, my lord, I have given furnished and also referred are respondent number 3, Muniappa, who died on 1/6/2006. Respondent number 4, Rama alias Ramaya, who died on 23/1/2008. Respondent number 5, Muni Venkatappa, who died on 7/10/1995. Without giving notice or order passed by R1, same is challenged before the Tahsildar. But Tahsildar order was 14/11/2008. These all persons died before the Tahsildar order itself is 14/11/2008. But these persons died much earlier to order passed by Tahsildar. Therefore, the entire order has to be set aside by the learned district judge, because not brought the legal heirs, and the order itself is 14/11. As on the date of passing of the order by the learned Tahsildar, my lord, all these persons have died without bringing the order has been favorable to the private respondent and passed. Based on that, they are claiming right over the property in question.
My lord, your lordship may kindly look at Annexure B. What my learned friend is referring to is Annexure C. Annexure B is the order of the Tahsildar, which is at page 19. The petitioner before the MA court were represented there. It is not their case that they were not before the Tahsildar. They were very much before the Tahsildar. Their case is that there were other representatives, legal representatives, who are not brought on record. They are not before either the district court or the Tahsildar. Tahsildar's order at Annexure B, my lord, Chennakeshava Murthy, number 2, then number 7, Muni Krishnappa, who is the petitioner before your lordships, and number 10, G. Papaya. These are the 3 petitioners before the MA court. They say other legal representatives were not brought on record. Now, in Annexure B itself, if your lordship may kindly come to page 20. ಪ್ರತಿವಾದಿ ಹಾಗೂ ಅವರ ವಂಶಸ್ಥರ ಪರವಾಗಿ ವಕೀಲರಾದ ಎಎಂ ವಿಜಯ್ ರವರು ಹಾಜರಾಗಿ ಈ ಕೆಳಕಂಡಂತೆ ಲಿಖಿತ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. So all of them were represented before the Tahsildar in 2008.
No, who they were represented?
They were represented, my lord. That is what the learned
Only
Tahsildar
one
also
Prativadi,
records.
not all
ಪ್ರತಿವಾದಿ
Prativadis.
ಹಾಗೂ ವಂಶಸ್ಥರ ಪರವಾಗಿ ವಕೀಲರಾದ ಶ್ರೀ ಎಎಂ ವಿಜಯ್ ರವರು ಹಾಜರಾಗಿ ಈ ಕೆಳಕಂಡಂತೆ ಲಿಖಿತ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. This is at page 20.
No, sir, just so then let him examine. Let the district judge examine who were dead as on the date of passing the award.
Correct.
And then let him, if the defect could be cured, then they could be made legal representatives heard and disposed of.
That's also correct. Because my submission, my lord, the claim in respect of ours only, we are interested in survey number 79, 28 guntas is concerned. The order of the Tahsildar is 79 as well as 90. They are claiming for both lands. But our claim, my lord, in 78/9 joint both the survey numbers, a common order was passed by the Tahsildar, wherein the not bringing all LRs, it is affecting the rights of even including other survey numbers, because they are obtaining. I am not seeking any protection. Survey number 90 is concerned. I am challenging legal ground that the order itself is nullity in the eye of law against the dead person. How can the order will pass? Then they are claiming they are the owners of the property.
Well, if their case is legal representatives are not brought on record, at least in MA he could have brought the legal representatives on record, my lord. He's only doing forum shopping, my lord. After 12 years, they go back to the district court.
We can send it back to the district court to see who's dead, and under recording is undertaking that he would impede the legal representatives of the petty whoever, and then to decide what and then to decide the MA on its merits.
My lord, it would be because now there are 79 and 90, my lord. His only concern is 79. If your lordships are remanding the entire matter for everybody to come in and participate, then the survey number 90 also gets opened.
No,
Because they're not before your lordships, my
we'll
lord.
pass an order only insofar as survey number 79.
79. 79 and vis-a-vis the petitioner, my lord. If it can be restricted only to the petitioner, because nobody is aggrieved by this order.
Even if it is a dead order, my senior counsel is telling, my lord, is dead order has to be accepted by the learned district judge, and whatever they obtained an order is correct. If the Tahsildar passed again a dead person, we cannot brought to the notice of the court. That is the submission now. It is totally, entirely, it is again, it is a principles of violation of natural justice also, my lord, because dead person order obtained, they are claiming right over the property. What is the district judge, my lord, has done? Remanded to bring all the legal heirs, consider the claim once for all is the order of the district judge, my lord.
If petitioner was so curious for you could have brought other parties also before the district judge.
At least
In my cause title, specifically stated page 24.
You could have brought them on record. He knows who are the LRs.
Because I am not representing. That is my cause title I have stated. They were not brought on record by, though they died in 2008, 2006 and 1999.
You could have filed application to bring on record.
But once the matter remanded by, on the submission made by the Mysore, the private respondent Mysore Stone Pipe Limited, the matter dishonorable court remanded to the Tahsildar.
Just one. Now, your rights are insofar as survey number
79.
Situation only for 79.
So far as that aspect, we send it back. Insofar as the remaining portion of the order, if somebody is agreed, they have to challenge. Next. Without entering into the merits of observations made in MA 3 of 2022, the order in MA 3 of 2022 is set aside, matters remitted for reconsideration insofar as claim of the petitioners herein as regards survey number
79.
Of Chikkabanavara village is concerned. Full stop. Such order is passed, taking note that the contention raised is that the order is an order in nullity as some of the respondents had died. Full stop. So far as survey number 79, as a petitioner is present, counsel for the petitioner submits that the legal representatives of the petitioner herein, who was a respondent in MA, respondent in MA,
Appellant in MA,
appellant in MA, would be brought on record. The learned district judge is to then determine as to whether the contention of the petitioner herein insofar as survey number 79 was vitiated as having been passed against a dead person. Accordingly, the present petition is allowed by setting aside the order in MA 3 of 2022 only insofar as the claims of the parties in respect of survey number 79 of Chikkapanavara village is concerned. Now you are the appellant.
They were the appellant.
We are the appellants.
They did
We
not
are the
bring. That is
appellants.
why we were submitting, my lord, that they could have brought.
Your appeal only abates if you have not brought on record.
They have not brought on record, and he is not the legal.
Milord,
He
I was the respondent in the Tahsildar order. They have to brought on record as a respondent's legal heirs.
No, that's a different matter. But I'm saying now the legal, now even insofar as appellants in MA.
Yes, my lord.
They are alive or dead?
But they dead, we brought to the notice of the court in the cast title, page 24. May kindly look at, my lord. Page 24 of the order. Please kindly look at, my lord. Respondent number 2 after. Muniappa, since died on 1/6/2006, LRs were not brought on record, and Rama alias Rama is so dead, and others we brought on record because I am also not aware who are the exact legal heirs, because I cannot give a false communication to the court, because I know whatever truth, death certificate and date we have given furnished.
Lord, why is he then standing or holding wakalat for the legal?
Allah.
Because he was the respondent before the Tahsildar.
Milord, question was whether the order of the Tahsildar is a arbitrary or perverse is called in question.
That he'll reconsider it.
Yes.
As far as my writ petition
But
is
order as
concerned, my lord, I am seeking for complete setting aside of the order of the district judge. So that will have to be considered.
No, but correct. But then you have to hear the others then.
My lord, he is the contesting respondent here also. I have made him party. He has entered appearance in my writ petition.
So then we'll have to make an observation insofar as the other survey number. Let the district judge examine if as on the date of passing of the order of the Tahsildar, whether the other people were alive or dead, and we can leave it.
No, when survey number 90, nobody is challenging before your lordship, my lord.
No,
The
that's
DC,
correct. That's why.
DJ
Yeah, that's why we are restricting ourselves only to 79.
and your lordships are setting aside only for that limited purpose. I am seeking
Correct.
for setting aside complete, because 90 will still operate. This district judge's order as far as 90 is concerned still operate, will continue to operate, because partially your lordships are setting aside the order. 90 because I am the owner in 90 survey number, that has to go, my lord.
But then that you have to challenge separately. We'll hear you on that.
They have to give opportunity again to that survey number persons, milord.
Well, it is opening Pandora's box before the district judge then, because 90 nobody is before your lordships. Appellant claims to be the legal, not the legal representative. He was the party before the Tahsildar. Then he comes before this court and says
But
he was the party, my lord. He's not a legal
but
representative.
the order can't be against dead person.
Yes, milord.
Well, it is not. No
That's why
documents
question
are
was
produced. No documents are produced to denote that they were dead as on that day.
death certificate produced.
No, then correct. So then I'll ask the district court. I can set it in aside in its entirety.
Please.
Ask the district court to examine whether, in so far as the order of the Tahsildar, which is in appeal in the MA proceeding, to examine whether all parties as contended by the petitioner were alive or dead. If they are alive, then let him hear on merits in his MA. If they are dead, then it may have to go back home. You just look at it, come back next week. Think about it. Now there are two things.
Please, my lord, because
One is it's his MA, isn't it? So if we are setting aside now, insofar as 79, and so with the observation that his legal representatives are being brought on record, and you hear them and you pass fresh orders. That is insofar as 79.
79, my lord.
Now, insofar as the other survey number, we may have to say that the district court may examine whether the order of the Tahsildar was against a dead person. If it is so, then it may reopen that.
But no legal representative was before the district court also, my lord. As far as 79 and 90, both, there are no legal representatives who went before the court and said we were not heard. It is only the parties who were already before the Tahsildar went before the MA court and said, no, no, there were other legal representatives of other people, not even their family. It is other families, is their contention.
No.
My lord, your lordship may kindly pass it over, my lord, if the client wants to
Now,
take that.
insofar as the other survey number,
Please.
now if it's left open for the district judge to see, to examine whether orders passed against a dead person. That's
No,
all.
it is a perverse order, my lord. Obviously, my lord,
Then
by
like,
looking into the
because
order.
they will-
In law, it will not survive, isn't it?
But somebody has to challenge that, my lord. Nobody has challenged.
My lord, if,
And
my
our-
lord, if I am a party, I have to brought to the notice of the court.
Once it's brought to the notice of the court that
With no documents, my lord, without notice to
Death
me,
certificate
12 years
produced.
later,
Well,
it gets-
date of death certificates produced. Date of death brought to the notice of the court.
I'll pass
No documents, my lord, MA order, no documents are produced.
he's saying
Then
that,
they are alive. Let them come before the court.
But I am not before the MA court.
Yes,
just one minute. That's not the question. If you are saying they are dead, you have to give material.
Details, my lord, is concerned. I am challenging in so far my survey. My lord, it is a duty of the council who are on record to the bringing to the notice of the court.
So
Then court has to issue
But death
notice to the
certificate before your
LRs.
lordships, my lord.
On
Let them
what
produce the death certificate before your lordships. also.
What, just one, on what basis the district court can say it's an order in nullity unless some material is
My
before the
lord, one
district
submission, my lord, may kindly, in this lighter way, may kindly take into this matter, my lord. The other side submitting that, my lord, they are the petitioners before the Tahsildar, obtained an order in 2008, making them as a dead persons. Whether the order passed by Tahsildar, who has to be brought to the notice of the court, my lord, in that event? Because I was not appeared and I have no knowledge about that. Therefore, we brought to the notice, my lord.
So far as you are concerned, we have effectively disposed it of.
My lord, that concerned, my lord, only, but the court has to adjudicate whether it is a perverse order or not is concerned. Court has to left open to the court, we decided it, my lord.
Can make an observation.
Yes, my lord.
In the MA, while we set aside the order in its entirety, the court may relook into if material is placed that the other persons are respondent, what order is to be passed.
My lord, at
Suppose
least,
nobody files.
my lord, what is the hesitation for my learned friend to produce before your
My
lordship?
lord, I am not a concern to that, but it is only
the one who
duty to
went
bring
before
to the
the
notice
MA
who are
court.
dead.
Who's went before the MA court?
It means to say, entire, I am
Pass
not.
it over, but you just examine.
Please, ma'am, please.
Yes.
Only as regards the others.
Please.
230. Yes, next.
25, Chidananda Kumar M. Vivekanand. Petitioner.
So far as application for amendment is concerned, my lords, the application could be allowed. My lord, I may be permitted to file statement of objections to the petition.
The petitioner has filed an application on order 6/70 seeking to amend the petition whereby certain modifications are sought insofar as extent of land in various survey numbers is concerned. Instead of taking note of the submission that such error. What is the reason?
Reason, my lord, at the time of filing the writ petition, my lord,
was due to
available records shown that 12 guntas of land has been
was due to bona fide lapse and taking note of the amendments of the affidavit. Application is allowed. IA 1 of 26 is allowed. Necessary amended petition to be filed. Yes.
I'll file my counter, my lords. I require some time.
The statement of objections to be filed by the third respondent within 10 days from today.
Please.
Relist the matter.
Respond number 2 and 3, my lords.
Respondent number 2 and 3 within 10 days from today. Relist the matter. Yes. Yes.
Oblige.
List 2, fresh matter serial number 1, Pradeep Nayak.
Senior counsel is on his legs, my lords. May I request for 2:30, my lords? There is some urgency.
My
lords, I'll take notice. Can be taken up next week, my lords, because they've served copies. My lords, they've challenged the tribunal order, my lords. they have to file an appeal before a division bench challenging the tribunal order. And there are divergent orders, my lords. Few orders are against us, and this order, my lords, is in revenue favor. Now they've challenged validity of the section as well as the tribunal order, my lords. The tribunal order, my lords, I request you, lord, they have to file an appeal before division bench.
You see, let them start, we'll see.
My lord,
It
I'll
requires-
take notice for respondent number 7.
Okay, pass over, we'll see what. Pass over.
Mobilized.
Serial number 2, Mohammed.
My lord, for petition, my lord. But section 120 in detention order was challenged, my lord, along with the confiscation notice, my lord. Without completing the proceedings on section 120, then the 130 proceedings was initiated by the respondent, my lord. My lord,
We heard it last time.
Last time your lordship heard, my lord, we have submitted report also, inspection report also.
Correct.
He is a non-existing person. I request this honorable court,
You give a bank guarantee
5% cash and 75% bank guarantee, my lord.
because of the allegation of non-existing, that's all.
but as per the report itself, they have mentioned that the petitioner place of business, they are running the business, my lord, as per the interim report.
No, go to the report, let us go to the report.
Observation during inspection, my lord.
Yes.
At the time of verification of RTP, the GST registration data, the following
Which
observation.
paragraph you want to read? Which
Second page, my lord. Second
Huh?
page.
Page number?
Observation report, second page, my lord. First paragraph. At the time of obtaining GST, this so and so, registered at the place of business and longitude, latitude, so and so. In second paragraph, my lord, the taxpayers obtained GST registration with effective from 1/7/2025. During the inspection, the property owner is out of station, my lord. For that is the reason he was not able to show that there is running the business. At the time of inspection, he was not in the station, my lord. Property owner is not in the station. Contacted the property owner by phone, and Ritam Kundu was they stated that Ritam Kundu does not conduct any kind of business in the principal place from the date of rental agreement. That is from June 2025.
No, but now your owner only has stated like that. How we can enter into that dispute here? Now the precise question, in case confiscation, then how will they be able to recover if there is such serious allegation?
My lord, the entire amount is 1 crore 46 lakh rupees, my lord. My lord, first thing, second thing, my lord, 129 proceedings has been initiated in the in this
That
regard.
will hear, on merits we'll hear. We can't release it, but we'll hear it on merits. Otherwise, you go before the appellate authority and you expedite your appeal. Let them decide on the merits of it. In terms of the whatever order in appeal, then you can claim your right to.
My lord, they have recorded the statement of the wife of the owner, my lord.
That correct. That we can't enter into that adjudication in these proceedings.
My lord, because in the identical
My lord,
circumstance, my lord,
order
we
is,
are having the EWA, my lord, we are
18/3/2026.
having the EWA bill and we have transit, my lord.
Now we don't know what is correct and what is wrong. If the landlord is giving such a statement, why should we draw a different
My lord,
interpretation?
we are having the bills, my lord, no? Rental bills we are having, my lord.
That I don't know. You file an appeal. We'll direct the authority to expedite hearing of appeal or seek for release of before in the appellate proceedings. Let the before the appellate authority.
Consider, my lord, if they filed an application for release of goods.
Before the appellate
Kindly
authority.
have it on day after tomorrow, my lord, in the fresh list, I will consider.
Relist.
Same stage, my lord.
Relist at same stage on. Yes.
Serial number 3.
If you are going to pay, you advance the case. I'll only adjourn it. If you are going to pay the remaining 25 plus bank guarantee, you mention and advance it. Otherwise, let it come after vacation. If you want, you file an appeal. Yes.
Serial number 3. Ankit Jain.
Yes.
Hello, sir. For the petition, I'm challenging an ex parte impugned order where I was not being served, man. And order has been passed under section 73, which is at page number 18, my lord, annexure A.
State or central?
My lord,
Yes, ma'am.
let them pay 10% of the demand and remanded back, my lord.
What is the demand?
Demand is 1 crore 39 lakhs.
You pay 10%, we'll send it back.
Seek instructions on that, man.
Now find out. We'll send it back. that amount will be subject to whatever adjudication to be made.
Please.
Huh? EGA.
Date of hearing may be fixed, my lord.
No, like he wants to find out. EGA, that HCGP accepts notice for the respondents. Relist the matter in the same stage on 29th.
Yes.
Otherwise, you by 2:30 you're going to say you find out.
Yes, ma'am. 2:30, ma'am.
2:30, pass over.
4. Serial number 4, Nagaraj, MS.
Page 42, Your Lordship. Page 42, Your Lordship.
No, who is answering respondent?
State. Deputy Commissioner of Commercial Taxes.
State commercial tax.
Yes.
Number 1.
Yes.
Page 42, Your Lordship. Quash the impugned order passed by so and so. Hold that the R&D service and software services supplied to the clients outside India by the petitioner for the consideration received in convertible foreign currency satisfies the conditions prescribed and so and hence constitutes export of service. The petitioner, Your Lordship, is an entity that has, Your Lordship, number of export-oriented units. They undertake, Your Lordship, development of software, which are used, Your Lordship, by the companies abroad for developing technologies, Your Lordship, that are used in automobile components, advanced technologies in automobile components. So this has been considered as an export of service, as an information technology service. Now, this has been the practice, Your Lordship. Pre-GST, we have been getting refunds and all that. Post-GST, Your Lordship, there is a prohibition in the export of services rules that says, Your Lordship, that if you undertake a service in respect of goods that are supplied by the recipient, suppose, Your Lordship, I export a computer. The recipient, Your Lordship, finds that there is a problem in the computer. Then he sends it back to me for undertaking certain repairs, Your Lordship, on the computer. Now, that will be a service rendered in respect of the goods that have come to me. So, there is a place of provision of service, Your Lordship, or place of supply of service that says that in these circumstances, it will not be considered as an export because you are doing it here. That rule, Your Lordship, is being applied against me to say that I have employed a number of capital goods. I have purchased it from number of companies. I have employed capital goods. I have used those capital goods, Your Lordship, for developing software and providing the information technology service. That they are using it to say that you have worked on goods and then developed the technology. Therefore, it is not considered as an export. Plainly wrong, Your Lordship, because these are not services rendered in respect of goods that are given by the recipient of goods. Therefore, it will be considered as an export of service. Every other consideration is satisfied.
Now, the service that you render is with respect to what?
This will be, Your Lordship, we develop information technology service or like solutions, etc. Your Lordship, we supply it to a number of companies abroad. They use it, Your Lordship, for using it in the components, automobile components. For example, some of the high-end cars, Your Lordship, will have different types of components that are used, high advanced technologies. So we develop technologies, supply it as an information technology service. And that, Your Lordship, is considered as an export. Now, there is no goods that are supplied by the recipient in respect of which I undertake these goods, undertake these services. Only then that prohibition will apply. Now, this, Your Lordship, is for 1 year. The other years, Your Lordship, are all pending before my lords. And Your Lords can, same interim protection, Your Lordship, can be given copy.
Copies.
There are 4 other writ petitions, Your Lordship, that have been filed. This is the 5th writ petition in the series. You also see the first page, the table. Right from 2017 onwards, Your Lordship, this export is being denied. One to 4, Your Lordship, is for the earlier periods. The 5th one, which is before my lords today, is from 1st April 21 to 31/3/22. And these demands are raised. The earlier writ petitions, Your Lordship, there has been an interim protection given to us. So the same protection can be given, Your Lordship. All these matters can be tagged and heard, Your Lordship.
Yes. Who's the contesting respondent?
I am the statement.
So they're saying interim orders are passed.
Yes.
Identical question in the previous.
Same. And this is raised only in the GST period. Pre-GST, your lordship, considered as an export, refunds granted, no change in the facts, no change in the agreements.
Where is the interim order?
Lords will see. In the second page, your lordship, 24266 of 23. The order dated, your lordship, 8/1/2024. Directed to tag this matter.
But nothing is there in that.
Only this, your lordship.
At least something must be said, isn't it?
I
Giving some direction. Shall we record some submission at least on what ground you are claiming? So now you are contending that the disallowment of export benefit is on the premise that there has been some service on goods returned, which is which you say is not proper, as the service rendered is not in respect of any goods returned.
that are given by the recipient. That's all. That's a.
And senior counsel appearing for the petitioner submits that the question raised in the present matter is identical to the question raised for previous years. With respect to the same petitioner in WP 24877 of 2023 and 24266 of 2023. Full stop. It's submitted that in WP 24266 of 2023 on 8/1/2024, there is a direction to the respondents not to take any precipitative / coercive steps against the petitioner. Full stop. Further submitted as an identical issue is raised in the present matter also. An interim order on same lines may be passed on the ground of parity. Next, senior counsel appearing for the petitioner submits that the effort to disentitle the petitioner from claiming benefits on export cannot be denied unless there was any service with respect to goods returned by the recipient. Full stop. Submitted that in the present case, there has been no return of goods by the recipient, and accordingly, the premise on which export benefit is sought to be denied does not exist. Full stop. In light of the same, and taking note of the interim order passed on 8/1/2024 in WP 24266 of 2023, there would be an interim order in the present matter also, and the respondents are restrained from taking any precipitative steps / coercive action pursuant to the impugned orders.
Annexure A.
Pursuant to Annexure A. Learned HCG accepts notice for the respondents list along with WP number 24877 of 2023 and connected matters.
Maybe only a submission, your lordship, all the 5 can be clapped, and the date could be fixed post vacation. Because this keeps on accumulating, your lordship. Every year this demand is created for us.
And now we've called along with
all the
along with WP numbers.
The 1 to 4, your lordship. This table, your lordship, I have given. There are serial numbers 1, 2, 3, and 4 here.
List along with WP number serial number 1, 2, 3, and 4 of the synopsis.
So there are other issues, your lordship, on which we will file an appeal. There are other issues, your lordship, we will file an appeal. Only this, your lordship, is before my lordship.
Serial number 5.
Great.
Relist in the week commencing from second week.
Appearing for the petitioner, my lord. In this case, 2 adjudication orders have been passed for the same assessment year, my lord. For assessment year 1920, which is at annexure D and E, my lord. At page number 22 is annexure D, my lord. And annexure E is at page 27, my lord. Similar matters have already been reminded by the coordinate bench, my lord, which is at annexure G at page 41, my lord.
My lord, page number 24 may be kindly prepared, my lord. Last para, my lord. Para number 5, my lord, last.
Page 30.
Page number 24, my lord. Hence, a pre-intimation of in form GST TRC 01A was issued on 22/3/2024.
Page 34.
24, my lord. 24. And the same was served.
Which
to the
paragraph? Which paragraph?
Para number 5, last line, my lord.
Yes.
And served through this office mail to the so and so, which is the registered email ID GST registration. Next para, my lord. Para number 6. The taxable person has not filed any objection nor discharged the tax liability. So and so. It's a ex parte. May be remanded, my lord.
But he has been served according to you.
Served, notice is served, email address, portal, and registered post also sent. That para number 5, my lord, where I have read pre-intimation, then served through taxable through registered post, and also served through email ID and GST portal. 3 times service is done.
My lord, it can be remanded back to the stage of post show cause notice, my lord. We can file a reply, my lord.
Madam, Ade submission.
No, you have not received according to you.
Yes, my lord.
The present petition has been filed. Seeking for setting aside of the order of adjudication at annexure D passed under section 73. Full stop. Petitioner has also sought for setting aside of the notice of demand at annexure F. Full stop. The case of the petitioner that the order in original is an ex parte order. Insofar as petitioner has not filed any objection to the show cause notice nor discharge tax liability as asserted by the revenue. It's further submitted that the petitioner was not served. However, learned CGP would point out to observations made at para 5 of the impugned order and submits the petitioner had been served by way of mail to the registered email ID, and hence non-participation is due to the lapse on the part of the petitioner. Next, petitioner submits that even otherwise, as the order is passed without benefit of reply, matter may be remitted for fresh consideration to the stage of reply to show cause notice. Next, peruse the order in original. It is noticed that the authority has observed that there was a short declaration of outward tax and short payment of tax. Next, the authority has further adjudicated the case on the basis of material available and proceeded to pass an order. The discrepancy as alleged is a factual aspect which may require a response of the petitioner on its merits. Taking note of assertion of the petitioner that they have material to demonstrate that the alleged discrepancy in the show cause notice does not exist, it would be appropriate to set aside the order at annexure D and remit the matter to the stage of reply to show cause notice. Full stop. Accordingly, the order at annexure D is set aside. Matter is remitted to respondent number.
Respondent 3, my lord, the commercial tax officer.
3 without further notice. Respondent number 3 for reconsideration from the stage of reply to show cause notice. The petitioner to mark his presence before respondent number 3 without further notice on
18th of May.
The CGP accepts notice to the respondent. Petition is disposed of in terms of the above. Petitioner is at liberty to make out reply to show cause notice. All contentions are kept open.
6, Ashok, serial number 6.
Much obliged, my lord.
My lord, this is an ex parte order. It's a state GST.
My lord, in this case, my lord, kindly be turned into page number 66, my lord. Para number 8, my lord, if your lordship permit me, I will read, my lord. In response to the show cause notice, taxable person has not filed any reply. Hence, a reminder notice along with personal hearing dated 16/5/2024 was issued and made available in the GST portal. However, taxpayer has neither filed the reply nor utilized the personal hearing opportunity provided. The reason from same and best known to taxpayer. So it is ex parte, my lord, but however, demand is up to 18 lakh. I request this honorable court, let them pay 10% or else at least cost adru katli anta to the State Bar Council Advocate Welfare Fund.
My lord, what happened here, they were unaware of the order passed. My lords may go to page 69. It's an email received from my customer, Godrej Properties.
No, correct. Now they're not seriously objecting. They're saying you pay 10% of the demand of tax.
Yeah.
That would be subject to outcome of the adjudication. I will send it back. The petitioner, HCGP accepts notice for respondents 1 and 2. Notice to the third respondent is dispensed with. Now, what is your reason for not replying?
No, I was not aware of the order being passed. It's only on, that's why I request you to go page 69. It's an email which I have received from the customer.
My lord, it is a GST portal, my lord. It is bound. They cannot claim that ignorance of law before this honorable court.
It's a human error. It's an inherent human error. I'm not saying that I have done it intentionally. Because another reason that I was not noticing that an order has been passed. That page 69 is the email which I have received from a customer where he has put on hold on whatever dues he has to pay me. Against page 71 is the third party recovery notice.
No. What is the correct? What is the allegation now? Mismatch, is it?
Yeah, it's a 3B2A mismatch.
Paragraph?
I'll just put.
Excess availment of ITC.
Yeah, page 4. Sorry, page 10, para 4.
Yes. The petitioner.
So, my lord, just one mention. So, against a demand of 8,71,000 recovery notice, my customer has put a hold on 1 crore 39 lakhs. So, I'm finding it very difficult to run my business.
The petitioner. So your customer is more loyal to them than to you.
It appears to.
The petitioner has challenged the order of adjudication at annexure D and the summary order at annexure D1 as well as the recovery proceedings initiated pursuant to the order of adjudication. It is the case of the petitioner that the order of adjudication at annexure D is an ex parte order that has been passed without benefit of any reply to the show cause notice. Further submitted that the authorities have adjudicated on the premise that there is an excess claim of ITC in GSTR 3B than that which was available in GSTR 2A. It submitted that such discrepancy as noticed by the authority is factual in nature, and if an opportunity is granted, petitioner would meet grounds made out in the show cause notice. Full stop. Next, it submitted that due to bona fide lapse, petitioner was not able to make out a reply to the said show cause notice. Next, and HCGP would submit that once intimation was put out in the portal, petitioner was bound to have taken note of it. Next, peruse the order of adjudication at Annexure D. Authorities proceed on the premise of there being discrepancy between the ITC as claimed in GSTR 3B vis-a-vis declarations in GSTR 2A. Full stop. The said aspect as rightly is essentially factual in nature and requires to be demonstrated by the petitioner. Full stop. In light of adjudication being completed without benefit of exercise of attempted reconciliation, it would be appropriate to set aside the impugned order by putting the petitioner on terms. Next, taking note of the assertion of the petitioner that they would reconcile the alleged discrepancies in GSTR 3B vis-a-vis declarations in GSTR 2A. The order at Annexure D is set aside. The petitioner is put on terms and required to deposit 10% of the tax demand. Full stop. Next, petitioner to appear before respondent number 2 without further notice on 18th of May. Next, consequent to the setting aside of the order of adjudication, the recovery proceedings pursuant to the impugned order are also required to be set aside. All contentions are kept open.
Well, not 10%.
That I've ordered. I've ordered that 10% to be paid.
Of the demand may be deposited before the assessing.
Such deposit as referred to above is to be made before the matter is before the next date, before the date fixed. All contentions are kept open. There only, why can't you have some kind of mechanism in deserving cases?
My lord, it is a tax statute itself has a limitation, my lord.
Yes, next.
That's why.
Serial number 7, K. Govindra Kamath.
But actually, your lordship is correct. As per limitation notification is concerned, we are seeking extension through GST Council. Why can't this appeal remedy should be extended? None of the petitioner advocates raised, I think petitioners did rise before the GST Council.
Yes. Yes.
Your Lordship, in serial number 7, I'm appearing for the petitioner. Your Lordship, the petitioner has challenged an order passed under section 73. It's an ex parte order, Your Lordship, at Annexure A, page number 17.
Who is answering respondent? State.
State, Your Lordship. Yes, state, Your Lordship.
Number 19, my lord.
Your Lordship, may I just be permitted to make submissions, Your Lordship. In this case, the order was an ex parte order. The petitioner had not benefit of this appearing in these matters. In 2025, the petitioner learnt about this order, Your Lordship. At Annexure D, page number 30, the petitioner's counsel writes a letter to the respondent stating that why the demand which is raised in the order that should be dropped. And in fact, as against the demand of 6 lakhs, more than 9 lakhs has been paid by the petitioner. So accordingly, this letter is submitted and the petitioner submits that the earlier auditor who was engaged, he is no longer there. And because of the change in auditor, they were not aware about these proceedings. So as such, the petitioner was of the belief that these proceedings are dropped. But subsequently, the petitioner receives a recovery notice, Your Lordship, and his bank account is attached. That is at Annexure E, page number 33, typed copy, Your Lordship. Your Lordship, this is a genuine case where because of the change in auditor and the petitioner also had COVID and he's a sole breadwinner of his family, Your Lordship. If one opportunity may be given, the petitioner can also demonstrate that how in fact more than the demand the tax is paid. He has in fact reversed his income tax ITC input tax credit, Your Lordship, which he has mentioned in his letter dated 27th May 2025, which is at page number 30, typed copy page 31, Your Lordship.
Where is that reversal?
Your Lordship, page number 31, the typed copy of Annexure D.
Yes.
The letter dated, the email dated 27th May 2025. With reference to the order of adjudication dated 21/12/2023, demand with respect to wrongly avail of RCM as ITC without payment of so and so. Since our GST return was filed by an auditor, we are not aware of this notice or demand. After the change of auditor, we came to know about this notice. Now, in July 2017, we give an explanation, Your Lordship. In that, 2 columns are mentioned. The first column, first row, Your Lordship. Subsequently, we have reversed ITC in GSTR 3B as below, and we give the computation that how in 3 different months, September, February, and March 2020, we have reversed the ITC. Then we also place on record how through ITC we have in fact paid the subsequent dues as well, Your Lordship, which is totally of about 3,53,000. And the total calculation computation is given in the table below. And then we also make a request, Your Lordship, that since we were not aware about this notice or demand, due to negligence of the previous auditor, we request your good self to guide us to close this issue and close the demand in the proper way. Your Lordship, although they should have approached this honorable court at that point in time, but the petitioner being a small-time trader, Your Lordship, has just made this request to the respondent, and likewise the respondent has not given any reply to this saying that it cannot be considered or otherwise. So the petitioner was of the belief that these proceedings would be dropped. And only when the recovery notice, his bank account has been attached at Annexure E, page number 32, the typed copies at page number 33.
Yes.
My lord, this is a ex parte order, my lord. Page number 19 may be turned into para 5, my lord. In that para 5, last para, my lord. If your lordship permit, the show cause notice was issued and served by making it available on the common GST portal on 16/9/2023. As per the provisions, section 169 of the GST Act, an opportunity was provided to show cause within 30 days from the date of receipt of the notice as to why the tax and interest should not be determined. Further, the taxable person was also intimated to avail the personal hearing to submit the objections explanations if needed. Next, para 6, my lord. In response to the show cause notice, even though the sufficient opportunity has been given to the taxpayer, has neither filed any reply nor paid the ascertained above liabilities. My lord, I request, this is total, my lord, amounting to 16 lakh, my lord, demand. I request before this honorable.
But the Annexure B, they say they have paid. Annexure B.
My lord, they have not responded before the.
No, that is correct.
Notice, my
No,
lord.
in terms of this 10%, in terms of deposit, 10%.
So that is what, my lord, liability discrepancy when order is passed, subsequently they have made, my lord. They are telling we have paid, but they have not in time. They have not came before the appropriate forum and came before the submission made. That is the ex parte order, my lord. After order, they are supposed to go first appeal and make take the clarification, my lord. They have not done. Or else even rectification, they would have filed a rectification. If they have filed rectification application, they can file, my lord. if they have paid also. They have not done anything. They directly approached before this honorable court. However, this personal opportunity, ex parte order is there. We have provided sufficient opportunity, notice is served, due process of law is taken. Hence, I request before this honorable court, 16 lakh demand is there. Let them at least pay cost, because they approached 2023 order, my lord. Let them pay a minimum cost and remanded back matter before the assessing officer, and let the adjudication take place.
Then HCGP
A
accepts.
nominal cost can be imposed, Your Lordship.
Then HCGP accepts notice for the respondent. The petitioner is called in question the correctness of the order of adjudication. Full stop. The petitioner submits that they had not made out a reply to the show cause notice due to bona fide reasons. And in light of no response having been made, authority has adjudicated the case on the basis of material available with it. Full stop. It's further submitted that dispute relates to ineligible input tax credit claimed, and discrepancy relates to GSTR 3B hyphen 4 within bracket A 3 vis-a-vis declaration in GSTR 3B within bracket 3.1 within bracket D close bracket. ಇದು page 18 ಅಲ್ಲಿ. In light of it is submitted that in light of the alleged discrepancy which is factual in nature, the petitioner have granted an opportunity would meet the discrepancies as made out in the show cause notice, and accordingly request is made for setting aside of the impugned order. Next, and HCGP submits that orders are to be set aside is on 21/12/2023, and the petitioners have approached after undue delay. Next, we peruse the order at annexure A. The premise on the basis of which the authorities have proceeded is that there is a discrepancy insofar as ITC claimed. Said aspect is factual in nature, and noticing that the authority has completed adjudication without having the benefit of a reply to the show cause notice, and in light of the assertion of the petitioner, it would be appropriate to set aside order at annexure A while putting the petition on terms. Next, accordingly, order at annexure A is set aside. Matter is remitted to the respondent for reconsideration by reconsideration. Full stop. Petitioner is permitted to make out reply to show cause notice, and thereafter the respondent authority may proceed to complete adjudication as is permissible in law. Next, petitioner to appear before the respondent without further notice on
18th of May.
19th. Yes. 19th. Yes, Your Lord.
Petitioner to pay costs. Petitioner to pay costs of rupees 15,000 to so and so.
Your Lordship, may I request that any nominal cost may be imposed, Your Lordship. 10%. 10% of 6 lakhs, he would have to pay 60,000, Your Lordship. The tax
10,000,
value is
10.
Because it is 2023 order, my lord.
10,000.
Your Lordship, may I request that the respondent be directed to withdraw the bank attachment, Your Lordship.
In light of setting
That will go automatically.
In light of setting aside of the order of adjudication, recovery proceedings pursuant to which have been initiated are set aside.
Obliged.
8/7/1.
Yeah, pray for the petitioner in this matters, man.
Yes.
My lord, it's a matter where the audit officer and the adjudicating officer are one in the same, my lord.
My lord, on this ground, they cannot seek the stay, my lord.
No, on merits you make out. Apart from that, that we'll see.
Lords,
Apart from that, you make out your case on.
Lords, one submission is that the notification 9 and notification number 56, my lords, is pending consideration before the Honorable Supreme Court, my lords. In that submission, my lords, request for an interim order to stay, my lords. I have not been intimated of the order in original nor the I've only got to know about the order of adjudication through my Garnishee order, my lords. My customer has come to me and he's come before me and saying that such an order is there against me. I'm not able to make payments, my lords. In the year 2026 itself, I've been intimated, my lords.
My lord, kindly
Discrepancy
be turned into page
between
number 40, my lord.
STR 3B and,
my lords,
what is the premise? ITC, is it?
Yes, my lord. Difference of 6%, my lords. Difference of 6%, my lords.
So belated availment.
My lords, the Garnishee order has been intimated to me in the month of February 2026, my lords. Instantly, I moved this writ petition and I'm seeking relief, my lords.
No, just 1 minute. You are claiming your ITC claimed part of it was rejected as a belated claim. Huh? Page 39.
My lords, the order is ex parte, my lords. I couldn't produce anything to show my contentions, my lords.
Either audit, my lord, or adjudication. He has never appeared. I will demonstrate page number 40, my lord. Kindly, if your lordship permit, I will read, my lord.
You want to go back, we can remand it.
Lords?
You want to go back, we can remand
Supposed to go back, madam. It's supposed to go back. He can take all contentions. Limitation, same adjudication officer, the consent remedy will be available to him. But 10%, anyhow, small
10%
amount,
of?
cost let him pay, my lord.
Huh?
Lords,
Small
one
amount,
submission,
let him,
my lords.
if he has a problem.
Lords, as mentioned, my lords, the audit officer and adjudicating officer.
That we'll see.
My lords,
Why hold it here now? Why keep it? If on merits you are able to satisfy their ends the matter, this contention, I'll keep it open.
My lords, in the meanwhile, my lords, till I seek instructions from the petitioner, my lords.
No, what for? Why? What instruction you want if we are sending it back?
My lords, I'll just seek instructions.
No instruction. I don't need your instructions in that. I'm sending it back. Half the battle is won. Remaining, you leave it. All other contentions, I'll keep it open. You say court has ordered, don't look at anybody. That's all. What is that? I'm giving you relief, no? You take it, we'll see.
My lords, the matter is
Tomorrow
pending
may
before-
never come. You have to clutch whenever it is there. Matter may not reach. I'm telling you that is a difficulty. Matter may not reach. Instead of being left high and dry, you go back, you raise it. Your contention regarding audit will keep it open. You may raise it in the second round if you suffer an adverse order.
My lords, nominal cost may be imposed in that.
Yes. The petitioner has challenged the order of adjudication, which is order in original at annexure A. This petitioner also sought to assert validity of the show cause notice. Full stop. Petitioner also sought for certain allied reliefs as well. Petitioner submits that proceedings are vitiated as the authority which has conducted the audit is the authority which has also completed the has passed the adjudication order. Full stop. It's further submitted that the petitioner could not make out reply to show cause notice due to bona fide reason. Full stop. It submitted that the rejection of the respondent regarding ITC claimed could be demonstrated if opportunity is granted to the petitioner after setting aside the impugned order of adjudication. Next, peruse the order at annexure A. The authority has noticed the audit observations regarding discrepancy in the ITC claimed. There's also the short declaration of output tax in GSTR 3B. Next, it is noticed that though show cause notice was served, no
Through
reply
RPD only is served, my lord.
was served.
Even audit report also served through RPD.
Was
Duly
served.
served, my lord.
It is noticed that the authority has observed that though show cause notice was served, however, no reply has been made by the respondents, by the petitioner, and the petitioner has failed to produce RA bills, R capital A capital bills, comma, work order, comma, estimates for Schedule B, comma, agreement copy, comma, profit and loss accounts, comma, balance sheet, comma, purchase bills and statement, and bank statements. Full stop. Accordingly, the authority, in the absence of such material, has completed the adjudication proceedings. Full stop. Learned counsel for petitioner submits that if opportunity is granted, they would meet the grounds made out in the show cause notice. Next, noticing that adjudication has recorded factual findings and the authority did not have benefit of reply to the show cause notice on its merits, it would be appropriate to afford an opportunity to the petitioner by remitting the matter back for reconsideration.
One submission. My lords, in the order of adjudication, my lords, they make a reference to the assignment dated 6/3/2024, my lords. I maybe provided a copy of the same, my lords. I can use it in my show cause notice.
He can claim, my lord. He can make an application, he can claim. It is not
Accordingly-
required from this honorable court to make
accordingly,
observation.
The
He
order,
has fundamental right.
order is impugned order at annexure A is set aside. Matter is remitted for reconsideration. The to respondent number,
My lords, it may be directed show cause notice stage back to respondent number 2, my lords.
to respondent number 2. Petitioners permitted to make out reply to the show cause notice. All contentions and merits are given. All contentions and merits are kept open, including the contention regarding audit officer and adjudicating officer being one and the same. Next, petitioner to appear before respondent number 2 without further notice on 20th of May. Petitioner to pay cost of rupees 10,000 to so and so.
Cost.
10,000.
Yes.
Serial number 9.
With respect to cost, my lords.
10,000.
Serial number 9. Jeevan Niraleke, Tirumali.
I am appearing online.
Assessment year 15-16. The limitation expired on 31/3/22 to reopen the Malod. Number reassessment notice is issued on 5/4/22. That's one ground. Malod, it is barred by limitation.
148.
148. And Malod, second ground is that Malod, jurisdictional assessing officer initiates the proceedings. Subsequently, assessment order, Malod, the stage of that it migrates to faceless. That's two grounds, Malod, I am pressing for.
Yes.
My lord, the notice has been issued by the Panvel officer at Mumbai, Maharashtra, Panvel at page 38. So the question which arises is whether this honorable court has got jurisdiction. And for the knowledge of my learned friend, I would cite a judgment. That is, first thing is I don't have I don't have authorization to appear on behalf of the assessing officer who is at Panvel. And the second thing is even the local office has not yet given me authorization. The third thing is that there is a Supreme Court judgment on this issue, which my learned friend may kindly have a look and then get back. That is CIT versus ABC Papers Limited at 2022 9 SCC 1. Which says that the jurisdiction falls at the place where the assessing officer is situated, even if the file is transferred under section 127. So these questions, in fact, Sammati was also raising objection regarding passing orders of interim orders in respect of assessment orders passed outside the state. And this is also one of the cases. So I would suggest that my learned friend look into this judgment and get back, because in the meantime, if I get authorization, I will be able to argue fully.
My lord, page number 57, your lordship, my kindness. 57. No doubt, my lord, for the assessment year 15-16, the assessing officer at Panvel had a jurisdiction. But at the time of, my lord, the reopening in the year 2022, I had shifted my residence, my lord. I have lordship, may I kindly see, my lord. These are the returns which I filed in response to 148, showing Bangalore address. My PAN was shifted to Bangalore, my lord, in the year 2024. Even before that, my lord, I have shown my address as in Bangalore. That's one. My lord, the assessment order is being enforced in Bangalore by attaching the, my lord, bank accounts, my lord, which are situated in Bangalore. Lord, 57, 58, 59.
Now this return that you have filed.
Yes, my lord.
142.
139, my lord.
139.
My lord, first return 57 for the assessment year 15-16. 148 was issued on 5/4/22. In response to that, my lord, I have filed my return. That is on 23/10/23. My lord, 23/10 October 23. That is I was in Bangalore. So I filed a return from here.
Page 40 may be seen.
And my lord, 40 assessment order.
Assessment order where it is written as ITR filed, and the reply is also filed for one of the notices.
And the assessment order is being enforced here. Demand is being enforced in Bangalore.
Correct, but the return you have filed to what, to Panvel?
Yes, from here. It's online, my lord.
No, but jurisdiction now, because that says that the assessing authority must be within the jurisdiction of the court. You want to find out?
Milords, I got a judgment directly on that point, Milords. Let him, which says that Supreme Court says that in the context of IT-80 orders, it is clearly held that the jurisdiction lies to the High Court, which has where the assessing officer is situated, even if the file has been transferred under section Rule 127 of the Income Tax.
Part of the cause of action has arisen within of this honorable court, because it is being enforced here.
Because in this case, the file was not transferred. Even now, I doubt whether it is transferred.
Transferred in the year 24, my lords.
24, okay, but during
Transferred
that
in
year,
the
it was not transferred.
now at present, my lord, the PAN lies in the jurisdiction of the Bangalore.
No, but that judgment appears to say that till it is transferred, I think wherever the assessing authority, then only that court has used.
That's the court has to exercise jurisdiction, and this is for the sake of consistency.
We'll have it tomorrow. You produce that. Have a look at it later.
Please, tomorrow, Your Worship.
Current counsel Tirumadish accepts notice for the respondent. Release the matter in same stage tomorrow.
10, Venkatesh G.
Connection A1, page 30.
Page
30, 30. Adjudication order. In this case, my lord, I have filed my reply to the show cause notice, but I could not appear for the personal hearing. The matter my lords have heard on 2 occasions earlier, where I was traveling during that time. And on the last occasion, instructions were sought in respect of the endorsement dated 11th November, my lord, which is at page 38.
Now you are denying that.
Yes, my lord. And
Now
then
just
my-
you were asked to verify that 11/11/2025
Yes, ma'am.
some endorsement is issued affording him an opportunity. That is referred to
At page 38.
in your order. Now they are denying that 11/11/2025. That you have to verify. Last time I adjourned it. You verify whether on 11/11/2025 opportunity of the endorsement is issued by you, fixing date of personal hearing. He's denying it. You just find out from your
But however, in page number 35, my lord,
page 30.
35, my lord,
Huh.
it's clarified, my lord, it's the ex parte order.
Huh. So we'll send it back.
Remand it back, my lord. Let them deposit 10% of the demand, my lord.
My lord, on that, my instructions are like this, my lord. Already they
If
have
not, if
recovered.
they want to go, let them pay cost and go, my lord. They have an inconvenience.
Certain amounts have already been recovered so far.
Okay.
So
Page number
may be
35,
restricted to
if your
that amount,
lordship
my lord.
permit me, I will read, my lord.
Whatever has been recovered so far, it may be restricted to that.
So pay some nominal cost and we'll send it back.
But already they have recovered substantial amount.
That's okay. There is some lapse on your side also.
No, my lord. In this case, it is a case where I was
That-
traveling, I couldn't have foreseen that they
Our
will issue
nominal
the
cost, let them
notice.
serve to the society, not to us, not to court or not to anyone,
The
department also.
petitioner. It's out for setting aside the order of adjudication as also the summary of the order passed by respondent for the tax period April 2021 to March 2022. Petitioner sought for certain allied reliefs as well, including setting aside of notice to third person. Next. Petitioner submits that the order of adjudication has been passed on premise of wrong availment and utilization of ITC, comma, excess availment of ITC, and short declaration of turnover under other grounds. It's submitted that though the taxpayer had filed a reply, however, thereafter, opportunity of personal hearing was not afforded. It's submitted that if the matter is remitted to the stage of affording opportunity of personal hearing.
Yes, my lord. And also filing of further documents as
To
pointed out.
submit, my lord, page number 41, para 2, my lord, where he has to require document, he has to supposed to produce
Yes.
ourself ascertained. The taxpayer has merely asserted that the receipt represents loans and advances. However, no documents such as loan agreements, board resolutions, confirmation of parties, partner, capital account extracts, repayment schedules,
Yes,
bank loan
in the
correspondence,
beginning.
or any ledger
Yes, yes.
substantiating the existence. They have to give these details.
The petitioner would place before the authority necessary records that would enable the authority to be satisfied regarding response of the petitioner. Full stop.
And also
I'll
additional
continue.
submissions.
I'll continue at 2:30.
Much of.
2:30. 2:30.
Actually, endorsement ಇದೆ.
ಕೇಳಿಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಖಂಡಿತವಾಗ್ಲೂ ಇಲ್ಲ
ಯಾಕೆ ಗೊತ್ತಾ?
Court officer.
ಇನ್ನೊಂದು 5 ವೇಟ್ ಮಾಡಿ. ಇನ್ಸಿಡೆಂಟ್ ಒಂದು GH ಅಲ್ವಾ? ಇಲ್ಲೇ ಇದೆ ನೋಡಿ ಫೈಲ್. ಕರಿತೀವಿ ಅಲ್ಲ, ಪಾಸ್ವರ್ಡ್ ತಕ್ಷಣ ತಗೋತೀವಿ. ಅದಾದ್ಮೇಲೆ 4 ಇದೆ. ಸರ್ವಿಸ್ ಟ್ಯಾಕ್ಸ್ ಇಲ್ವಲ್ಲ ಸರ್? ಪಾಸ್ ಅವರ್ ತರ್ಸಿನ್ ಸರ್. ಪಾಸ್ ಅವರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅರ್ಜೆಂಟ್ ಇದೆಯಾ? 12 ಎಷ್ಟು 3 ಮಾಡಿ. ಹನ್ನೆರಡು 54 ಇನ್ನೊಂದು ಟ್ವೆಂಟಿ-4 ಹಾಕೊಂಡ್ಬಿಡೋದು. ಮಾಡಿ ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳೋದು ಲಿಸ್ಟ್ ಮಾಡಿ ಟೈಪ್ ಮಾಡಿದ್ದು. ಫಸ್ಟ್ ಪಾಸ್ವರ್ಡ್ ಟೈಪಿಂಗ್ ಯಾವುದು ಅದೊಂದು ಅಲ್ಲೇ ಇರಲಿ, ಅದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಮುಂದಕ್ಕೆ. ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ಬಿಡ್ಲಿ 10 ಆದ್ಮೇಲೆ ಮುಂದೆ 10 ಎಷ್ಟು ಟು 10 ಅದು ನಡೀತಾ ಇದೆ. ಅರ್ಧ ಆಗಿದೆ, ಅರ್ಧ ಕೊಡ್ತೀನಿ, ಉಳಿದಿದ್ದು ಕಂಟಿನ್ಯೂ ಇಷ್ಟು ಟು 10 ಕರಿತೀನಿ ಸರ್. ನಾನು
ಮಂಜು ಪಾಸ್ವರ್ಡ್ ಕರಿತೀಯಾ? 24 ಪಾಸ್ವರ್ಡ್
ಒಂದು ಕಂಟಿನ್ಯೂಷನ್.
Lord, if you can make a mention, list 3 serial number 1, so that section 9 petition, the filing is going to memo.
Tribunal has been constituted, my lord. They are seeking for a disposal of this petition by relegating parties to the tribunal for their section 17 measures. Till then, whatever interim protection was granted by this court will continue.
Well, it's still the tribunal decides, my lord.
Just hold. ಯಾವ್ದು?
List 3 serial number 1.
List 3 serial number 1.
Yes.
CPI number 2.
List 3 serial number 1.
What's the serial number? List 3.
Number 14.
So they have no file the appeal, they file the appeal of it.
Petition against the show cause notice, when the writ petition was pending, and the OI, by the time we got the interim order, I think it may have been.
The present petition.
The OI has been stayed.
OI.
So these issues are on.
IDL.
Correct. It's 3/18/37. 14.
Has been filed seeking for grant of interim measures till the arbitral award
230
is passed. In the interregnum, both parties have filed a joint memo and request
Suppose you say that
the petition itself be disposed of recording terms of the joint. The joint memo reads as hereunder. Next.
You can take it at 4:30.
While it is to be noticed that this court has passed an interim order
We have informed the other side.
on
15/6/2023.
15/6/2023. Next. That interim order has been extended. Next. It's further submitted that it's further submitted
Same, it can be tagged.
that in terms of the joint memo, the
So this can also.
liberty is reserved to the petitioner to file appropriate application under section 17 of the Act before the tribunal for grant of interim relief.
The main matter is connected.
It's further as noticed that the joint memo, that in terms of the joint memo, both parties have agreed that the ad interim order dated 15/6/23 would maybe extended
So we can ask him to post it.
extended till consideration and disposal of the petitioner's application for interim relief as referred to, that is to be moved in terms of the observation at para 3 of the joint memo. Next, in light of the above, petition is disposed of. The interim order passed on 15/6/23 would continue to operate till necessary motion is made and orders passed in terms of observation made at para 3 of the joint memo as regards the application of the petitioner for interim relief. All contentions on merits are kept open. Office to return certified copies / originals if any, after retaining photostat copies for reference.
Just one clarification, that motion should be made on or before 4th of June 2026. That may also be recorded, my lord.
Comes from para 3,
In order to avoid any ambiguity, it's there in para 3. My only request is that it may be explicitly recorded, my lord, that such a motion should be made on or before 4th of June 2026. That's the next date of sitting of the tribunal.
Needless to state, observation at para 3 regarding motion to be made by the petitioner seeking interim
This is a
relief
matter, no? Once
is
it's
to be made on or before 4/6/2026 as found at para 3.
My lords, list for serial number 77. I request for it to be taken up at the end of the list, my lord. It's a very short point that survives for consideration. The petitioner's claim of over 8 crores is coming in the way of us sanctioning a residential layout plot of around 450 odd acres, my lords. So it's a short point, my lords. My lords may hear it and dispose it at the outset. It's a fairly straightforward matter.
Let us see. Which matter?
List for serial number 77, my lords, and the connected matter.
Stayed and posted that. Can we ask for it to be taken up today?
If it has to be heard on merits, no possibility today.
We'll take a chance, my lords, if it may be
Let
posted.
us see, I'll mark it.
Serial number 28 in this court, Vivek's colleague is there, it's covered by this judgment, your lordship's judgment, where preliminary notification is passed, no final notification, seeking quashing of preliminary notification.
Kottiri, let us see. Mark
petition, right?
Mark it.
The
Yes.
lordship's kind permission.
list number 4, serial number 2, my lord.
Joint memo.
Yes, my lord.
Give it.
My lord, there are 3 cases.
Ah.
So, my lord, in one case is petitioner has signed, but 2, I mean, so he, my lord, he said he may need time for a day or so. So one, my lord, where he has already signed, petitioner has signed, maybe dispose of, and the other 2 may be kept tomorrow. So he
No, we'll have it tomorrow only. Once and for all, we'll finish it. Once and for all, we'll finish it. We'll have it tomorrow. Huh?
Please.
Release tomorrow.
Anyhow, my lord, I have signed in the memo.
Now it is your satisfaction. If you feel that there is no difference between you and your client will fall in line, we'll record it and we can complete it. Why insist on party signature? Unless he feels that there is some issue.
One of the petition I already signed.
No, correct. It's up to you. If you are confident and there is no communication gap between you and your petitioner, we'll dispose it of.
Confident, my lord, because they are.
Then we'll dispose
My
it.
lord, I mean, proper, my lord, recording should be there tomorrow, my lord. I don't want, my lord, after.
Then I'll have it tomorrow.
Yes, my lord. After doing
Release
all the
tomorrow.
efforts.
Amended petition is taken on record. Release tomorrow in the fresh matters list. Fresh matters list.
If the Lordship's kind leave, apart from this 230 matter, there's one more matter in list 3, item 14. Lord, the order in original has been challenged, admitted, stay granted, and it is coming on Saturday before court number 10. That's the writ against the order in original. Now, my lord, in the same matter, they have preferred an appeal when the
List
matter
3, serial number
14.
Yes.
So when in the same matter, they have now preferred an appeal. So we have challenged the appeal also. Both has to be heard together. Either your lordship may admit it and post it on 10th before that bench, before court number 10 on Saturday. I mean, your lordship finds consequential, my lord. I told the other side also.
No, correct. But proper procedure will be let your counsel on record move a memo.
Yes.
Before the division bench to summon this.
No, this is not before the division bench.
Not before single judge. Before the single judge, court number 10.
What happened, my lord, is we challenged the show cause notice. During the pendency of the show cause notice, order in original was passed, and the order in original was stayed by a coordinate bench of this honorable court, a learned single judge. That matter is pending before is part heard and pending before court 10.
On Saturday.
Coming up on Saturday. Now, what against this order in original, the revenue has filed an appeal before the first appellate authority. Now, if the order in original goes on account of jurisdiction not being there, the appeal automatically goes. So what we have challenged now is the appeal proceedings to be stayed until that matter is heard.
Otherwise, if the appeal is allowed, then writ is infructuous.
The appeal is pending before?
The first appellate authority, second respondent in item number 14.
Who appears?
Mr. Jeevan appeared in the other matter. He is appearing in the other matter.
Jeevan Niralek.
You bring him in his presence, we'll see.
Very well. After learned senior has a 230 matter, if it can be taken up after that, my lord.
Let us.
Great.
Both have to be tagged together, that's all.
Correct, but then
yes,
correct, but orders for coordinate bench will have to be done by the chief because of some other issues.
Yes.
So we'll see what is to be done.
Very
or this could await till some decision is taken there.
Only thing is the proceedings will have to be stayed here, my lord, because if
He
the
should not
appeal
pass
is
orders in
decided,
appeal.
then
You serve a copy on Jeevan.
it's been served. Item 14, list 3. Meta
Order
platforms.
original is pending there. Again, they have preferred an appeal.
OIDs.
They want the appeal also to be.
OIDs.
Yeah. Same matter, my lord. The appeal can't be disposed of.
No, so then we'll keep the proceedings in abeyance till that is decided. What?
It's coming on Saturday. The matter. Item 14.
If my lords kindly see the interim order, it is part of this writ petition at page 532.
OIDA service.
OIDA.
But it was tagged along with that, those matters, no, Nest
Correct.
and.
Correct. That's coming up on Saturday.
Uber. Lord, all those matters are tagged together. The other 2 matters, my lord, the present matter which is they are mentioning.
With all online services
Online,
outside
my
India,
lord,
can they tax it?
No, correct, but according to procedure, It, orders have to be passed by the chief and then only it would stand.
No, what your lordships perhaps can do is, if your lordships kindly see the interim order, if your lordships can pass an interim order and direct tagging of this matter with the other petition automatically.
I can't order that. That has to be done by the chief. At the most, some interim relief you want,
Yes.
we can consider and keep it pending.
Yes.
If my lords kindly see page 532.
They filed an appeal when the order is pending, they filed an appeal.
Page 532 is the earlier writ petition interim order.
Lord, I think your lordship will put it in abeyance. Let them not dispose of the appeal. We'll file a memo and get it tagged up.
500
Okay,
and
no?
532, 532.
So I difficult to recollect.
And 533, the order starts, my lord. Top of 530.
Appeal they have filed.
This is the same June order. They have preferred an appeal. So let me get that.
identical contention.
Identical contention, same order in original, we challenged it and that matter is pending already, my lord, it's part heard. Against that order in original, revenue has filed a first appeal. All that we are asking in this writ petition is to stay the proceedings in the appeal so that our writ petition doesn't get infructuous, doesn't become infructuous.
Yes, Jeevan.
Because ultimately, if the order is quashed, my lord, on account of want of jurisdiction, appeal automatically consequentially goes. So therefore, my lord, this.
That is writ petition number
16088
of
2025.
One 6088 of 25. Where appeal is not.
No, this is against the order in original. They have preferred an appeal against that. So we are saying this has to be tagged along. The revenue is preferred an appeal. Revenue is preferred an
Revenue
appeal. Revenue is preferred an appeal. The order in original is in my favor.
My lords, kindly see our interim prayer is at page 56.
Original.
Page 56.
Is challenged before the learned civil.
Yes.
Yes, it is pending.
We have challenged. You have challenged it in appeal, which is pending in the before the first appellate. Revenue is challenged.
No, it appeal or.
No, first appeal.
First
Statutory
appeal. Statutory.
So I was just, instead of saving time a lot, we'll move the chief for the upper directions. Meanwhile, let them not pass an order within next 10 days or 15 days, that's all.
That comes Jeevan. Accepts notice for the respondents 1 to 5. And senior counsel Sharvin Datar appearing for the petitioners would submit that as against the order in original WP 16088 of 2025 has been filed by the revenue
By
and
the petitioner. By the SSC.
petitioner and matter is pending and an interim order is in operation.
That's right. At page 530.
Next, it's further submitted that pursuant to ancillary proceedings are pending before the appellate authority.
Respondent number 2.
Respondent number 2. And as the outcome of such proceedings is dependent on the adjudication of WP 16088 of 2025, for the present, there may be an interim order of stay of proceedings, appellate proceedings before the second respondent.
Second respondent pursuant to annexure H, which is the appeal filed by the revenue.
Pursuant to annexure H.
G and H.
G and H. Next, in light of the proceedings pending in WP 16088 of 2025, which the outcome of which is stated to have an implication as regards the proceedings of appeal before the second respondent, subject to further consideration, there would be stay of proceedings
before the second respondent pursuant to annexure G and H.
Stay of proceedings before the second respondent, which appeal proceedings are pursuant to annexure G and H.
That's
the respondent is at liberty to seek for modification of the interim prayer if circumstances so arise upon filing statement of objections.
Great.
Your Honor, if I could mention item 53 in list 3, I had mentioned in the morning as well, Your Honor, there is a lien which has been marked on the business account.
We have
When
made
it ma-
note of it. Just wait, we have
Please.
made note of it.
Please, Your
Serial
Honor.
number 44, my.
Ah.
Serial number 44 in list number 4 pertain to passing of general award, my.
Ah.
May
Let
be
us see.
disposed.
ಅದು ಬರ್ಕೊಂಡಿರು. ಹ? ಇದ್ಯಾವುದೋ ಒಂದು ಇತ್ತಲ್ಲ, ಇದ್ಯಾವುದೋ. ಹಾ. ಅವು ಯಾವ್ಯಾವ ಸ್ವಲ್ಪ ಅದು ಯಾವುದು ಪಾಸ್ ಓವರ್ ಅಂತ ಹೇಳಿ ಬಂದ 2:30ಗೆ ಸ್ವಲ್ಪ ಹಿಯರ್ ಮಾಡಿ ಅವೆಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಇದ್ಯಾವುದಿದೆ? ಹಾಂ ಹಾಂ ಹಾಂ.
My lords, I'd like to make a mention, my lords, this 4 item number 1, my lords. Argument is only on the entertainability of the petition, my lords, that's it. And for the
Let us see, I made a note of it.
Sure, grateful, my lords.
Peruse the order of adjudication at annexure A1. The authority has noticed aspects relating to
Serial number 3
short
ಕರೀಲಿಲ್ಲ.
declaration of turnover, excess availment of ITC, comma, wrong availment and utilization of input tax credit in absence of original purchase invoices. Which is that paragraph you were pointing out? That
Page number 43, my lord.
40?
3, my lord.
Next. It is to
My
be
lord,
noticed.
41, my lord.
No, 43, first paragraph, isn't it?
41 also there is, my lord.
43, first paragraph.
Second para, my lord, discrepancies highlighted in the audit report, including
Correct.
excess availment of ITC.
Yes.
But page 41 also, my lord. The second para. The taxpayer has merely
Yes, yes.
asserted the receipts represent loans and things.
41 second para, my lord, where last line, my lord, if your lordship permit, the taxpayer has failed to produce these mandatory records during adjudication.
Yes.
Because I read everything, actually they have given reply. We have information, we have issued endorsement, but none of the documents were produced. But first appearance, they have not appeared also. Orally they came and in hurry burry they requested.
No, they've given a reply. Afterwards, they have not given these documents.
Nothing, they didn't appear at all.
No, but they've given reply.
Yes, my lord.
My lord.
But they have not.
Yes, my lord.
Certain documents to the understanding of the petitioner is given.
That's why cost must be levied. Otherwise, 10% let them pay my request, my lord. But if they feel inconvenient, let them pay at least cost.
Yes, yes. Next. The authority has observed that the petitioner, though afforded an opportunity of personal hearing, has failed to take benefit of such opportunity afforded. Next. It is to be noticed that the issues raised are factually dense and require furnishing of necessary records. In fact, the authority in the order impugned has made certain observations which indicate that the petitioner ought to have produced certain records.
But my submission may be recorded. I opposed, my lord.
Observations made are as follows. Page 41, second paragraph. Page 43, paragraph 1 and 2, pencil and mark.
My lord, in 41 second para.
Correct.
In 43 second para, my lord.
43 second paragraph.
Page number 43, second para, there also. Their explanation.
Even the first paragraph, even the first paragraph,
Yes, my lord.
first and second paragraph. Next. Though Lord HCGP would contend that once reply is made to the show cause notice, non-furnishing of documents is a lapse on the part of the SSC, and the authority has rightly drawn an adverse inference for non-furnishing of documents. However,
Last line, my lord, if you lordship permit, these mandatory records have not been provided, merely submitting an ITC register without corroborating documents
yes,
does not satisfy the burden of proof under section 155.
However, it would be appropriate that an opportunity is granted to the petitioner to produce the documents in light of the observations made in the order itself, to the effect that the petitioner has not discharged the burden of proof as imposed on the SSC under section 155. Next. Accordingly, the order at annexure
A1,
which is order of adjudication dated 3/12/2025, is set aside. Matters remitted for reconsideration before respondent number,
sole respondent,
before the respondent, the petitioner, to produce relevant documents as are necessary to make out his case, taking note of the observations made in the impugned order of adjudication which are extracted above. Needless to state, the burden is on the petitioner to demonstrate and make out his case by way of reliance on appropriate documents. Next, accordingly, the authority, upon appearance of the petitioner, may afford an opportunity of personal hearing. Petitioner may produce such records as may be necessary to make out his case. Accordingly, the order at annexure A1 is set aside. Matters remitted to the respondent. Petitioner to appear without fresh notice on. Next, petitioner to pay costs.
18th of May.
Costs of rupees 10,000 to the so and so.
My lord, 10,000 is very meager, my lord. Please, my lord. In this case, my lord. One humble request, my lord.
15,000.
At least one minimum.
Yes.
My lord, annexure A2 is a summary of the order that also needs to be quashed. And annexure B is a bank attachment.
Annexure A2 is set aside as well. In light of setting aside of the order at annexure A1 and A2, the recovery proceedings as reflected in annexure
Annexure
B are set aside. Yes, next.
Next 123, Sangamesh RB, Ajay Kumar.
Yes.
In this matter, my lords, BDI, my lords, has allotted, my lords, these sites. All these petitioners, my lords, are slum dwellers, my lords. They're all allotted the sites in the year 1987, 1990, my lords. Now, my lords.
Yes, Chandrachud. Yes.
But this matter, let me just point out some facts. This matter, survey number 69/1 and 69/2 of Lingarajpuram is the land area which is in question. Both these lands were notified for acquisition by BDA also. The preliminary notification is of the year 1977. The same was followed by final notification of the year 1980. Thereafter, the further proceedings seems to have taken place. I have not able to get the entire records in time. But this much is clarified, my lords, that the lands were subject of notification, so object acquisition by BDM much earlier. The same lands, my lords, appears to have also been notified, my lords, for the benefit of the railways, as per the notification that's been now produced by the petitioner, my lords, at annexure G. Because these two survey numbers have been notified over there.
That is subsequent.
Subsequently. Now it needs to be clarified from the Railways Department, my lords, whether this notification which has been produced, my lords, was carried forward and whether they further took the acquisition to its logical conclusion, my lords, by passing an award, and did they pay the compensation and if they took the possession of the land. Otherwise, my lords, the acquisition of BDA would
Revive.
would survive, my lords. Because my documents show that it was carried forward further. They may have to clarify that position.
Now, my lords, they're interfering with my possession, my lords.
Pass over, let him come. Pass over. Yes, next.
24, Vijay Kumar.
Okay. 24.
My
Yes.
senior is outside. I'll just call him.
The principal point, my lord, is in one judgment, my lord, fundamental principles when it is a nullity.
No, just one. It is. Yes.
My lord, 24.1 is our petition, wherein we challenge the entirety of the district court's order. Your lordship may kindly remand the matter back to the district court, my lord, with a direction that they being the appellants, let them bring the LRs of all the landowners whom they think that has not been included, because they are the appellants before the district court. With that observation, my lord, matter may kindly be disposed.
Your other contention, you raise it before the district court.
Is the appellant before that?
So you raise it.
They are the appellants.
Correct. Now, insofar as any other point, including orders passed
No.
against a dead person, amounts to nullity, all other contentions will keep it open. You raise it before the district court.
Yes.
So that will be
But Supreme Court clearly held, my lord.
No, that you raise it before the district court.
Yes.
Let the district court
With
take
regard
note
to
of it.
nullity, any person can question before the any appropriate authority because they are the original order obtained at the hands of Tahsildar.
Correct. That you have to establish.
Yes, my lord.
That
Yes,
as on
yes,
the-
yes, yes. We
So
will
that
do it.
you do it then.
Yes. Till that interim protection with regard to the disbursement, my lord, is concerned.
Further, ಇದೊಂದು asterisk ಹಾಕಿರ್ತೀನಿ. ಅಲ್ಲಿ ಇದು ಸೇರಿಸ್ಬೇಕು. As regards the order with respect to other survey numbers not relating to the claim of the petitioner, that is survey number
90, my lord, 90.
90 of Chikwa Banavara village. The learned district judge may consider the contentions as is permissible in law. Next. Accordingly, reiterating that insofar as respondents in the miscellaneous appeal who have a say as regards claim of the petitioner in survey number 79, petitioners to bring on record the legal representatives if so advised. All other contentions are kept open to be raised in the miscellaneous appeal. Accordingly, the present petition is disposed of while noticing the aspect relating to order in MA being passed against dead persons.
My lord, petitioner in item number 24, because I am petitioner in 24.1. Your lordships directed that petitioner will have to bring the LRs on record, or the appellant before the MA court has to bring the LRs on record. Because your lordships now dictated, my lord, the petitioner to bring LRs. Because there are two petitions.
And next, insofar as WP number, ಅದು separate heading. Seal number 24 ಅಂತ
24 is maize, my lord.
ಅದನ್ನೇ ಕೆಳಗಡೆ seal number 24 ಅಂತ ಹಾಕಿ separate ಆಗಿ ಅದು ಕೂಡ 24 ಕೂಡ. Insofar as WP 25589 of 2025 the present petition could be disposed of with the observation that the respondent KIDB would not disburse the compensation amount till the dispute in the miscellaneous appeal does not attain finality.
My lord, that would mean then they will.
What is the direction now?
My lord,
Vis-a-vis the petitioner herein. Vis-a-vis the petitioner in WP 25589. So till that attains finality between this petitioner
till the disposal of the MEA, my lord,
till disposal of the miscellaneous appeal.
Miscellaneous appeal.
Yes. Accordingly, petitions are disposed of.
Lord, and the petitioner to bring the LRs on record is petitioner in this manner.
That's separate under separate
Please.
heading. I'll write.
Please. Or appellants in MEA, my lord. That would be.
One sentence at the appellants in the miscellaneous appeal.
MA 3 of 2022.
In MA 3 of
2022
are required to take steps to bring LRs of the deceased respondents in the said appeal, failing which consequences would follow.
Please, and expeditious disposal, my lord. If I may seek your lordships.
The learned district judge may take appropriate steps to expedite disposal of the MA, taking note of the seniority of the matter and the urgency as pleaded.
Please, oblige.
My lord, learned district judge can decide including the nullity of the original order.
All contentions your lordships have said.
I've kept it open.
Please.
Yes, that
all contentions are kept open. Yes.
This is
No,
where
so now BDA proceedings are earlier in point of time.
Lord, this is a notification of the year 1980, my lord. Because the railways being a central government agency, they cannot notify their name. They are only the beneficiaries of the notification. The notifications are published by the state government on the request. And this was proposed for a Bangalore-Salem railway line, which is already in existence on this particular property. The land which was abutting this particular railway station now has been given to the suburb railway, where the suburb railway is already in execution, where a few writ petitions whereon that particular project is getting stalled on these particular few writ petitions. Out of that, one writ petition was a batch of writ petitioners on the same contention, where they were the allottees of the Bangalore Development Authority, was before this honorable court. This honorable court, while that writ petition was under process and under consideration, the suburb railway, wherein as the land owners or the land losers were already compensated for the lands, as a few constructions had come up, they were compensated for that particular constructions by the suburb railways, KIRDC, KRDCL. For that, they withdrew those writ petitions. They have made their applications to them independently and have obtained the compensation. And in this particular writ petition, their contention, there was a civil suit also filed against the railways as well as the KRDC who are executing the project. In that writ petition, the interim application was rejected on the premise and on the count that it is a notified land. It is already taken possession in the year 1980 itself. Later on, the sale deeds which they claim cannot be without having a challenge to the notification. Then this particular writ petition on the orders of the trial court is my understanding is the writ petition here. Now, on the count, the notification or there is no challenge to the notification. That is my first count prayer before your lordship. They are only seeking that they have given a representation to the Bangalore Development Authority for their allotment of a reallotment of a site. Without challenging, when the trial court has also made it a specific finding that there is a notified, the lands are notified, there is acquisition process being completed, without challenging, it's a 1980 delay and latches. Maybe that is the reason why that particular prayer is not included. if your lordship is pleased to take the prayer, my lord, at ink page number 14 of the writ petition paper book.
No, no, what protection you want?
My lords, I am only praying, my lords, let them not demolish until consideration of that
That
application, my lords.
correct. That is by whom? That is by the BDA.
BDA, my lords.
Now the authority which is going to
My lords,
disturb
since,
you-
my lords, even BDA
rail-
has a notification, my lords.
No, correct. Now that the railways are now asserting their rights under that notification, which is not challenged.
My lords, we are asserting under the BDS notification, my lords. My lords will see their notification is, my lords, in the year 1980. My lords, we are now in 2026. For 4.5 decades, my lords, they do not take any action. No, my lords, after 45 years, my lords, after I have built houses, everything, my lords, these are slum dwellers, my lords. Now they want to demolish, my lords. It is not that, my lords, I mean illegal possession. What the learned council is submitting, my lords, in the other batch of writ petitions, those were all illegal occupants, my lords. That is why they withdrew, my lords, on the count that KRCL will pay compensation. Here, my lords, I have, my lords, possession. In fact, my lords, BD has executed sale deeds in favor of me, my lords.
Yes.
May I make one submission? The prayers, my lords, of one ascertaining, asserting, my lords, that they have title over the property, and the other prayer of seeking for alternative site can't go hand in hand. They'll have to either say that they will press for the relief of prayer of an alternative site. If their relief, my lords, they would press for is for an alternative site to be allotted, my lords, as per their representations. My lords would direct BDM, my lords, to consider the same and also ensure that, my lords, an alternative sites are allotted to them. If that's what their prayer is. If they want to go on the question of challenge to the acquisition or otherwise, my lords, then that would be a different aspect. If they want to secure, my lords, an alternative site, my lords, because otherwise they should not have made such a prayer in their writ petition.
No, that is there. But what is the intersay?
Please.
Intersay between you and the railways. What
Please,
is the,
please.
What is
Now,
the position?
One would be, my lords, that the land has been notified and acquired, my lords. Now, what's been stated by the railways, my lords, is that as per the document which has been produced, my lords, my learned friend says, my lords, this is a 16-2 notification and not a preliminary or final notification as per him. And this is of the 1980. My acquisition, my lords, comes out in 1977. 1980 is when my final notification comes. Thereafter, I have taken up further action. Then, my lords, my acquisition would survive, my lords, because it would become a subsequent, if that is the subsequent.
Earlier in point of time.
Lords, this is a subsequent, my lords.
No, according to you, yours is earlier. in
That was my submission, my lords, but according to the Council for the Railways, my lords, they say their notification is the earlier one.
So then you place it on record.
Please.
As per the petition papers, my submissions were on that.
No, correct. Now, Mr. Chandrachud, you place your stand on record.
We both will try to get the
My only
position records.
respectful submission before your lordship is, my lord, there is no challenge to the notification, first and foremost.
Correct, but you place it on record. Let us see which is earlier. Suppose yours is earlier in point of time. What is the legal implication? We'll examine.
Legal implication, that I will just assist the honorable court. My lord, my submission on that particular fold of the court's question, my lord, the state government is the one which acquires property for the railways. As we are the beneficiaries, we are only the beneficiaries. As an agency under the central government, under the Land Acquisition Act.
State has passed.
State, it is the state. Always it is the state who acquires the property for the railways, Your Honor. Because all notifications, we railways become only the beneficiaries. Because the land acquisition is through the special land acquisition officer. Because we make a proposal and the amount is paid from the railways treasury.
No, correct. So you place your whatever material.
Yes, ma'am. I'll just assist that.
On record.
Yes, ma'am. Because on reading this particular preliminary papers, I was able to assist the honorable court onto that particular point. Because there is already an existing Bangalore-Salem railway line which is running. It's a 2-acre extent of this particular 69/1 and 2, Your Honor. The remaining portion which was there, now that has been subleased by way of a sublease to the state government for the suburb railway, which is already in progress. This particular stretch of Lingarajpuram railway station, where the suburb rail is coming, is now stuck with a few writ petitions here. One batch of writ petition, the KRC, who are the beneficiaries of this sublease, already entered by virtue of that and got it settled. Now this is other batch, Your Honor.
Let us see, I'll have it on
And the
next.
public project is now getting to a stall by virtue of these type of litigations coming.
So I
Until
won't-
Malaj, then Malaj, an interim order may be there,
Right, we'll
Malaj.
try to get the details.
I'll have it on next Monday. Meanwhile, orally you instruct them not to demolish. I will not pass an order. I'll await further instructions from
Now,
your
there
side.
is no question of demolition also as per them in their prayer, Your Honor. Nor in the interim prayer. In interim prayer only is that disposes.
Let us see. Relist the matter. State you also
That's
examine.
reason is this, Malaj. Now they're aggressively, Malaj, on this, Malaj.
Let us see, let's get a clear picture and then I'll pass an
May
order.
I make one request? Rather than an interim order, maybe it could be called so that,
So I'm calling, I'm saying orally you instruct them
Yes, ma'am.
not to dispossess till the next date. On the next date, I'll consider after you take your stand.
yes, madam.
Relist the matter. in
Let's
the
may I
same
request it
stage
on-
on
Monday, as you
28th, Malaj, if I may
Monday.
request.
My lord, I'll
28th,
accept
Tuesday, Malaj.
For 3 minutes.
Tuesday, 28th.
I'm so obliged,
The
Malaj.
notice I'll accept on, risk number 3.
R3.
It's already ordered.
Order. Copy me this.
Give the state another copy.
I'll serve them one more copy.
Next,
Malaj,
next.
they may be directed, Malaj, not
I've told them,
to, please, Malaj.
there before the
Pass
court.
over matters list to serial number 1, Pradeep Nayak.
Sorry, I missed it in the morning. Literally, those 5 minutes I was out of this court. Just before I go into the merits of the case, I'll just give my lords a brief, very brief background into the petitioners and their credentials. Now, the petition number 1, is a public charitable trust. It was constituted by way of a trust deed on 1st of July 2015. I won't trouble my lords with just some relevant dates I take my lords through. It was granted, my lords, we applied for registration under section 12A as it was then. It was granted registration, my lords, on 8th of January 2016 for a period of 5 years. So from 2016 up to 2021, I enjoyed exemption. After the income tax authorities examined my deed of trust, examined the genuineness of the trust, the objects of the trust, and thereafter they granted me registration. That situation continued up to 2021. 2021, I applied for renewal. 2021, also I was given renewal. Now, my lords, I'll just pause here for a moment. Now, why I want to deviate from the facts, my lords, is just to point out that, one, there is no allegation that the trust receives any foreign funds. The trust itself, my lords, consists of various eminent personalities, not with the intention of name dropping, my lords, but former trustees have included former Supreme Court judges. Current trustees include former editors of leading newspapers, senior advocates in the Honorable Supreme Court. The benefactors, my lords, of the trust, the ones who are donating, the donors, include, again, my lords, former Supreme Court judges, eminent personalities, my lords, industrialists, and so on. So therefore, my lords, the only reason why I'm pointing out was as I'm submitting, not for the sake of name dropping, but because, my lords, there can't be any question as to the credentials or the of the donors themselves, and nor have they questioned that, to be fair. The beneficiaries, my lords, now just to come to the object of the trust itself, I'll take, my lords, through the specific objects. The trust itself, my lords, was constituted with the sole purpose of supporting independent journalists. Now, my lords, there are media persons who, out of volition or otherwise, do not want to join the mainstream media, or as they call it, the Noida media. They don't want to join those big media houses. They don't want to join the newspaper industry, but they want to pursue their dreams of becoming journalists. They want to be independent journalists. Now, as your lordships would understand, they are persons who would have no funds of their own or limited funds of their own, which is where, my lords, the trust steps in. The trust, my lords, supports them by way of giving funds to these independent journalists. Now, that is broadly, my lords, the object of the trust. I'll take, my lords, through these specific objects at the relevant point in time. Now, my lords, therefore, the donors, the beneficiaries, coming to the beneficiaries, the persons who we donated to include, my lords, well-known small media houses such as Live Law, Economic and Political Weekly, Supreme Court Observer. So, my lords, these are small houses which essentially provide vital information to the public. So, my lords, this is important, my lords, at a relevant point in time. I'll come back to it. So, therefore, my lords, there are various small media houses which have grown significantly because of the initial funding that they received. In fact, my lords, Live Law may be self-sufficient now, but in fact, they've written to us saying that They owe their very existence to the funds that we donated to them. So therefore, my lords, it's not, and why I'm also pointing this out is, these are not only political organizations or media houses we donate to, because finally, my lords, that's the color that is being given to this. I'll come to that again. So therefore, my lords, this is a broad overview of the trust. The department themselves granted me registration under 12A, renewed registration in 2021 up to 2026. Now, my lords, when that being the case, in 2022, there was a survey that was conducted, my lords, under section 133A. I'm told, my lords, not just in our premises, but also in another premise. I'll come to that. There's a Delhi High Court order, my lords, I'll be placing reliance upon, wherein, my lords, they seized various material. They asked us for various hard drives and so on. All of that we cooperated. All along the proceedings, my lords, there is no allegation that we did not cooperate. Now, my lords, after the survey action was completed, a show cause notice was issued, my lords may note this date, on 15th of December 2022, proposing to cancel our registration under section 12A(b), subsection 4. Essentially, my lords, on the ground that, and I'll come to the specifics later, but broadly speaking, that we are acting contrary to the objects of our trust itself. Now, at this stage, could I request, my lords, to kindly see the objects of the trust? My lords will find that at page 390. Page 390, could I request, my lords, to go? The only reason, my lords, I may trouble, my lords, reading all the objects is because their specific case appears to be that we have acted contrary to the objects of our trust, which would necessitate the action of cancelling our registration. Now, my lords may kindly see how broad-ended and honorable, if I may say so, the objects of the trust are. Clause 4, my lords, 4.1, to provide scholarships, fellowships, and awards for writers, authors, and journalists involved in public interest or any other form of journalism that spreads information and awareness and benefits Indian citizens and India as a country. To provide financial and other assistance to organizations and individuals creating and distributing public interest information to the public at large using digital media, social media, mass media, or any other media, thereby bringing about proper awareness and improving public understanding of issues. To promote excellence in education in the field of journalism by providing financial and other assistance to journalism schools and other education institutions in the country. To create public interest content, achieve wider distribution and consumption of public interest content, provide services to support content creation and distribution, create an umbrella brand that will provide a sense of common identity to the beneficiaries of the trust while allowing or preserving their respective identity and, importantly, independence. To undertake actions and initiatives, including but not limited to providing financial assistance by way of grants or through other means to create an ecosystem that sets trends, fosters and accelerates excellence in public interest journalism.
Now
And
the 12A is valid till?
When 2026, well, it was, when they renewed it in 2021, it was for a 5-year period up to 2026. In the meantime, my lords, now, of course, my lords has got a flavor of the objects of the trust now. Essentially, my lords, to promote public interest journalism that will eventually benefit the public. How? By supporting these independent journalists. Now, my lords, if I want to do an investigative journalism piece, I may have to travel. Let's say, my lords, during COVID, I had to travel to various parts of the country to report on what's happening across the country. I can't fund myself. So therefore, that's where the trust would step in and say how two kinds of funding again. One is if I'm a non-profit, I simply have to go and say, listen, I have, these are my broad ideas of what I want to write on. I anticipate about say 1 lakh or 5 lakhs, or whatever the case may be. Could you please fund? Now, the trust will consider my request. They may give the entire amount or they may give a lesser amount. That is a simple case of a grant itself. The second aspect, Malas, is where there may be profit-oriented organizations as well. For that, Malas, we enter into what is called content commissioning agreements, which up to 2019, this is again important, Malas, up to 2019, there was a subject-wise allocation. So let's say they wanted to write something about let's say, sports, which was possibly in our opinion not as important as writing something about politics or something more public spirited or public minded. I would give them a rate card saying I'm only giving you this much, and it would also be linked to the length of the article or the length of the video piece that is being made. So there was a rate card up to 2019. I'm told, my lords, after 2019, even that is done away with. So you simply have to come and tell me that this is what I need. We will consider a request. And this is most important, my lords, I do not interfere in any way whatsoever with what they want to write. If they want to write upon COVID, please go ahead and write about COVID. I don't tell them write only this about COVID or the manner in which it was managed. Only thing where I would, if for lack of a better word, interfere is I do a quality check. And that is simply, well, as your lordships can understand, because I don't want people to write using my money non-productive pieces or non-useful pieces to the public. Finally, Maharaj, the public has to be benefited is the ultimate objective. So that is my only limited, for lack of a better word, interference in the entire process. Now, coming back to the sequence of events, my lords will recollect, 15th of December 2022, I received a show cause notice proposing to cancel the registration under section 12AB4. I'll take my lords through the provision subsequently. These were, my lords, the 5 broad heads. My lords may kindly see at page number 560. This was the show cause notice. I'll only read the headings, my lords, because that I think your lordships will get again a flavor of what exactly was being proposed. The bullet point with the circle and the exerting influence. One, the summary of the same is discussed as below. Exerting influence for promotion of political articles by paying more money vis-a-vis other articles. So their first complaint was that you're promoting only political articles by paying more to them. I don't have any qualms about that. In fact, initially I was doing it. That was one of my objects also, because finally the public has to benefit. Then second, biased promotion of select articles and issues. Then supporting publicization of, or publication it must be, of polarized content. I think A, B and C can be sort of bunched together. Then the fourth one is again interesting. It says grants to profit-making entities in the form of professional fees. My object never said that I will provide grants only to non-profit making. Now, in fact, whereas tomorrow if Live Law makes a profit, I'm very happy for them, but it doesn't mean that I will stop funding them. And last one, targeted covering in the garb of fact checking. Now, these are the broad headings. They issued a show cause notice to me as to why my registration should not be cancelled. I filed a detailed reply. Subsequently, my lords, while these proceedings were going on, there was a personal hearing. Then I received another notice on 27th January 2023. In addition, what was happening all along was, every time there would be a hearing, every time they would call for certain documents, they would keep improving their case. Finally, on 27th of January 2023, I received a notice, first time contemplating retrospective cancellation, right from 2016 onwards. I filed my reply to that as well. One, why retrospective cannot be done, and even otherwise, once again on merits. Then eventually, my lords, on 26th of June 2023, my lords will find that order at Annexure B, page 302. An order came to be passed under section 12AB4 of the Income Tax Act. Before that, could I request my lords to kindly see the provision itself? That will probably give my lords a better idea of to what the scope of the provision is. Section 12, capital A, B, subsection 4.
No, it's now valid.
No, they've cancelled it. They've cancelled. Now, there are some subsequent events. I anticipate, my lords, and rightly so, the department will eventually, at least at the outset, state that I have an alternate remedy by way of an appeal. And I'll address that because there are certain constitutional issues I have raised which can only be raised in a 226 proceedings. And I am also armed with an order of this honorable court, a learned single judge, who permitted me to agitate it at an appropriate stage, which I would respectfully submit is now. So, but I'll come to that. I'll come to that as and when the issue of maintainability would arise. Now, if my lords were to kindly see, before that section 12AA, before 12AB, this is the registration that I received, 12 capital AA. It was, sorry, it's not complicated. My lords has it, 12AA. The principal commissioner or commissioner on receipt of an application for registration of a trust or institution made under clause A or AA or AB of subsection 1 of section 12A shall, call for such documents or information from the trust or institution as he thinks necessary in order to satisfy himself about 1, the genuineness of activities of the trust or institution, and 2, the compliance of such requirements of any other law for the time being enforced by the trust or institution as are material for the purpose of achieving its objects, and may also make such inquiries as he may deem necessary in this behalf. And after satisfying himself about the objects of the trust or institution and the genuineness of its activities as required under subclause 1 of clause A and complies with the requirements under subclause 2 of the said clause, he 1 shall pass an order in writing registering the trust or institution or reject it. 2 is not applicable. Why I read this out, my lords, is this procedure was done not once but twice. First in 2016, then once again when I applied for renewal in 2021. So therefore, my lords, the principal commissioner, only after completing all the formalities of satisfying himself about the genuineness of the trust, about the objects of the trust, was my registration granted. Then my lords may kindly come to 12AB. 12AB, more specifically subsection 4, my lords. This 12AB4, my lords, came into force with effect from 1/4/2021. Subsection 4, my lords, of 12 capital AB. My lords, has that? Where registration, subsection 4. Yes. Where registration or provisional registration of a trust or an institution has been granted under clause A, B, or C of subsection 1 of clause B of subsection 1 of section 12A, as the case may be, and subsequently the principal commissioner or the commissioner has, kindly mark this, noticed occurrence of one or more specified violations during any previous year. B is not applicable, my lords, nor is C. My lords may skip that. The principal commissioner shall call for such documents or information from the trust or institution or make such inquiry as he thinks necessary in order to satisfy himself about the occurrence or otherwise of any specified violation, to pass an order in writing cancelling the registration of such trust or institution after affording a reasonable opportunity of being heard for such previous year. Kindly mark this again, for such previous year and all subsequent previous years if he is satisfied that one or more specified violations have taken place. 3, pass an order in writing refusing. That again not applicable because they did cancel the registration. Just 2 things I'd like to point out, my lords. One is the 12AB4 is triggered only if the principal commissioner finds that there are quote unquote specified violations during any previous year, and he may then, if he satisfies himself that there are specified violations, he may cancel the registration for such previous year where he finds that violation and for such subsequent years. Then, my lords, kindly see the explanation where specified violation is defined. So these are the only cases in which the registration can be cancelled. My lords, has the explanation. For the purposes of this subsection, the following shall mean specified violation. A, where any income derived from property held under trust. That's not the allegation, so I'll skip A. B is the trust or institution has income from profits and gains of business, which is not incidental to the attainment of its objective. That's not the allegation once again. So B also not applicable. C, the trust or institution has applied any part of its income from the property held under a trust for private religious purposes, not the allegation again. D, the trust or institution has established for charitable purpose, created or established, has applied any part of its income for the benefit of any particular religious community or caste, not the allegation again. So therefore, we're only left with E. Any activity being carried out by the trust or institution is not genuine or is not being carried out in accordance with all or any of the conditions subject to which it was registered, or the trust or institution has not complied with the requirement of any other law. Again, that's not applicable. So therefore, these are the only cases, my lords, in which the rigors of section 12AB are attracted or triggered. Now, coming back to, my lords, the impugned order, so the original order cancelling my registration, which was passed on 26th of June 2023. I highlighted those 5 main points. Essentially, my lords, the show cause notice has been reproduced as the final order. after, of course, extracting my objections and briefly dealing with them. Now, this is important. After, the operative portion is at page 374. I'll just come to page 374, my lords. I won't trouble my lords reading the entire order because it's quite verbose. Page 374. Considering above, undersigned is satisfied that there were specified violations in the case of the assessee trust for the previous years 2016-17 to 2021-22, relevant to assessment years 17-18 to 22-23. So the registration of the assessee trust as granted under section 12A, 12AB of the Act is cancelled with effect from previous year 2016-17 and for all subsequent previous years as per provisions of section 12AB4. Now, as soon as this order was served on me, I approached this honorable court. I filed writ petition number 17891. My lords will find that order at page 726. I think it's in volume 4, I'm told. Annexure AD. 726. My lords may cease.
Yes.
726. Kindly come to page 728. Learned senior advocate appearing for the petitioner seeks leave to withdraw.
Paragraph?
I'm sorry,
Paragraph?
There's only 2 unnumbered paragraphs at page 728. My lords will see the same petitioners. This was filed in the year 2023, immediately upon receiving the order. The prayer column, my lords may kindly see at page 727, which is extracted. That was challenging the order under 12AB4. Now, my lords, what happened then was, this is on 23rd of August 2023. At that stage, it was felt probably appropriate that it would be better off if we approach the tribunal, which is the statutory appellate remedy, while leaving open the constitutional challenge. Learned senior advocate appearing for the petitioner seeks leave to withdraw the petition so that he can go before the ITAT, provided that his right to challenge the violations of the statutory provisions is kept intact. He has filed a memo dated 23rd August 2023 to that regard. Then the second unnumbered paragraph, in view of the above, leave has been granted. Leave having been granted in the memo, petition is disposed of as having been withdrawn with liberty. So then, my lords, we went to the ITAT. Now, interestingly, could I just point out one aspect which my lords will note, probably sheer coincidence, 23rd August 23 was the date of the order. 25th August 2023, could I just pass on what had happened, my lords, is on the same day, I'm told, 2 other similarly placed trusts were also surveyed on around the same time. Identical grounds were raised, saying that you're promoting political articles, you're promoting polarized content, therefore we'll cancel a registration. One of the organizations, my lords, approached the Honorable Delhi High Court. My lords may kindly see the order. This is the reported version. Is it okay? I'm so sorry. I have the unreported one, but my lords may kindly see. This is order dated 25th August 23, which is why, my lords, I said by sheer coincidence, 2 days earlier, my lords, that writ petition came to be withdrawn before this honorable court. Then, my lords, may kindly see the paragraph number 3. This writ petition assails the order dated June 30th, 2023, passed by respondent number 1 under section 12A, read with section 12A, 12AB4. Mr. Datta, the learned senior counsel, appears on behalf of the petitioner, has made several submissions. Again, 4.2, the learned senior counsel has drawn our attention to the kind of work in the space of policy and research petitioner organization has carried out in all these years. Then, my lords, there are various contentions that are noted, primarily on the ground that, kindly see, 4.3 I'll read. It's the same thing, 4.3. It's the same. 4.3 I'll read. This apart, closer to the merits of the matter and the issues concerning jurisdiction, Mr. Datta admits that principally the following flaws are embedded in the impugned order. Although the first show cause notice dated so-and-so, adverse to a survey report furnished by the investigation wing of the IT department, it has not seen the light of day till today. The petitioner has not been furnished with a copy of the report. I'm just pausing here, my lords. Identical. Even in our case, we have repeatedly asked for that survey report. Till date, we have not seen it. Second, the impugned order seeks to cancel registration obtained under section 12A with retrospective effect. In this context, it is pointed out that the impugned order has cancelled registration qua several financial years while dealing with the issue-wise purported violations. Mr. Datta said that he's clearly in the teeth of the provision of section 12AB42 of the Act is contention that cancellation of the registration could have been ordered only for the previous year in which the violation was noticed, and if at all for the subsequent previous years. Third, there has been a breach of principles of natural justice inasmuch as no opportunity of cross-examination of persons whose statements were relied upon by the respondent's revenue was granted. This action, according to Mr. Datar, is a serious infraction of law, as those very statements have been relied upon in the impugned order. Fourth, insofar as the third show cause notice was concerned, no personal hearing was granted. That may not apply, so I'm told we were given a personal hearing. Then, my lords, may come to paragraph number, I think 7 and 8, following which they have extracted 12 AB4. Paragraph 9, my lords. 9, no? Same. This brings us to the issue as to whether the balance of convenience is presently in favor of the petitioner, and would any irreparable harm be caused to the petitioner if an interim order as sought by the petitioner is not given. The cancellation of registration would definitely entail a consequence which would result in disabling the petitioner from accepting any contributions from domestic contributors. The petitioner is an organization which survives on contributions. The employees engaged by the petitioner and its work depend on the contributions that it receives. Therefore, the balance of convenience as it stands is in favor of the petitioner. The third aspect we need to consider is that if we were to decline the interim relief, would any detriment be caused to the petitioner, which is irreversible? Insofar as this aspect is concerned, we can only say that the inability of the petitioner to accept donations may derail its programs which are in the pipeline. Thus, having an overall view of the matter, we are of the opinion that the petitioner has made a case for grant of interim stay and further examination, and for further examination of the matter by the court. So and so notice is issued. In the meanwhile, para 17, madam, in the meanwhile, the operation of the impugned order shall remain stayed, subject to the petitioner maintaining a proper account of the contributions received by it, including the details of the contributors. The petitioner will also furnish details of the mode and manner in which the contributions received are spent.
It's only an interim order, is it?
That's an interim order. I'm told the writ petition is still pending. Against this interim order, the revenue approached the Honorable Supreme Court. SLP came to be dismissed in limine. Well, I'll just place that order. So of course, it's just a very short order. That's why I submitted. This happened coincidentally 2 days after this writ petition came to be withdrawn in 2023. 25th August, the Honorable Delhi High Court passed its order. 23rd August, the writ petition was withdrawn. Now, of course, my lords may see that SLP came to be dismissed. Now, coming back to the facts of our case, my lords, your lordships may recollect, we withdrew the writ petition with liberty to agitate the constitutional issues at an appropriate stage. We've filed an appeal before the Income Tax Appellate Tribunal. Now, my lords may kindly see the Income Tax Appellate Tribunal's order dated 16th of January 2026. Again, my lords, a fairly verbose order, but there are some observations here, my lords, I would like to highlight. My lords may kindly come to page 293. Wherein, my lords, I would respectfully submit that gives cause for us to knock on the doors of this honorable court under 226, because, my lords, it gives rise to serious constitutional issues, including Article 19, including possibly rendering 12 AB4 itself unconstitutional for being manifest. Paragraph 58, my lords, and if my lords permits, I'll read about 3 or 4 pages, because this really is the heart of the merits of the matter. And my lords, just to give a preview, what I would like to submit is, my lords will note all along, the theme has always been that the people you have contributed monies to seem to be writing articles against the ruling dispensation, which seems to be contrary to objects of my trust. That seems to be the theme. I'll just read it out once. Para 58 is the first ground. Coming to ground number 9 to 13 on the merits, we have carefully considered the rival contentions and also perused the material placed before us. We find that the first specified violation was stated by the learned PCIT is with respect to, this is the first one, exerting influence for promotion of political articles by paying more money compared to the other articles. We find that the submission of the assessee was that the covering politics is left to the journalist, and further, the assessee does not review articles, stories published, and does not have any directorial oversight. Further, assessee, when confronted with the agreements and various rate cards, it was explained and narrated that Caravan is a very renowned and awarded magazine. The learned PCIT rejected the same, stating that the claims are very generic and no reasons are specifically provided that why political articles are paid higher. Further, the claim of the SSC that there is a huge cost involved in publishing political articles compared to other articles, and therefore there is a change in rate, is also not substantiated. We find that the rates paid by the SSC for politics, governance, policy, corruption, as per the payment terms, as per schedule number 2 of the addendum agreement, is rupees 1 lakh compared to other topics, articles which are even half of the rate. Therefore, it is apparent that if the articles are published on specified subjects of politics, governance, policy, corruption, economic, business, free press, law and society, the amount of remuneration to be paid by the content provider for a story is rupees 1 lakh, whereas for others it's only 50,000. But this remains only a fact that when the political articles are published, the assessee is paying more to the content provider. This also remains a fact that if the higher sum is paid by the assessee to the content provider, it is in a position to influence those content providers to give more political contents. Thus, the allegation of learned PCIT was that the assessee was trying to control the category of the content by paying them the higher sum is correct. The explanation of the assessee was only with respect to that all these content providers are very renowned, have earned testimony to the quality of journalism produced on a consistent basis. However, there was no reply that when the assessee pays higher sum for a particular topic, the content providers, why the content providers will produce the material or content which is higher, which is earning them less revenue. Thus, it is true that by paying the higher sum or creating a rate structure in a manner, the assessee is promoting them to produce more articles on politics, etc. This fact was not denied by the assessee that when a higher sum is the fact was not denied by the assessee that when a higher sum is paid, whether the content providers will produce the articles which are earning less. Naturally, the allegation of the learned PCIT was not on the quality of the content of the magazine, but the fact that the assessee is promoting printing of political articles and trying to control the category of content by paying a higher sum. This is their conclusion. This is not stated in the object of the trust. Thus, it shows that the activity of the assessee is promoting articles on political agenda by paying the higher rates to different media. Then, my lords, paragraph 59. With reference to, this is the second allegation, biased promotion of selected articles and issues. Before I come to that, my lords, may kindly recollect, which is why I read the objects of the trust. The objects of the trust, my lords, are extremely broad, are extremely wide in scope. We want to produce public-spirited journalism. We want to promote public-spirited journalism. The fact that coverage on politics may require more funds, my lord, is not denied. They're saying that you're paying more for politics. That seems to be contrary to the objects of the trust. They don't say which object. They just say it's contrary to the objects of the trust. Now, paragraph 59. With reference to the biased promotion of selected articles and issues, the learned PCIT has referred to WhatsApp chat between the CEO of the SSC as well as the key person of so-and-so, to whom the SSC has provided a total grant of 2 crores in 4 financial years. The communication with the key person of Spunkline Media, to whom the SSC has provided a grant of so-and-so in 5 financial years, further with the key person of Printline Media, whom the SSC has provided, and the chat with Ms. Barkadat, to whom the grants of so-and-so are provided in 2 years. The WhatsApp chat clearly shows that from the side of the SSC, a definite hint for publication of specific stories in different languages are conveyed. It may be an altogether different thing that when those entities publish those articles or not. But it is a fact that the chat of the SSC with those persons clearly shows an inclination for promotion of select articles by those entities. Thus, when the SSC has given huge sums to these entities, naturally the hint is provided to carry out a particular story. At least the chat shows that these content providers are given attention to it. It is immaterial that those parties did not print such articles in their own wisdom. We are not here to test the wisdom of those parties, but to examine the activities of the SSC, whether it is charitable or not. We do not find this part of any object of the SSC to give a lead for publication of particular kind of articles. There is also a definitive hint to carry on the articles by translating it into a different language, which are already taken by the other content providers. A specific communications with the print line media, so on. So I'll skip that now. Kindly come to, anyway, the conclusion once again is you're by hinting at certain subjects, you're promoting certain content, which is not in accordance with the objects of your trust. And interestingly, he admits that those articles may not have been published, but that makes no difference. But even if they were published, I would respectfully submit that there is nothing in the objects of the trust which say that we cannot suggest if there is something else which we feel is important happening. Let for instance, there is an LPG crisis. No one seems to be covering it in the manner in which possibly we feel it should be covered in Karnataka. It's being covered in Gujarat. We could keeping the public spirit in mind at the end of the day, suggest, why don't you try and cover this LPG crisis? That is all. That is the limited amount of interference that there is, nothing more. Then paragraph 60. Now, this is really where they give away, I would respectfully submit, what led to all of this. Whether inadvertently or deliberately, this seems to have slipped out. The third objection is that the assessee is supporting publication of polarized content. This fact is considered at paragraph number 5 of the order of the learned PCIT. The assessee was specifically shown the several articles published by so-and-so media, as well as foundation. The headlines: for harassed for being Muslims, sedition cases in Modi era, as BJP talks of law against conversion, attacks against Christians in rise in Karnataka, Modi government keeps financial deal with Bharat Biotech secret, and further certain ground reports and issues which are mentioned at pages so-and-so of the order. On looking at the themes of the articles placed at page 53 and 54, it clearly shows that these are polarized contents and which is not the object of the assessee. Further, even otherwise, publishing polarized content which may create any disturbance in the society or are of a political nature cannot be held to be charitable activity at all, which is our submitting. I don't need to say anymore. There seems to be a problem. Somebody seems to have had a problem, and this seems to be targeted at those articles because that may have caused an embarrassment to somebody. It appears as if he has not even read those articles. Conjecture is that these sort of articles will give rise to polarized situations. Now, let's kindly see again, if there is a financial deal with Bharat Biotech, assuming there's an article, whether it's true or not, I'm not going to go into that. How is that, polarized? Now, very frankly, there are articles, I'm told, which may criticize even the political party in the state over here. So it's not as if there is, he seems to have highlighted these articles, but in any event, the overarching theme appears to be that these articles seem to be embarrassing someone, therefore we will stop your funding. Then the fourth objection, again, is completely, I would respectfully submit, it's completely extraneous and it seems to be completely without application of mine. Fourth objection is that the assessee is granting huge sums of money to the several entities under the garb of content commissioning charges as professional fees, but there is no details of any services rendered by them to the assessee. Therefore, such grant cannot be considered as an application of fund. Now, my lords may skip over some of that, possibly start with the sentence starting carefully. My lords has that around midway, about 6 or 7 lines from the bottom. Carefully considering once again the objects clearly provides that it had been provided to educational institutions or certain charitable organizations or other institutions engaged in journalism, it would have definitely served the object of the assessee. However, contributing funds to profit-making entities without giving any evidence of services rendered to the assessee defies common sense that it can be considered as an application of the income of the assessee. Because my objects never say that I will give money only to loss-making entities. In fact, one of the objects says I will provide seed funding. Seed funding essentially is to make the tree grow. If the tree grows, I'm happy. If they make profits tomorrow, they're able to stand on their own 2 feet, I'm happy. Merely by happenstance of somebody making a profit. For instance, what is live law? Live law is a classic case. Kindly see, now the effect of this. Now I'll come to really, my lords has seen what the order is. Kindly see the effect of what they've done now. They've cancelled my registration. That means for every rupee I get from any of these donors, 30 to 35 rupees will go straight away to the government. Now, I ask myself, will these donors even come forward tomorrow? Knowing that every paisa which I'm giving as a donation, and again, I'm emphasizing, not one paisa has come from abroad, so there's no question of the FCRA applying. I'm not registered on the FCRA at all. So therefore, these are all local philanthropists, including, as I was submitting, Justice Rohinton Nariman is one of our donors. Justice Ruma Palo is one of our trustees. Now, as merely by happenstance of some articles having been published, and some of those articles possibly causing embarrassment to whoever it might be, the effect is my funding has been cut off effectively. Now, the corollary to that, the effect of that would be, if I don't receive funds, the funding to these journalists, which seems to be the ultimate objective. Now, kindly see, I was just taking a step back. Take the simple example of live law. Nobody can deny that some institute or entity like live law has provided tremendous service, my lords, to students lawyers and dare I say judges also, my lord.
Just, yes, Raviraj.
My lord, essentially, my lord, what is being argued is on merits against the order of the tribunal. That is an appealable order. And so far as, my lord, whether cancellation of registration can be made for years earlier to the year of amendment, my lord, that is a subject matter, my lord, which is pending before this, the Honorable Division Bench. And, my lord, they have been admitted. Question of law has been formulated, my lord, whether the amendment made to section 412 AB4 is prospective or retrospective. There are several matters, my lord, which are getting listed also from time to time. My lord, they have not reached hearing. And so far as, my lord, the grievance that the objections made to the cancellation order has not been considered by the tribunal, my lord, they'll have to file an appeal, statutory appeal before the division bench.
Correct, but the scope of the observations made in the order can't be looked into by the appellate authority. The interpretation given on some issues.
My lordship may kindly see, may lord, go to page number 299, the finding given by the tribunal.
No, correct. Now, what is charitable purpose? The interpretation or observations made raise certain larger issues which we'll consider.
My lordship may kindly see, my lord, para 65.
Yes.
Further, the trust being an entity which is receiving the donations from the most illustrious companies, entities, and persons from the country, as well as the most decorated board of trustees, does not make the case of the trustee SSC stronger that despite collecting donations from them, the SSC can carry out objects which are not the objects of the trust. Further, the various certificates of the personalities that those are not influenced is also of no use. There is no evidence produced before us by the SSC except the reports, etc., which are merely documents without substance to show that the SSC is carrying on the activities of the trust in consonance with the objects and deserves registration under 12AB of the Act. Therefore, we have no hesitation in dismissing ground so and so. Now there is a finding of the tribunal on, my lord, on facts. Whether it's right or wrong, my lord, they'll have to challenge it before
No, correct. We'll consider it, but I'm saying observation made by the tribunal borders on interpretation of their right to freedom of speech and expression as being linked to objectives which are stated to be charitable. So it raises some issue. We'll consider it. You take a stand in writing.
My lord, I appeal for R7, my lord. Here the IT order has been challenged on merits. My lord, I would rightly submit that this petition may have to be placed before the division bench. Where the IT order is also challenged, the division bench would be the appropriate bench which would consider.
Which
my lord, IT Annexure A, my lord.
Annexure?
That's the impute order I just read, my lord. The tribunal's order.
Tribunal order, my lord. Normally, tribunal order should have been challenged in ITA, income tax appeal, before which is placed before division bench, my lord. Now the petitioner happens to challenge the IT order on merits before this honorable court. My humble submission would be that the matter may be placed before the division bench, my lord, because they are challenging the IT order, my lord. But in fact, the Delhi High Court interim order, which the learned friend has placed, is of the division bench of the Delhi High Court, my lord.
We have the benefit of having Mr. Datar here. You could probably clarify that petitions possibly go before a division bench in Delhi High Court. You're saying that the matter which you appeared, sir, the writ petition was placed before a division bench. Registration.
Correct. The objection of the revenue is that the order of the tribunal is subject matter according to statutory scheme of an appeal by way of income tax appeal.
Via recess.
You have challenged.
Yes, boss, we have challenged. In fact, what other than the, I would also respectfully submit, just to complete, there are, for instance, my lordships may recollect in express newspapers.
So where is your prayer?
The prayers, my lords, are at page 193. Now 12AB4, my lords, if, as I was reading out just some time ago, these specified violations, if they are read to include objective analysis, or as well as the US Supreme Court has used the words viewpoint discrimination, my lords, the section itself would fall foul of the rigors of Article 14. And in addition to that, my lords, if that is being sort of weaponized to curtail free speech.
Let us see. Now you take
Lord,
the
may I
stand.
make one clarification? My lord, there is a batch of matters which are pending before the division bench. Lord, batch of matters, my lord, which the revenue has filed before the division bench, my lord. The issue is, my lord, the issue came to be decided against the revenue by the tribunal, holding that the amendments are only prospective. Now the question, and other than this matter, my lord, this matter, because the tribunal also went on holding it against on merits. My lord, the question of formulated, my lord, by the division bench is whether on the facts and in the circumstances of the case, the tribunal is right in law in holding that provisions of section 12AB4(2) of the Act cannot be applied retrospectively.
No, but they have challenged the validity of the section. So you'll
Please.
have to take your stand.
My lord, the question of law formulated by the division bench is whether, my lord, it would act prospectively or retrospectively.
Correct, but that question is under the provision. Now they're challenging the validity of the provision. You have to take your independent stand.
Yes, my lord. Because
You have to take your
Then, my
independent
lord, let them file an appeal under 260 of the Income Tax Act and ask for stay of the operation of the tribunal.
Can you challenge the validity of a legislation there?
And it's only a substantial
For the
question.
stay of, my lord, stay of order of the tribunal.
Now, even if there's a statutory remedy, you can file a writ. That is a settled position. But however, entertainability is a matter of discretion. That when there's a substantive appeal provision, you shouldn't entertain a writ. But when they've challenged the legislative provision, you have to entertain.
As per the liberty granted to us earlier.
heir or to make challenge, it goes before the division bench.
Now, the challenge to the constitutional validity cannot be without reference to a factual context.
Correct.
After you file a statement of the objection, we'll consider it. I'll keep that question open. Now, who appears for, you accept notice for?
My lord, I accept notice for, my lord, 7.
I appear for R7.
The cost, President Council, Sri Arvind Chavan accepts notice for the 7th
My lord,
respondent.
2,
Then 1 to 6.
my lord, 1, 2, 3. My lord, 4 is Delhi, my lord.
So 1 to 3 you will accept.
Please.
President Council Sri Raviraj accepts notice for respondents 1 to 3. Then
Arvind Chavan for 7, I think.
I
yes.
appear for 7.
No, 4 to 6.
Notice maybe I have to.
For,
Notice maybe I have to reach.
Emergent notice to respondents 4 to 6.
my lord, I'll let notice go, my lord, 4 to 6.
Emergent notice to respondents 4 to 6. Now, so you don't take any precipitate, that order will stay.
Can I just make one request? Now, the difficulty I can see from the revenue side also was, but my difficulty as of now is simply this. By virtue of the fact that my registration stood cancelled, I could not file an application for renewal. As your lordship may recollect, 21 to 26, I was given registration. 26, under normal circumstances, I would have filed 6 months prior an application for renewal. But because of this ongoing litigation, I could not do it. So if a lordships were to permit us to file that application, and then at least going forward, we could take advantage of course. In fact, one more aspect I must point out, that retrospective demand only to stop the interest clock and to show our bona fides, we have paid 20 crores. 20 crores demand we already paid. So there's not, even if your lordships were to say, don't take precipitative steps, there's nothing really. So some of the assessments have already been stayed in another petition, but 20 crores, which was accreted income from 2016, they paid under protest, of course. So therefore, if your lordships reserves liberty for us to file an application, and if they consider that dehorse the income tax tribunal's order, that will at least help us going forward. The back period, we've already paid the entire amount.
That liberty anyway, my lord, they have. They can always file an application.
Tribunal order in
Senior counsel for the petitioner.
And limitation also, because that
My lordship may kindly record it, my lord, to
Submits that the present petition involves
Just one
the challenge.
submission. Lordship may kindly record that because IT-80 order has been challenged, my lord, this primary objections by us is that it should have gone to the division bench, because normally even for the advanced ruling authority order, my lord, it goes before the division bench, my lord. So that is our humble submission.
The present petition lays a challenge to validity of section 12 capital AB subclause 4 Income Tax Act as being unconstitutional, and consequential relief is sought by way of a direction to respondent number 1 from implementing the said provision. Certain other reliefs are also sought, including challenge to the validity of section 115 TD of the Income Tax Act, 115 TF. Full stop. The petitioners have also challenged the validity of the notification dated 13th November 2014 at Annexure C.
My lords, may kindly see interim prayer 3, my lords. If that is granted, that should suffice for the moment.
The petitioners have also challenged the validity of the order of the Income Tax Appellate Tribunal at Annexure A. It is Learned Counsel Sri Arvind Chavan would contend that challenge to such order statutory scheme would be before the division bench, and hence any consideration of relief as regards the order in ITA ought not to be permitted. Full stop. Next. While making submissions relating to the validity of the order of the Income Tax Tribunal, contentions were raised that certain observations made relating to the interpretation of charitable purpose would touch upon certain constitutional rights. Next. It further submitted that the tribunal, while interpreting the objectives of a charitable trust, has adopted an interpretation which curtails their constitutional rights under Article 19(1)(a). It is, however, submitted that the relief sought for as regards the order at Annexure A is incidental to the challenge to the constitutional validity of the provision, and this court could exercise jurisdiction over such order where validity of constitutional validity of the provision under which such order is passed is challenged. Next. After hearing the matter for some time, Learned Counsel Sri Raviraj submits that they would take their stand in writing, and further submits that prima facie order of the tribunal has recordings on findings of fact which ought not to be entertained in the present petition. Next. Taking note that the constitutional validity of the provision has been challenged, and incidentally the order of the tribunal is challenged, the petition requires to be entertained, which order is subject to further consideration after filing statement of objections. Next. As it is submitted that the order of the tribunal, insofar as demand has been satisfied.
Yes, sir.
The Learned Senior Counsel appearing for the petitioner submits that the only interim prayer now sought for
Prayer
is,
number 3, my lords, page 195.
Interim prayer
Number 3.
Roman 3. Full stop. The relief sought for by way of an interim order is a direction is a permission for the petitioner to file an application for registration in accordance with section 12 capital A 1 small ac Roman 2 and direct such application be considered without regard to the findings in the order of 26th June 2023.
My lords, may observe delay also. I don't want another technicality because we could not do it 6 months prior because of the ongoing litigation.
Further submitted that the application for renewal
My lord,
to have been
let them file an application, my lord, let it be considered in accordance with law.
application for renewal ought to have been filed earlier, but due to pending litigations, there has been some delay in seeking to file such application. Full stop. Next, for the present, in light of the contentions raised, it would be appropriate to observe that the respondent number
Who will have to consider it? File an application. I think respondent number 7, my lords.
They are not 7. I think principal commissioner is not made party.
subject to further consideration if the petitioner to file an application for renewal or
For the
registration.
appropriate officer, my lords, may say. I think I'm told it is 7, but
No, it's renewal or renewal.
renewal,
No,
renewal.
because of search transfer.
The petitioner
Now
were to
because
file.
it is transferred to respondent number 2.
Respondent number 2.
2 will be the authority will consider their application.
If an application is filed before
the appropriate officer.
appropriate authority,
Appropriate commissioner.
appropriate commissioner for renewal of registration
Yes.
in accordance with section 12 capital A 1 AC Roman 2, same may be taken up for consideration as per law, full stop. In light of a challenge to the constitutional validity of the provision and challenge to the order in ITA, order of in ITA 625 BANG 2023 at annexure A, the application may not be solely rejected on the ground of observations made in the order at annexure A. Such observation is made as validity of the order at annexure A is also an aspect being looked
My lord,
into
that would, my
before
lord,
this court.
invalidate the observations made by the tribunal. If tomorrow, my lord, if
Subject to outcome
for
again,
some,
lords.
this honorable court is to hold that the observations are correct.
We'll clarify that.
No, there are
Needless
two
to
ways.
state,
No, why I thought this is an easier way out.
Needless to state that this direction is passed for the present.
Correct.
And is open for modification if circumstances are so made out upon the respondent filing the statement of objections.
Grateful.
My lord, constitutional validity of the section has also been challenged in I'm told, my lord, serial number.
87, my lords. In serial number 86, 87, and 104 and 105. Same thing which Mr. Vikram argued now, my lords, 12AB, as to its retrospective effect. And my lords, the specified violations percolate back to the years when these were never the violations. Is also there in 86, 87, and 104 and 105.
Lord, that is held against the revenue and we are filing, my lord, a statutory appeal.
In addition to that, my lords, there are certain other grounds like all this were done in a reassessment proceeding, which are time barred. So, my lords, in addition to what Mr. Vikram argued, additionally, the challenge is also, my lords, it's on the basis of a reference made by the assessing officer in an otherwise invalid reassessment proceeding. So, these are also, my lords, and inter alia it would include, my lords, the challenge on the constitutional validity. 12AB4, my lords.
86,
86, 87, my lords. and 104 and 105, Lords. I'm sorry to have barred in, Lord, because the issue is same. I thought I'll just save the time of this court.
The difference is, my lord, in these particular cases, my lord, the
There is no
tribunal has held
tribunal
against
order.
the revenue. Tribunal has held against the revenue.
No.
Holding.
I'll clarify, my lords. I'll clarify. That is also one of the grounds of challenge. For 4 years, my lords, the tribunal held in favor of the petitioner. In between some years, my lords, the matters were not before the tribunal. The learned commission of first respondent, my lords, chose not to follow the binding decision of the tribunal in the petitioner's own case. That is another ground. But just to keep the matter simple, my lords, apart from various other grounds of challenge to the order of the learned commissioner, constitutional validity also is there at the first challenge itself.
Now the PCI, the authority has not followed the order of the tribunal.
Order of the tribunal on the same set of facts. Against which order of the tribunal, the revenue is in appeal, which, my lords, earlier they were saying that certain matters are before the division bench. But these are the years where, my lords, these are the in-between years, which, my lords, are arising from same fact situation. And when brought to the notice of, my lords, the learned, the first respondent, rather than following, my lords, the decision in petitioner's own case, the respondent followed the decision against which Mr. Vikram has come and argued and denied me the and cancelled the registration. So that is the only difference.
Now, which is that order which he has not followed?
My lords, that is given in Annexure H, my lords. Page number 250. This is passed for 4 years. 15, 16, 16, 17, 19, 20.
Here again, you're challenging the order of the tribunal.
No. I am not challenging, my lords, the order of the tribunal, because the order of the tribunal is in my favor for these 4 years, 15, 16, 16, 17, 19, 20, and 22, 23. In the meanwhile, the years before, my lords, were taken up by the first respondent. He initiated the proceeding for cancellation of registration, arising from same set of facts. So what the petitioner did, my lords, brought this decision of the learned tribunal to the notice of the first respondent and requested him to follow the binding decision of the learned tribunal. So what the first respondent did, instead of following the binding decision of the tribunal in respect of very same petitioner, he chose to follow another decision which Mr. Vikram was challenging before, my lords, now, of the tribunal. So that is another ground which is challenged here, my lords, as to the judicial discipline which he ought to have followed.
Now, what is the order now?
Order is the Annexure A, my lords, at page 192. At page 192, my lords,
Yes.
order of cancellation of registration.
So we'll club it with that matter. Then senior counsel appearing for the petitioners submits that while passing the order at Annexure A, the authority has failed to take note of the order in the case of order of the tribunal, ITAT Bangalore bench, in the case of Rukmini Educational Charitable Trust versus Principal Commissioner of Income Tax.
Same petition.
2025-180 taxman.com 257 Bangalore Tribunal, which the first respondent was obliged to follow and has taken note of another order of the tribunal at Annexure.
That has not been given, my lords, it's only referred to.
Another order.
In Annexure A, my lords.
Annexure, the early Annexure H, 250.
No, to another order of the tribunal.
Referred to in, my lords, page 203 of Annexure A, my lords.
To another order of the tribunal.
Para 5.2.
Para
5.2 at page 203.
In the case of Independent and Public Spirited Media Foundation versus Principal Commissioner of Income Tax Central 2026-182 taxman.com 403. In light of such assertion, matter requires consideration. In the interregnum, there would be stay of the order at annexure A.
Annexure A. And my lords, the notice under annexure B, my lords, under section 148.
As well as notice under section under section 148 at annexure B and proceedings pursuant thereto.
Yes.
Learned counsel Ravi Raj accepts notice for the respondents. A list noticing that there's an overlap of issues, legal issues, as well as the validity of constitutional validity of
Insertion of 12AB, my lords, section 12AB, subsection 4.
Page? Where is your prayer page?
That is, my lords, in page 128 is the prayer, my lords. 186, my lords. 186. Prayer A, my lords.
Constitutional validity of amendments made to section 12AB4, comma, explanation to 12AB4, and second proviso to section 143 plus 3 of the Finance Act 2022 has been challenged. List along with WP number so and so. Which is the next one?
87 also same, my lord, for another year.
Same order.
Same order, my lords. Different assessment here.
No, correct.
Yes,
What order I've dictated would hold good.
Would hold good, my lords.
Repeat the same interim order and club along with. Office objections to be complied with in the interim. This one?
Same, my lords. Another year. There are 4 years involved.
Same order.
104 and 105.
Same order.
Same order.
Yes. Now, what do you say regarding that contention that where they have to file an appeal against the order before the division bench, if it's an order of the tribunal, by challenging the constitution validity, indirectly they're seeking the single judge to enter into validity of that order.
My lords, there are decisions which suggest that, my lords, in a regular line of appeal, where, my lords, a substantial question of law would have been framed, the constitutional validity wouldn't come as part of it. So therefore, my lords, the law as it existed will have to be interpreted, my lords, my humble understanding, under section 260 capital A. The virus, my lords, would have to pass through a separate line of challenge.
Yes.
Obliged, my lords. Grateful.
Yes.
Issue to serial number 3.
Pay for the petitioner. Let's say we are willing to pay 10% of the demand.
This has to be disposed of.
Yes.
Okay, tomorrow. I'll dispose it of tomorrow. Tomorrow.
Demand
10%. Correct. I'll pass the order tomorrow.
Yes.
List on top of fish matters list tomorrow.
Under the caption order.
Top of fish matters list.
Program C.
Next. Yes.
May just two, my lord, points on this is
Just on the mic.
few, my lord, basic, my lord, factual aspects based on which, my lord, this SCN was emanated. My lord, lordship may kindly take a synopsis. My lord, third column, the synopsis, before the acquisition of shares of the petitioner by DIGO.
Paragraph?
My lord, this is third column in the, my lord, the synopsis. No, writ petition papers, your lordship. Writ petition papers. Synopsis in the writ petition.
Yes.
Before the acquisition of shares of the petitioner by DIGO Group and Relay BV, the company so and so entered into an agreement with so and so, pursuant to which there was an obligation on DIGO PLC and Relay BV to support so and so continuing as a non-executive director and chairman of the petitioner. My lord, next column is that, my lord, the DIGO PLC acquired the majority shareholding, and my lord, the control and management of the company, petitioner company, my lord, goes into the hands of this DIGO. My lord, lordship may kindly come to, my lord, next page, second column. Certain parties owed dues to the petitioner, and such parties had given their balance confirmation to the auditors of the petitioner for the financial year 12-13. However, at the time of the audit for financial year 13-14, these parties claimed that they have advanced certain amounts to certain alleged UB group entities, and the dues owed to the petitioner will be paid by such parties only upon receipt of their dues from such alleged so and so. Accordingly, for the financial year 13-14, the parties who owed dues to the petitioner disputed the balances owed by them to the petitioner. The statutory auditors of the petitioner in their audit reports so and so confirmed the same. My lord, this has led to this impugned agreements in the now next paragraph, my lord. They have explained it in detail in the writ petition, my lord. That may not be necessary, my lord. I'm so. Pursuant to the above observation made in the audit report of the financial year 13-14, the petitioner appointed an independent consulting firm to examine such transactions, who submitted its initial inquiry report, which indicated diversion of funds from the petitioner company at the behest of so and so. Due to the diversion of funds findings in the report and the presence of so and so as a chairman prejudicially affecting the business operations of the petitioner, the board of directors of the petitioner called upon so and so to voluntarily resign as a director and chairman of petitioner company, and also step down from his position in the subsidiaries of the petitioner company. So and so refused to step down from the board of the petitioner company. Thereafter, the board of the petitioner company requested DIGO to review its position in relation to its contractual obligation to support so and so continuations to hold his position in the petitioner company. Lord, this has led to two agreements being entered into between the petitioner company and the then director, and DIGO and then director. So entire, my lord, a comprehensive, my lord, it is a package as such. My lord, the page number 3, third column, they explain, my lord, about the nature of the agreement. On certain aspects, my lord, the department is not agreeing with, but in overall, my lord, it's a petitioner entered into a settlement agreement with so and so, which he agreed to step down immediately from his position as a chairman and non-executive director of petitioner, and also agreed to resign from his position as a director of petitioner subsidiaries, Royal Challengers Sports Private Limited and Four Seasons Wines Limited. In addition to that, as a part of the overall settlement, so and so procured termination of some of the historical agreements as mentioned in Schedule 1 of the settlement agreement. In return, petitioner agreed to release so and so from its civil/commercial claims against him in connection with the initial inquiry. First element of a quid pro quo is this: if you step down, we will not, my lord, initiate any coercive action as per the findings of the inquiry committee, which indicted him of siphoning of the funds. My lord, the petitioner had entered into 8 agreements with certain companies where the former director and chairman had an interest, direct and indirect influence and control over those companies. My lord, in lieu of he stepping down, and my lord, in lieu of a promise made by the petitioner company not to initiate any action, my lord, he agrees to procure termination of all those 8 agreements entered into various parties. My lord, I'll just take few where, because they argued that there is no monetary consideration. They argued that without monetary consideration, it cannot be construed as a service. My lord, I will show from the terms of the agreement itself that there was indeed a monetary consideration. My lord, these 8 agreements were not approved and voted down by the, my lord, all shareholders. Since, my lord, under those agreements, consideration had already passed on, partly, and petitioner was under obligation to perform those, my lord, contractual obligations. So by voting down of these agreements, my lord, put the, my lord, position of the company in a very piquant position. So, my lord, that was one of the, my lord, the condition that promising him not to initiate any action against him, the quid pro quo is that he would procure the, my lord, termination of all these agreements to make the, my lord, the petitioner free from all obligations. My lord, my lord, I will just take your lordships through those agreements. So my lord can, my lord, ascertain, my lord, appreciate that the nature of the agreement is such that, my lord, both the parties, my lord, agreed to perform, which are, my lord, absolutely commercial in nature, and petitioner had benefited from that promises financially and commercially. Lords, may I just take your lordships to few of the, my lord, terms of the agreement, and not only that, my lord, the certain contracts which were entered into and consideration received, the SCN observes that, my lord, they were not recorded in the books of accounts. I skip, my lord, the lordship may kindly come to now annexure D, page 65. That is a show cause, impugned show cause notice.
Page?
Page 65, my lords. My lord, in addition to this, my lord, one my lord, striking feature is non-competence and my lord agreement clause, where in lieu of this, the former director and chairman undertook, my lord, an obligation not to compete with the same in the same business for a period of 5 years. That was also a part of the agreement. And neutral, to remain neutral. I request my lord to kindly come to Your Lordship may kindly come to page 83. There's so many discussion about so. My lord, 83, internal page 19 of the show cause notice. My lord, para 11.4, my lords. From the audit committee note on potential settlement enclosed as so and so to the minutes of audit committee meeting dated so and so. My lord, analysis of the cost and benefits of potential settlement and its implications of potential settlement as a related party transaction. Conclusion and management recommend so and so. My lord, analysis of cost and benefits of potential settlement. While the settlement is an integrated package for purpose of assessing whether the settlement would be a material related party transaction under SEBI listing regulations or would require shareholder approval so and so, the analysis is undertaken purely for purpose of assessing USL regulatory obligations under the Indian law, does not alter so and so. In the table below, cost likely to be incurred and recovery is likely to be waived as a result of settlement have been computed and stated without discount. Equally, potential benefits and savings have been stated without discount. My lord, this is the chart, my lord, where they try to, my lord, approximately they will arrive at, my lord, a monetary value of the, my lord, the settlement which going to be benefited petition. My lord, next page, your lordship. While even by conservative estimates, the settlement would garner the financial and monetary benefits discussed above, there would be certain important intangible benefits that would also follow from such a settlement.
You're reading at page?
Page, my lord, 84, my lords, below the table. The settlement would free up considerable management time and bandwidth that has gone into addressing the fallout of the management inquiry and uncertainty associated with the RPT transactions. This would allow management to dedicate more time and resources to focusing on USL's business and strategy, and would also address related audit qualifications that have been made in the past by USL statutory auditors. And given the ongoing problems that so and so is facing in relation to Kingfisher Airlines and UBHL, including being recently declared a willful defaulter, the dissociation of so and so from USL's board could have knock-on benefits, including in relation to USL's relationship with banks and its ability to finance its funding requirements. Moreover, it would signal a conclusive break from UB Group and allow USL Group identity to the more closely linked Diageo. The alternative to a settlement would be extensive litigation, not just with so and so, but the numerous other entities involved. This will last several years, result in uncertain outcomes, cost high sums of money, and occupy substantial management. Lord, then they go on to record the statement. Lordships may kindly come to page 87. My lord, these are the certain agreements, my lord, 87, some agreements which were terminated in consequence of, my lord, this undertaking given by the, my lord, the former chairman. And my lord, 14.1, 14.2 and 14.3.
Yes.
Then your lordship may kindly come to my lord, page 102. After my lord, they discuss things. Why the my lord 29.4 paragraph. In view of the above facts, it appears that USL is liable to my lord, sorry, pay service tax in respect of the consideration for such service under section 66B of the Finance Act, read with section 67 of the Finance Act, so and so. It can be seen from various statements recorded during the course of investigation that the reasons and justifications cited by the officials of the USL for non-payment of a service tax in respect of the consideration flowing to USL under the USL VJM agreement were there is no element of activity in this agreement or arrangement, and that the arrangement does not constitute provision of services, and there was no monetary consideration receivable by USL from so and so as per the agreement. Contention 1 appears to stem from the misconceived notion that there should be some kind of physical activity to qualify as a service under service tax law. It appears that the term activity is not used in the service tax law in a restrictive sense, but has the widest possible scope or connotation. Even passive activities such as agreeing, refraining, relinquishing, tolerating, waiving, etc. are covered by the scope of the term activity used in service tax law. In any case, the fact that agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act shall constitute a declared service is specifically declared as a service by including the same in as a declared service in section 66 of the Finance Act 1994, indicate the legislative intent to tax the same. It also appears that the intent of the legislature in including the same in section 66E, which is context free unlike section 65B, which is qualified at the beginning of by the words unless and context otherwise requires, is to dispel any doubts as to the taxability of the same and protect the same from the challenges based on a restrictive interpretation of the term activity used in section 65B. If the challenge of clause E of section 66E is based on a restrictive interpretation of the term activity is allowed, it would render the said clause inoperative and defeat and frustrate the legislative intent. Hence, the said reason justification cited by USL for non-payment of service tax in respect of the consideration flowing to USL under the USL VJM settlement agreement does not appear to be legally sustainable, and it appears that they were liable to include the value of such are liable to pay service tax in respect of so and so. My lord, he extracts the, my lord, provisions of the Act and rules, and my lord, analysis of the costs and benefits of potential settlement. My lord, he makes a approximate estimation. My lord, then your lordship may kindly come to (114), lordship may. My lord, para 30.5. They were contending that, my lord, the consideration was not there in the entire arrangement. My lord, from the party ledger of Watson Limited in the books of USL and the details of amounts payable and paid to Watson furnished by USL, it is seen that no invoice had been raised by Watson. My lord, this is very important. Watson on USL for the amounts so and so USD and so my lord, pounds, which were payable by USL to Watson Limited on signing of the USL Watson advertising agreement in 1314. From the facts, documents on record and statements, communication of the concerned officials of the USL, it appears that the said amounts were not even accounted as liabilities in the books of USL, either prior or after termination of the USL Watson advertising agreement. My lord, this is one of the agreements, my lord, which, my lord, the former director and chairman, the procured termination of that. In lieu of, my lord, the promise made by the petitioner that no action would be initiated against him. This is one of the agreement which they refer to, where the money has changed hands, but no reference in the books of accounts, my lord. Lordship may kindly similar. Now, from the facts and documents on record and statements, communications of the concerned officials of USL, it appears that the said amounts were not even accounted as liabilities in the books of USL, either prior or after termination of the USL Watson advertisement agreement. Hence, it appears that the termination of the agreement effectively resulted in a set-off of the USL liability to pay the said amount against an equivalent amount due to USL from Force India. It appears that USL and Watson Limited are not likely to pay the said amounts to each other or make accounting adjustments recognizing such payments. It appears that one of the reasons for the above arrangement is to evade the service tax payable on the said amount if it is paid or accounted. Since the service provider is located outside the taxable territory, the point of taxation, my lord, he goes on, my lord, deliberating on the what provisions of law will apply in such a situation. My lord, 30.7 on page 115. Since the service charges involved originally payable in 1314 is yet to be invoiced, paid or accounted, it appears that the point of taxation cannot be determined so and so. Since the service provider is located outside the taxable territory, it appears that the only other rule under which the point of taxation can be determined in this case is Rule 8A, reproduce so and so. Well, this is under the reverse charge mechanism. Liability on US is under reverse charge mechanism.
How much time will take?
It will take some time, tomorrow or day after, maybe any day. Few more clauses of an agreement, and my lord, and their submissions, my lord, I'll deal with.
Lord, I will reply on virtually. I'll try to.
Yes.
Lord, my friend can also. I'm on a very short point, my lord. My only submission, very submission is, assuming there are settlements, etc. If what is being settled is an actionable claim is not liable to service tax and also not liable to GST. Because the consequence of what the department is now doing, any settlement of legal disputes, here there is no dispute that USL had to get money from Malia Group, Malia had to get from USL Group. We don't have to go into the multi-corporate involvements, etc. At the end of the day, they were dues, etc. They found there is no point going to court, it is expensive. We said we'll settle it, subject to certain conditions, we'll step down. But at the heart of it, what was? Actionable claims were settled. If actionable claims are settled, it's not liable for service tax. That's all. That's the only short point.
My lord, my endeavor is to, my lord,
no, I mean,
prove that, my lord, there was no actionable claim.
No.
We are not taxing actionable claim. This is a camouflage, my lord, and
no,
there is one agreement.
The point is
multiple, my lord, agreements with multiple parties.
The table says my claim against you is 100
My lord,
rupees, your claim against me is so much. Both the claims are settling with this memorandum of settlement. Lord, day in and day out, we come to a settlement. Apart from Lok Adalat Mediation Center, we come to so many settlements. We agree to, there's a commercial courts now. Commercial court mandates going for mediation. So many claims are settled through mediation, and the actionable claim is settled. So if the actionable claim is settled, because the point is, suppose I filed a suit for 1 crore and I settled for 60 lakhs. If the show cause notice is accepted, I have weighed 46 lakhs. I've tolerated the breach to the extent of 40 liability. That is a draconian consequence. So that's why we are pitching our case on a very narrow issue. If what is the subject matter of settlement is an actionable claim, which is a debt due from parties, then that is under the schedule itself. They say actionable claim is neither goods nor services. The only actionable claim which is liable is betting and gambling and horse racing, etc. So that's my short point. My friend can take his time. I'm not going to go beyond this one.
You have to
And
answer.
that the definition of service excludes actionable claim. GST excludes actionable claim.
Well, I'll show my lord what the
That's a
service
short
tax
point, so my friend
excludes.
can, yeah.
What is an actionable claim in terms of, my lord, the provisions of the, my lord, Finance Act and also GST. My lord.
So, my lord,
There is something, my lord, which lordships have to, my lord, ponder over. This is not an usual kind of a contract. So I'm not reading all the clauses of the contract, my lord. Our entire show cause notice as such.
This
My
is
lord, only a relevant, my lord, I will just highlight.
If I may submit, whenever there is an intercorporate war or within the family members in the group companies, there is ultimately they come to a settlement, they come to this. When they settle actionable claim, there's no GST. So apart from the large amount involved, on a daily basis, my lord, see insurance claims. A accident person claims 50 lakhs. In the Lok Adalat, Mega Lok Adalat, he settles for 20 lakhs or 25 lakhs. Then is the insurance company, is the claimant tolerating a breach? He's only settling an actionable claim. It's a debt due. What is the actionable claim? Any debt which is not secured is an actionable claim.
The proceedings in the court, my lord, which are exempted totally.
But let me, so I just wanted to say, because I'm not getting the merits of show cause, because lordship is 226, my lord. My lord need not go into para 4.6 and 5.2. That's not the writ court. Whether the jurisdiction is, can he bring to tax a settlement of actionable claims? That would be my humble.
My lord, my endeavor is to, my lord, to demonstrate before this
That's all.
honorable
I told you
court
to say it, I'll
that
be
there is
here.
no actionable claim. The purpose of, my lord, taking your lordships through these various clauses of the agreement is to, my lord, to show that, my lord, there is no such a thing as an actionable claim which is being taxed. My lord, I will, after this, my lord, I will take your lordships through the, my lord, relevant provisions of the act also.
The arguments of learned counsel Shri Jeevan on behalf of the revenue remains inconclusive. Relist the matter. Yes, Jeevan, when you want it.
Any day, my lord, convenient to the court, my lord.
Witness. Yavattu date
30th. Any day, my lord, before vacation also, I'm ready. My lord, sir. Another half an hour, my lord.
Is the court closing? No, only request before 30th April. Because I got some personal difficulty in the first week. Family, it's possible. He's going to take half an hour. I will not take more than 10 minutes. I made my submission. My friend will be here also. If it is possible.
10 minutes equal to 1 hour.
No, Mr. Datar, 1 point. Last time you didn't get my point. We have some timelines. So the clock starts ticking.
I got the point, but I did not.
So I have in my list many more.
No, I'll tell Lordship, my lord. My lord, because I've argued for 2 hours, my friend has argued. My lord makes it part-heard. We can have it in after vacation also in June. I have no problem. We don't have to re-argue the case. That's all I'm saying. So in June, July, whenever you want, because my lord, we got the interim order in 18. Only because of March pressure, they activated it. So Lordship will make it part-heard in June. We'll most happy we can come.
Let him finish. For your reply, I will give it post-vacation.
Vacation. And Lordship make it part-heard.
So no, for him, we'll see for his reply. I'll have it on 27th.
For some reason, Lordship's time pressure, if he can't finish, even if he replies after vacation, June is much comfortable. We can both do also in June.
Have it after vacation, my lord.
What do you do?
First June.
As substantial arguments have been heard, it is treated as a part of this is the matter.
You can see this.
In the week commencing from 8th, a date will be intimated by the court officer.
On 8 June onwards. The interim order may continue.
Interim order in operation is extended till the next day.
Deeply. What will make it parted?
Yes. Yes. All matters which are urgent and which were mentioned.
My lords, number 72, I mentioned in the morning, my lord. Please.
Yes.
There is a threat of demolition. We are all, my lord, there, my lord, since for several years. But now what they say is, they want to widen width of the road for which we have no objection. But they are not ready to pay compensation. They did not even say that we are encroaching. We are not ranked trespassers. My lord, our title and measurement are reflected, my lord, in the document maintained by themselves. My lord, ours are, my lord, 60, 70 years old buildings. My lord, the local body, my lord, the city municipal council, 8 responded. It says that, my lord, it only maintains the underground, my lord, drainage and the footpath. Widening is not their, my lord, task, and it is the National Highway. National Highway Authority says they have not undertaken, or they don't want to do anything, my lord, so far as widening is concerned. Not in Chalkere city. My lord, NHA, my lord, 150A, my lord, there is a bypass road to avoid, my lord, the traffic, vehicular traffic entering the city, my lord. They built a, my lord, a bypass road. It is only, my lord, city vehicles, my lord, the road is meant. The road, my lord, as far as our living memory, my lord, goes, it is only 25 to 30 feet, my lord, the width. Now they want to have 30 meters, my lord, width road. And they say that we are not going to pay you compensation when we undertake the, my lord, widening of a road. There is no question of payment of compensation. My lord, even your lordship also, my lord, in similar matters, page 186, my lord, your lordship said, my lord, they can't be, my lord, taking over private property, even for, my lord, widening of a road, unless, my lord, the land is acquired in the manner known to law. Even if it is a case of an encroachment, we should be given an opportunity, my lord. It is a serious, my lord, allegation. Encroachment of a public road is a serious allegation. We need to be, my lord, heard. And they don't want to do anything, my lord. I have page 185, my lord. I have produced, my lord, the item, the news item appeared in the newspaper. Raste Aglikarana Kamagari Kuntita. My lord, what they say is, my lord, in the middle of that page, my lord, in the paper, my lord, this the commissioner says, my lord, some of the my lord, merchants, they are, my lord, halting because we are not opposing widening. If at all they want to widen the road, let them do it. It is for public purpose. But what they say is they are not giving us compensation. It is not necessary according to them. ಬಳ್ಳಾರಿ ಮಾರ್ಗದ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ತೊಂದರೆ ಮಾಡುತ್ತಿರುವ 66 ಅಂಗಡಿ ಮಾಲೀಕರ ಸಭೆ ನಡೆಸಲಾಗಿದೆ. ನಗರಸಭೆಯಿಂದ ನೀಡಲಾಗಿರುವ ಅಂಗಡಿ ಪರವಾನಗಿ ದಾಖಲೆಗಳನ್ನು ಏಪ್ರಿಲ್ 13 ನಂತರ ಹಿಂತಿರುಗಿಸಲು ತಿಳುವಳಿಕೆ ಹೇಳಿ ನೋಟಿಸ್ ನೀಡಿದೆ. ವ್ಯಾಪಾರಸ್ಥರು ಕೇಳುವ ಪರಿಹಾರ ಕೊಡುವ ಅವಕಾಶ ಇಲ್ಲ. When it is our property, we will not inherited or succeeded, and some of them are will not purchase property.
Now you'll have to hold an inquiry if there's encroachment.
Yes.
If you want to acquire it, it's up to you to acquire it, but you can't encroach on the property without such procedure.
This is, my lord, National Highway Authority.
Maybe. Who accepts notice for that?
But not AGA, my lord, can appear, my lord.
AGA accepts notice.
Or 3 to 7 and 9.
No, just one.
They accept notice for my lord.
Accept notice for R1.
So and so accepts notice for the first respondent. AGA accepts notice for 2, 4, 5,
2, 4, 5, 6, 7.
7 and 9, assistant executive.
7 and 9.
9, man, please.
7 and 9. Then 3.
3 is my lord N. Kumar.
Learned Counsel N. Kumar is right to take such notice for the third respondent.
8, my lord, municipality.
8, any standing counsel? The Commissioner, City Municipal Council.
But I take out notice.
Emergent notice to the 8th respondent. Petitioner is at liberty to serve standing counsel, if any, for the 8th respondent. The petitioner contends that the respondent authorities are seeking to take over private properties of the petitioners without acquisition and without payment of compensation. Attention is drawn to the media report in the newspaper enclosed at Annexure.
But they have not given it.
No, Annexure J. Full stop. It's contended that
Annexure
properties of the petitioner cannot be encroached upon except in accordance with law. Next. It's clarified that the private properties of the petitioners cannot be encroached upon without following due process of law. Full stop. In the event the respondent authorities are of the view that there is encroachment of right of way by the petitioners, needless to state, under the relevant statutes, there has to be an inquiry determining as to whether petitioners have in fact violated right of way or public property. Full stop. Next. If the authorities to make use of the private properties for the purpose of road widening, however noble intention and object may be and public interest involved, the private rights cannot be encroached upon except by acquisition under the relevant applicable statutes. Accordingly, the respondent authorities are restrained from encroaching upon the private properties of the petitioner. Full stop. Next. Needless to state, it's made clear that the authorities are at liberty to hold an inquiry in the event of any alleged encroachment or are at liberty to take appropriate steps for acquisition under the statutes in force. However, till such inquiry is concluded or acquisition process is concluded, question of dispossessing the petitioners does not arise. Respondents are at liberty to seek for modification of the interim order upon filing their statement of objections.
Hand delivery, my lord, I know. It's already 5 o'clock, my lord.
Huh?
There is a threat, my lord. They said, my lord.
We'll upload it. We'll upload it. Upload my
Hardship, sir.
Now, insofar as other matters,
Second list.
so just wait. Insofar as other matters, wherever interim orders are in operation, we will extend it. Dates will be given only of those matters where no interim order has been considered. Matters will be repeated. I've asked the court officer. I don't want to take up single matters now because it will amount to singling out. But the court officer has been instructed wherever interim orders are required.
Oral direction also may be extended, Lordship.
Yes. Yes. Wherever interim orders
Interim relief in the form of direction or order.
Yes. Wherever interim relief is required and matters have not been reached, the court officer will relist the matters according to whichever tomorrow, day after tomorrow, however is available.
One problem is
No other mentioning because it will only lead to, there will be no end for that. You make a request to the court officer, we'll accommodate all requests.
there is one problem. In case of all the matters listed again in third list or fourth list, again will not.
So we'll see whatever priority. Correct. But I don't know what other solution to this, but we'll list it still.
My lord, adhering to what your lordships have said.
Secondly,